of our democracy here in the United States. And on the other side, the Bush camp says it is unprecedented that it looks like this election may end up being settled in the courts. Well, there is a lot of court action here today, Tony. We've got 2 cases going on in Leon County. We've got 1 major case before the Florida Supreme Court, and we're hoping that by the end of the day, 1 month after Election Day, that we'll have a clearer picture as to what exactly is going to be taking place on Inauguration Day. Will it be the swearing in of George W. Bush, or will it be the swearing in of Al Gore? Back to you.
All right, Steve, thanks. So once again, to recap, right now the Martin County case is unfolding in the courtroom of Terry Lewis in Leon County Circuit Court. The Florida Supreme Court at the top of the next hour will be hearing arguments from the Bush and Gore teams. That is the Gore appeal of Judge N. Sanders Saul's decision not to permit recounts in 3 Florida counties. And then at about 1 p.m. Eastern time, Judge Nikki Clark will be hearing closing arguments in a Seminole County absentee ballot case. As we've noted, we'll bring all of those to you. Let's go back now to the courtroom of Terry Lewis, Judge Terry Lewis in Leon County, Florida. Right now, they are hearing testimony from Peggy Robbins, who is a campaign official for the Martin County Board of Elections, and she is being cross-examined by Ken Wright, who's an attorney for the Republican Party of Martin County.
Ms. Robbins, regardless of whether it would make things easier in your shop to have the identification number, the fact of the matter is that you know that the law requires it.
Yes.
Now, in terms of, you were asking questions about secrecy and whether or not you kept this matter secret. The fact of the matter is that even though you knew there was a problem as far as these identification numbers go, you yourself never made any public broadcast of what the problem was, did you?
Objection, Your Honor. It's covered by the stipulation.
I didn't remember that, but it won't take but a second. What paragraph is it?
I believe the stipulation was that either the Republican Party or the Martin County supervisor election notified the Democratic Party or the general public. 18 and 19.
Okay.
As far as the sleeve goes, the sleeve that we're talking about, just in terms of who the voters were, does not the sleeve also indicate whether the voter is a Republican or not, the party affiliation?
Yes.
And finally, you were asked some questions about your receipt of this information that you got. To your knowledge, this 10/27 date that I asked you about, that date as the request date was put down by your office after, to your knowledge, the Republican Party changed the numbers that were on the identification application card, correct?
If, in fact, that was one of the cards that was changed, yes.
Right. So you all did not consider it to be a request until you got the card back from the Republican Party, and the Republican Party had made changes to the application, correct?
Yes.
Now, you know, ma'am, you were asked a question about whether you did think that you did anything wrong. You know that, in fact, the only people that can make a request for an absentee ballot are either the voter himself or herself or somebody in their immediate family, correct?
Correct.
Those are the only 2 ways that a legal request can be made for an application for an absentee ballot, right?
Yes.
That's all I have, Your Honor. Thank you.
Ms. Robbins, before you go, let me make sure I know I had that marked, and I think you answered this question. Your office is required, is it not, whenever somebody makes a request, to make a record of that request?
Yes.
Okay. And is that what that is up on the board?
Yes.
So for every request that was made for an absentee ballot in this last election, there's a record of it in your office? And that was, you were asked the number of it, and I think you indicated there were 108 total requests that were not processed.
That's correct.
And those records are there.
Yes.
to be seen, right? Anybody could look at them if it's public record.
Yes.
Although it's supposed to be confidential, isn't it, under the statute?
I don't know, but they were told that I was told I had to bring them, so I brought them.
Okay, all right. But if we wanted to look at them, we could. And I think you said that 82 of those were the mass mail Republican.
Yes.
And the remaining 26, you don't know. You don't really look at that, but you could, in fact, tell, couldn't you, if you had the name?
Yes, we could tell what party they were if we looked it up, yes.
Okay.
But in a general election, we don't care what party we are.
But I mean, right now, if we wanted to find out, we probably could. Okay. Did you make any attempt, other than the mass mail out of the Republican Party, if there were just individuals that sent in a deficient or a defective request, didn't have the proper information on it, did your office make any effort to contact that person in any way to let them know it was deficient?
Well, before...
I think, with all due respect, I think this is actually covered in the stipulation.
Is it? Oh, that is a good objection. What is it?
I wasn't going to use that word.
What does it say?
That there was not, in fact. What's the paragraph, Council? 42.
Made no attempt to contact individual, let me say 41.
Yeah, you have to look at 41 and 42 together.
Okay, you're right.
I did not use the word objection.
Any follow-up questions for mine?
No, Your Honor.
Yes, Your Honor.
Your Honor, there is in fact testimony by Ms. Robbins at her deposition, which is contrary to that provision of the stipulation, as we have been reminded on other occasions by counsel.
Well, I mean, you stipulated to it. I think you're bound by it. If it's something that goes beyond that, is not contradictory to it, but supplemental, that's fine. But I think you're going to be bound by your stipulation.
Your Honor, I think if she were to hear what's in the stipulation, and then if there is a clarification, it would be available for her to explain. It's a question of timing as it relates to the stipulation. State 41 or 42 and 43. I think that would give her an opportunity to clarify that if that is at all needs any clarification.
Well, it's not going to make a difference in terms of you being bound by it, but just for clarification, I'm going to ask this question of the witness, Ms. Robbins. Here's what it says. Basically, it says, in the weeks prior to the election, your office did receive ballot request forms from individual defendants. I mean, not defendants. Freudian slip there, sorry. Individual Democratic voters, but not on the printed form. And that of those, they were deficient. They didn't have some of the information. And of those, it said there was no attempt made to contact those individual Democratic voters or the Democratic Party.
That's not true.
Okay, well, it doesn't clarify that.
Your Honor, given the agencies that we've been working on at this point, we've had 4 days to come up with a stipulation. If the lawyers screwed this up and she has facts, given the due process constraints that we're under, and she directly contradicts them, she ought to be allowed to contradict the stipulation. I mean, we've done the best we could.
Well, there's hearsay evidence in the record right now that wasn't objected to by Mr. Houck to that effect of his conversation, whether as to why he started doing it, because they were making efforts to do that. And
we're going to break away quickly from this argument about evidence, but after a couple of commercial messages, we'll be back with the trial in Leon County, Florida, before Judge Terry Lewis. Stay with us. There are allegations in Martin County, Florida, that Republicans received preferential treatment from local election officials. That's really the nub of a case going on right now in the Leon County Circuit Court, where Judge Terry Lewis is presiding. The reason that it's being done in Leon County Court in Florida, that's the county in which Tallahassee, the state capital, is located, and all election contests end up going to Leon County Circuit Court. We're joined by Paul Rothstein, who is a law professor at Georgetown University Law Center. Right now, they've been having a whole series of arguments about what evidence is admissible and what is not. But let's talk about two things. Number one, both sides have agreed to a whole series of so-called stipulations. They've basically said, we agree that these things are facts. And both agree that perhaps Republican officials behaved badly. The real question is the proper remedy for that bad behavior to throw out all ballots?
Well, it depends on whether the judge has a lingering suspicion that more was going on there than meets the eye. If it was just a ministerial filling in of some numbers, which should have been filled in anyway, the proper remedy is not to throw out all the ballots. Maybe punish some workers, fine them, lower their job ranking or something, but don't throw out the ballots. But if the judge has a lingering suspicion, as some of the evidence suggested, that there were other things going on there as the Republican Party people were handling these ballots, which were supposed to be in a secure place. And if the judge feels we know not what was being done, then there may be some problem. For example, the judge may feel that, and this is true, historically, if you wanted to fiddle an election, you did it through absentee ballots. And that's why a lot of mechanical requirements like numbers and identifications and things like that were put in to be sure that people weren't voting twice, that dead people weren't voting, that people who weren't residents of Florida weren't voting, that people who had voted in person weren't voting absentee or submitting 6 absentee ballots. And if the judge feels that some of these mechanical requirements are meant to ensure against that and that they are being flouted and that there is a real danger that these are phony ballots, then I think these cases, Seminole County and Martin County cases, have some real upside potential for Mr. Gore.
Okay, I just want to break in for a second. We were looking at shots at the courtroom there just a moment ago. Basically, lawyers are squabbling over a lot of matters of evidence. There is Peggy Robbins, who's a member of the Martin County Elections Board. She's pretty much completed her testimony, at least we think, and as we said, the lawyers are entertaining a whole series of motions before Judge Lewis. In any event, we'll get you up to date on that. Let me ask you one other quick question, Paul Rothstein. Does it seem that there are fraudulent ballots cast in this case, or that these are real people who filed real ballots?
It doesn't seem at this point that there were fraudulent ballots. This was just doing something to the applications. There are several fail-safes, several backup systems for checking that phony stuff isn't going on. And I think at this point, I feel it doesn't look like there were fraudulent ballots, but you can't be 100% sure.
Okay, so we will get back to the courtroom of Judge Terry Lewis in a couple of minutes. We're going to take a quick break. Stay right here on Fox News Channel. We'll be back with more.
I think we're talking about the same thing. I think this is...
As we return to Leon County Circuit Court in Leon County, Florida, Democratic Attorney Gary Coleman is arguing before Judge Terry Lewis. What's at issue right now are a so-called set of stipulations. Those are facts that have been agreed to by both sides, mainly so they can get this hearing over with as quickly as possible and Judge Lewis can render a verdict. What has happened is that Peggy Robbins, who is on the stand and has been speaking before, argued at one point during her testimony that, as a matter of fact, she and other members of the Martin County Board of Elections did try to contact Democrats who had faulty applications for absentee ballots. That seems to have run counter to some of the things in the stipulations. And so now lawyers on both sides are haggling about whether to admit this new evidence and whether it contradicts something that both sides have already agreed to. Let's go and listen to some of the squabbling. And if it becomes too incomprehensible, Paul Rothstein and I will return to put it in a little more context.
Forms about 108, plus I don't know how many of the other ones. Some of copies. Could you?
Sort of.
Okay. Mr. Smith is glad to help. Step down and go with this gentleman right here, Mr. Lebaski. Does she know where the ballots are? Is she going to get by herself?
We'll go get them.
Okay.
Bring them back here or down the court upstairs?
Yeah, Mr. Smith there will take care of it. Deposition, that I think was, I'm sure it was there. Or was this Mr. Coleman's, I guess?
Your Honor, at this time, we'd like to publish some depositions, portions of them, very briefly.
Very well. You going to have somebody read it, or you going to
We
read it yourself?
actually have Alice O'Brien here who will read those portions and get a copy for the court.
Okay.
Chief, come forward. Your Honor, just a bit of house cleaning while we're in this.
What's going on right now is kind of the equivalent of story time. You've got somebody who's sitting at the stand. She is going to read depositions, that is sworn testimony taken before the trial began, simply to enter it into the court record once again and to make an impression on the judge. We're not entirely sure what exactly is going to be read into evidence, but this is something that attorneys for the Democratic plaintiffs want to bring before Judge Terry Lewis, so you can assume that it is going to be friendly to Democrats. Let's also keep in mind that the Republicans have not yet begun to bring their witnesses on. This trial is going to go on for some time. The way it's slated today is that the trial will continue straight on until about noon Eastern time. Then everybody there has to clear out, because in order, they've got to get all those papers and all those attorneys out, because at 1 o'clock, Judge Nikki Clark is going to convene a hearing in the same courtroom on a case, a similar case, involving absentee ballots in Seminole County, Florida. So that sort of gives you a sense of what's going on. Let's go back to the courtroom for a moment.
Of the depositions of Brenda Lindsley, Emma Smith, and Amy Myers. There are 5 other deposition transcripts, portions of which we've included in the binder for you. First one is Ms. Lindsley. Could you give us your name and address?
Okay. My name's Brenda Lindsley. My address is 16100 Southwest Palomino Street in Indiantown, Florida, 34956.
And keeping your voice up, are you employed, ma'am?
Yes.
And where are you employed?
At the Supervisor of Elections Office in Martin County.
Would it be only after you spoke with the voter and got their correct identification number, voter registration number, that you would then affix that number on their application?
Yes.
Are there any circumstances that you can recall in which you would have put the voter registration number onto the application yourself without having first spoken to the voter?
No.
Did you become aware, ma'am, that there came a time in the fall of 2000, before the election, in which a representative of the Martin County Republican Executive Committee was allowed to have custody of applications for absentee ballots that didn't have all of the complete information?
Was I aware of it?
Yes, ma'am.
Yes.
How did you become aware of it?
Just I heard they were giving them to the Republican Party.
All right, and do you recall who you heard that from?
No.
And what was your understanding of the number of times in which representatives of the Republican Party were allowed to take from
Okay, we are hearing the red testimony, the red deposition of Martin County elections worker named Brenda Lindsley. We're going to take a break from this for a couple of minutes. When we return, we're going to have a conversation with Judge Andrew Napolitano and Paul Rothstein about what's going on in this courtroom, whether it's proper or not, and what the impact may be. Stay right here.
Numbers on them. Did you have an understanding as to where those forms were initially placed?
United States. Less than a half hour from now, the Florida Supreme Court takes up Al Gore's election contest appeal again. There's a live picture from inside Florida's High Court. Gore's attorneys will try to persuade the court that 14,000 disputed ballots should be hand counted. Also today in Tallahassee, testimony resuming this morning in a lawsuit over absentee ballots from Martin County. We're showing a live picture from that Leon County Circuit Courtroom as well. That's Judge Terry Lewis. Democrats want nearly 10,000 ballots thrown out. A similar trial over absentee ballots from Seminole County resumes later today.
May be difficult to keep all these straight, but we do have teams of reporters covering today's court action throughout Florida. CNN's Kate Snow is following Al Gore's election contest appeal. That means she's joining us by phone now from the Florida Supreme Court in Tallahassee. Kate, good morning. We can talk to you now, I guess, because court isn't in session yet. Otherwise, you're out of there.
That's right, Stephen. Good morning. In fact, I'm watching right now Attorney David Boies, Dexter Douglas walking into the courtroom. I'm right outside the courtroom. Also, Bill Daley, Mr. Gore's campaign manager, walking into the courtroom right now. He is here representing Al Gore, the vice president. Also inside already, they arrived about 15 minutes ago, the Bush team. Barry Richard is the lead attorney for George W. Bush. George W. Bush's team arrived a little while ago. Also, Ben Ginsburg inside and George Terwilliger representing George W. Bush. We understand that Mr. Richard will do most of the talking, if not all of the talking, for the Bush side of things. He will share a bit of his half-hour time with Joe Clark, who is the attorney for the Secretary of State, Katherine Harris. Also inside the courtroom, Clay Roberts, the Director of Elections here in Florida. Also, two members of the Miami-Dade Canvassing Board, David Leahy and Murray Greenberg, who's an attorney for Miami-Dade County. We don't expect them to speak, nor do we expect any of the interveners, some of the public citizens and voters who've intervened in this case, to speak at all today. Again, we just expect Mr. Richard and perhaps Mr. Clark to share their half hour. On the other side of things, we expect David Boies will be the only one speaking for the Gore team. Also want to note to you that there are 4 members of the Florida Legislature inside the courtroom. This important, of course, because last night they announced that they would hold a special session to begin tomorrow. Inside the courtroom, Representative Johnny Byrd, he's a Republican. He was, you may remember, the co-chair of that joint committee that they formed to look into the election, and that's what resulted in the report recommending a special session. Representative J. Dudley Goodlett, a Republican, is here on behalf of the Speaker, Tom Feeney. Tom Feeney will not be in the courtroom this morning. Representative Lois Frankel, who's the Democratic minority leader, is inside, and sitting next to her, Suzanne Cosmas, another Democrat representative, rather. The 4 of them, interestingly, sitting side by side, chatting. I was talking with them a little bit earlier. They're excited to see the Supreme Court in action. Some of them are lawyers. Some of them have seen this before, but a couple of them said they were interested to be inside the courtroom for the first time. Also, about 30 journalists filling almost one side of the room inside as we await the 7 justices. They should begin here at about 10 o'clock. And we're told each side, again, has a half an hour, although if the justices want to ask more questions, Stephen, they can do that. So this could go a little bit longer than an hour. Stephen?
Kate, if past experience is any guide, can you give us any sense of how long it would be before the justices actually issue a ruling?
Well, there's no way of predicting it, Stephen. We can tell you that the last time they did this, which was about two weeks ago in a couple of days, on Monday the 20th of November, you'll remember they heard oral arguments. They came out the next evening with their decision, and that was a very expedited process. They've also considered this an expedited case. They say it is a matter of utmost urgency. So we may expect to hear something perhaps by tomorrow. Stephen?
Kate Snow at the Florida Supreme Court. Kate, thank you very much. Darren.
Yeah, we want to kick it right back to Tallahassee, where my partner Bill Hemmer is standing by. Bill, looks like we're about 25 minutes away from those arguments in front of the High Court of Florida. Good morning, by the way.
Indeed, you're right, Darren. And just good morning to you. Thanks again. And just to remind viewers, while we're here, it was earlier this week when Judge Sandra Saul ruled decisively against the vice president to go and have a select number of ballots gone through and examined. It's in those ballots, about 14,000, in which Democratic attorneys argue there are the votes which can be found which will give Al Gore the lead over George W. Bush in Florida, and hence the 25 electoral votes, and in turn the White House. Again, that is the appeal that we expect to hear arguments for, and as you said, about 25 minutes time. Once again, here's David Cardwell with us, and let's go ahead and break down Judge Saul's ruling here from earlier this week. One of the things he mentioned, I'm going to read from his ruling, the court must find as a fact that a legal basis for ordering any recount exists before ordering such recount. A legal basis. What is he saying?
There he's saying that the plaintiffs who brought the contest have to show that there was a basis under the statute allowing for a contest for him to go in and do a recount. They were arguing that a recount was evidence. He concluded it wasn't evidence, that was actually a form of relief, and they had to show him that there was enough reason or enough doubt cast upon the results of the election that he had to go in and do the recount. He said they did not do that.
And some of this goes to your point. It's the next point he makes, okay? The plaintiff must show the result of the election would have been different and he or she would have been the winner. Part of that also goes to that word probability that we heard so much about last weekend.
Right. The court cases in Florida for years have said that it's sort of a but-for test in a contest. In order to prevail, you must show that but for what you're complaining about, the result of the election would have been different. Now, the Gore team is arguing that while those cases were decided over many years and have been the law in Florida, that the Florida Legislature in 1999 made some changes to the election contest statute, and they made it easier to bring a contest, and they put in there in that statute that not only do you have to show that the outcome would have different, but the outcome of the election has been placed in doubt. So they're saying we placed it in doubt, therefore you need to do the recount.
Here's another thing that Saul's concludes: no fraud, no illegality, no dishonesty. And part of that goes on the next page, page 10 now. The court further finds that there is no abuse of discretion when it came to the county canvassing boards.
Right. That was a fundamental difference between the two parties that just really permeated the entire proceeding in Judge Saul's court. The Gore team was saying, all right, the canvassing boards met, they took their action. That is merely evidence that we'll introduce as to what occurred. But court, you can fashion any remedy you want. You start over. You basically start from scratch. We'll put this in evidence, and then you can decide what to do. The Bush side said, no, this is more like an appeal from the canvassing boards. You take the action of the canvassing board, and it's presumed to be correct unless you can show an abuse of discretion. Judge Saul's sided with the Bush.
Let's talk again about another point that Judge Saul's made that's actually been debated down here since the ruling came out. And that was the point he made about in a statewide race, you cannot select from certain parts of the state without including the entire state. Democratic attorneys say, no, that's not the case. This should not be allowed. And the judge misinterpreted the law in that situation.
Well, as we found throughout a lot of this post-election legal maneuvering, that we're into uncharted waters, as we said, that we're making new laws sometimes as we go along, or at least addressing new issues. We've never had a statewide contest in Florida, at least in recent memory and under the current election code. So, yes, there is some question. And if you just look at the statute, it does contemplate that there could be an election contest that's more than one county, because the legislature passed a statute that specifically says when that occurs, you file it in Leon County. That's why we're up here instead of down in Palm Beach or Miami-Dade. But it doesn't say how you actually initiate that contest. Do you bring in all 67 counties, or do you pick and choose? Another fundamental difference between the parties.
I'm not sure if we can take the camera again inside the courtroom, but if we can show our viewers again a picture of State Supreme Court inside live. It is the not only journalists but also the lawyers there continue to mill about. The man with the I guess you could say bald top there, the bald crown, is David Boyce sitting there, lead attorney for Al Gore. Again, we anticipate he will take the bulk of the argument, all 30 minutes of his time later today. To his right and out of screen right now would be Barry Richard, and then next to him would be Joe Clark, who again will argue the Republican point of view in front of the justices. I think also, David, let's go back to the 7 justices, again, that were figured so prominently 2.5 weeks ago. One justice really struck me back then and still today, Barbara Pariente. She asked a lot of questions, and it's my understanding her history is to ask a lot of questions. But two of the things she asked back on the 20th of November was, number one, what gives us the authority to take this deadline and extend it? And number two, what is a fair deadline extension? They concluded it was 5 days at that point. And I bring that up simply because those 2 points struck me as so true based on the outcome and the decision that they gave.
Right. And Justice Pariente is known to be a good questioner. She likes to really probe and try to get into the case. And what was interesting about those 2 questions that you raised, the first question was, was it really appropriate for them to extend the deadline? That was the basic legal issue before them. But then when she went ahead and said, what's a fair extension, it almost, was telegraphing. She'd already decided we need to extend what's going to be the right extension.
And what they said was, David Boyce, what do you believe is a right extension? He said December 1st, which at the time was 10 days. They gave him 5, so they kind of split the difference.
And let's not forget, Miami-Dade Canvassing Board was saying we could complete our recount by December 1st, but they weren't able to do it by November 26th.
We've got more to talk about. We will, coming up shortly. Back to Atlanta quickly. Stephen and Darren one more time.
Gentlemen, thank you very much. Historic day.
It is, and we're standing by about 19 minutes away from those arguments beginning, oral arguments beginning inside the Florida Supreme Court. A look inside, and the reason we can show you this picture, the sunshine laws in Florida that allow cameras in the courtroom all the way up to the highest court. So when the arguments do begin, you will see them live here on CNN.
Also allowed inside the court a few, very few, regular citizens. And here.
People talking with people. KDDI.
You start every morning with eyes that are new. Open up, your heart knows what's true.
宇宙ステーション。16の国々が協力して作り上げる新時代の不思議な魅力を醸し。
The executive branch.
Gerald Kogan served on Florida's highest court for 12 years. He says it would be unusual for the court to overturn a finding of fact from a lower court judge like Judge N. Sanders Sauls.
However, if the court feels that a judge has grossly, abused his discretion, then the court will say, we're looking at the facts and his findings don't jibe with the evidence that was at trial, and therefore they'll go back and reverse it.
It's impossible to predict how the court will view the Gore appeal, said one former justice. No matter what they do, they're going to get a lot of grief. Kate Snow, CNN, Tallahassee.
And as we speak and play that report for you, our own Kate Snow is actually inside the courtroom of the Supreme Court of Florida right now. Kate? Do we have Kate on the phone?
The courtroom. Yeah, can you hear me?
Yeah, we can hear you now.
I'm actually standing right outside the courtroom. Let me bring you a bit of news. The cell phones in this age of cell phones are only usable outside, right outside the courtroom. And I just happened to walk up. David Boies, the lead attorney for Al Gore, was on the phone. I heard him talking, and he was talking with Vice President Al Gore. I don't know whether the Vice President called him or he called the Vice President, but I can tell you that I was walking by and I heard him say, "We have the law on our side." He thanked the Vice President, very much. He said, "Thank you very much, and we will speak to you afterwards." So all of the reports of the Vice President keeping close tabs of this legal fight, obviously, truth to those rumors. The Vice President speaking with David Boies, I confirmed that it was the Vice President on the phone just before he walked into the courtroom about 5 minutes ago. Darren?
And so you know for sure that he was talking to the Vice President while you were eavesdropping, so to speak?
Well, I was not eavesdropping. I was walking by, but I said, "Mr. Boies, is that the Vice President?" And he said yes.
Okay. Very good reporting. Also interesting to see that even Mr. Boies has to step outside to use his cell phone. The same technical challenges that you apparently had. Kate Snow reporting from just outside the courtroom of the Florida Supreme Court. Once again, about 13 minutes till those oral arguments begin. We'll get in a break here and be back after this.
Moving fast. The internet is forcing rapid change on traditional business. It's time to get online by joining Sesame, Asia's leading e-hub. It's a key strategic decision that will allow you to change the boundaries of your business and the rules of your industry game, putting your business above the competition. How do you get there? Through the door. Sesame, Asia's leading e-hub.
can learn the art of legendary service in a few months. It takes generations. Thai Airways International.
I'm Christine Romas on the floor of the New York Stock Exchange with this look at the financial markets. It's earnings worries and earnings warnings that are plaguing the tech stocks today. And you've got the tech part of the market moving lower while the blue chips seem to be stabilizing a bit here. Motorola is the latest company to reduce sales and earnings estimates for the current quarter. Here on the big board, shares of the mobile phone maker are down about 1 13/16. Motorola now says sales will be about $500 million shy of earlier estimates, and earnings per share will come in well short of forecast. That warning is hurting the big name techs on the Dow. The blue chip index had been lower, but has now managed to poke ahead about 3 points, 10,669. Yesterday, the Dow tumbled 234 points. Hewlett-Packard is falling fractionally. Bear Stearns cut 2001 earnings estimates on HP on concerns about the PC industry and HP's management. Also hurting tech stocks this morning, some negative comments about Microsoft. Microsoft shares are moving down about 4 points. Goldman Sachs making those comments this morning. And that's the latest from the floor of the New York Stock Exchange. CNN Morning News will be back right after
this. Where do you find inspiration? Sometimes where you least expect it. With technology that takes you beyond old boundaries to something more inspiring. Like these compact ProLine servers with Pentium 3 processors and a 1.75-inch profile that fits everywhere, you can have your next big idea anywhere. Welcome to the new IT. Inspiration technology from Compaq.
Your eyes on the world.
CNN.co.jp, CNN's new Japanese language website created in partnership with Asahi.com. Count on CNN.co.jp for news from every corner of Japan and the world. The latest in business and technology, sports scores and updates, and a whole lot more. CNN.co.jp. Up-to-the-minute news from CNN in Japanese. Log on today.
Meet Peter Westbrook, a 6-time Olympic fencer who returned to his inner-city roots to help children headed down the wrong road. It's just another example why people count. Only on CNN.
The only sex I practice is safe sex.
As a politician, I support the battle against HIV/AIDS.
I always talk to my kids about AIDS.
I volunteer in a program for people living with HIV.
It's okay to be responsible. It's okay to stop HIV transmission. A message from the Pan American Health Organization.
Need a good reason to care about the world? We've got millions of them. Care. How many lives can you change today?
Once again, a live picture inside the courtroom of the Florida Supreme Court. We expect those oral arguments to begin less than 7 minutes from now. While we wait, while we look forward to those oral arguments, we're going to get some insight on the legal issues facing today's court proceedings with Robert Shapiro. He is an associate law professor at Emory University here in Atlanta. Robert, good to see you once again.
Nice to be here.
We have been here before, just mere days ago, in front of the Florida Supreme Court. What will we hear different today?
The focus of today is really going to be on the contest proceedings now. That is, whether the vice president can show that there were votes that should have been counted for him that weren't counted. And I think he really faces 2 hurdles. One is that he's legally entitled to have these about 14,000 votes counted. The trial judge below said he wasn't, and he has to overcome that legal hurdle. And then I think he has to convince the court that there's time to do it. December 12th is the deadline suggested by the federal statute, and to count 9,000, 12,000 ballots by then, I think the court's going to be interested in how that's going to get done.
As we said, you're a law professor. I've heard one analogy about what the U.S. Supreme Court did as almost kicking back a term paper to the Florida Supreme Court and giving them instructions. If you want to get an A on this, this is how you have to rewrite this. With those instructions, what does the court need to do?
One of the things that did come from the Supreme Court opinion was to say to the Florida Supreme Court, be careful about what you do, and you may not be able to rely on the Florida Constitution because of the strange way that the federal election law operates.
So instead look to the U.S. Constitution?
Well, actually, just look to the Florida statutes primarily. The legislature has set up a scheme, and it's up to you to enforce what the legislature said and not to look to the state constitution to trump that. So I think it could be very interesting to see how the court understands those kinds of guidelines when it faces this case. It certainly knows that the United States Supreme Court could be looking over its shoulder.
So if we were looking at the proverbial red ink that would be on the first decision that the U.S. Supreme Court looked at, it's pointing towards the state legislature and saying, look at what their intent was, look at what they really wanted to do, because we're looking at the balance of power here.
Exactly. You can look at what the United States Supreme Court said. They said if you're just interpreting what the Florida legislature did, you're doing your job. If you're relying on the state constitution to trump what the legislature did, then you might be in trouble.
Okay, looking forward to what we're going to see today. Quickly, we have 30 seconds left. An hour of oral arguments?
That's right. That's what we're expecting.
But it can go longer.
It could. If the judges are interested or find that there's some issue that's unresolved, it could go longer. When an issue like this could well.
And once again, we're going to see a lot of peppering. This is not just lawyers having their say and getting to talk as long as they want. There'll be a lot of interruptions.
We can expect that. The justices seem very active in questioning the lawyers. They were before. We can expect that today.
And then after this questioning, will there be a decision no matter what, or does the court have options?
Well, the court actually does have an option. They asked for briefing on whether the court should hear this case at all. It's in their discretion for the Florida Supreme Court just to say, we don't want to hear the case. So that's certainly an option.
All right, very good. Robert Shapiro from Emory Law School, thanks for giving us a quick lesson on what we can look forward to today. We'll have you stick around and hopefully give us some insight later in the morning as well.
Great.
And we'll take a quick break.
And when we come back, we should be ready for those oral arguments to begin.
traditional Marunouchi district of Tokyo is about to become brand new.
Hello, everybody. I'm Paul Verkaman in Hollywood. Lauren Sidney is in New York. This year's Oscars are wide open, but one thing is crystal clear. They won't involve Billy Crystal. The entertainer has revealed he won't be available to host this time around if asked. Too busy in the spring, finishing a movie with Julia Roberts and a project for HBO.
While the race for the Oscars is still quite wide open, winners were announced on Tuesday for the National Board of Review. Quills, the risque film about the Marquis de Sade starring Kate Winslet and Jeffrey Rush, was named Best Film of 2000. Aaron Brockovich director Steven Brockovich star Julia Roberts earned Best Actress honors.
to file into their seats, which you see on your screen. Now, what's going to happen is that there are going to be oral arguments in Al Gore's petition to try to recertify the hand counts of ballots in several southern Florida counties. Now, the key here, we're going to see a lot of familiar faces, not merely the Supreme Court justices, whom Andrew Napolitano has introduced to us, but also attorneys we've seen before. Representing Al Gore, for instance, will be David Boies, a highly paid and highly lauded attorney. He will be speaking before the Supreme Court. The last time he spoke before that court, he won big. So he's hoping to enjoy significant success once again. He'll be followed by a local attorney, Dexter Douglas, who, among other things, is a fellow who worked on a board that helped come up with judicial nominees. In many ways, he's responsible for every one of the justices being up there on that bench. He's well known to them all. He's somebody who's a political player in the state of Florida. And as a matter of fact, in the first Supreme Court trial in Florida, actually introduced David Boies to the court. Now, we're going to have the Bush team. Again, familiar faces there as well. Barry Richard is kind of the lead Florida attorney and the fellow coordinating all of the Bush legal efforts in the state of Florida. As a matter of fact, today he's arguing in 3 separate cases. He had to ask Judge Nikki Clark to hold up her 1 o'clock her hearing in a case involving Seminole County because he was going to be doing today's arguments before the Florida Supreme Court. He will be followed by Joseph Clark, who has been representing Secretary of State Katherine Harris. Now, to help us review all the legal issues, I'm joined by Paul Rothstein of the Georgetown University Law Center. Let's talk about the key issues today.
The viewers should listen for 3 key issues. There are others, but there are 3 very important ones. One is called the issue of whether there is de novo review or an abuse of discretion standard. Now, that's lawyer speak for something that's really very simple. How much deference is owed to the canvassing board's decisions? A de novo standard would say that this court must decide afresh for itself, and if they would have decided differently than the canvassing boards, then they substitute their judgment. An abuse of discretion standard, however, says that even if we think we would have done something different, if what the canvassing boards did is at all reasonable and not totally off the wall, we will uphold them. So that's that question. Then the next question is the standard of proof, the burden of proof that Judge Saul's imposed on the Gore team. Should it be that Gore has to prove a reasonable probability that the election outcome would have been different if this had all been done the way Gore wants it, or is it merely that he must show it casts some doubt on the election result as it came out? So one's a high burden of proof, one's a low burden of proof. Judge Saul's put the higher standard on Gore. And then the third question is, should this be viewed statewide, as Judge Saul's did, that you have to be convinced that it would have made a difference to the election statewide, or should you view it just county by county? I think if you view it county by county, Gore has a good argument that if you count it my way, it would make a difference in the county, but would that make a difference statewide? Probably not, because if the machines are making these kinds of errors, they're going to make it in the Bush counties as well as the Gore counties, and it's going to be proportional to the vote that we already have for those 2 men. So these are the big things to watch for and listen for. There will probably be a preliminary argument about whether this court has jurisdiction in the first place and ought to take this up at all, but I think that'll go by pretty quickly.
All right, Paul Rothstein, thanks for that analysis, and Andrew Napolitano, stand by. Now, we're expecting the justices to come in about 30 seconds. Now, keep in mind, oral arguments tend not to be arguments at all. Both sides have already presented their arguments in briefs to the court. The justices have had time to read them. They know what questions they want to have answered. So what you'll have is the attorney standing up, maybe beginning to give some sort of prepared statement, and almost immediately being interrupted and peppered with questions from the various justices. Once again, to recount, we've got Chief Justice Charles Wells, who will be sitting right front and center. Also, Justices Leander Shaw Jr., Major B. Harding, Harry Lee Anstead, Barbara J. Perriente, R. Fred Lewis, and Peggy A. Quince. And now they are being announced, so let's go to the courtroom.
Now in session, all who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome once again to the Florida Supreme Court, where we'll have oral argument this morning in the case of Gore versus Harris. And as an introduction, as we did when we had oral argument in this court approximately 10 days ago in this case, we welcome the visitors here. Because of the limitations on time, it is absolutely necessary that we maintain order in the court at all times. And we ask further that at the end of the argument that counsel be allowed to leave the building together with their parties prior to the time that any of the visitors leave the building, and then hold all interviews outside the building. Once again, counsel, we are in need, because of the limited time, to get right to the issues at hand. And so I believe, it's my understanding, Mr. Boyce, that you're going to proceed first.
Yes, Your Honor. Thank you. May it please the court, my name is David Boyes, and I represent the Vice President and Senator Lieberman.
Mr. Boyce, let me start right off. When the case was here previously in the protest part of the proceeding, no counsel for any party in briefs or in argument raised with this court the U.S. Supreme Court case of McPherson versus Blacker. Seemingly because counsel did not believe that it was important for our consideration. However, that case was forcefully argued to the U.S. Supreme Court, and the U.S. Supreme Court has now called that case to this court's attention in the opinion that came out this Monday. And now, once again, no counsel has argued that case to this court, but I want to know from each counsel its importance here. My reading of that case is that the U.S. Supreme Court has said that the state legislature has plenary power, full power, in respect to appointment of presidential electors, and that power cannot be eroded even by the state constitution. Now, accepting that as controlling law, why does that not mean that the courts of this state can only be involved in resolving controversies and contests where the legislature explicitly gives this court that power, or a court that power, which it has not done in respect to presidential electors in 102.168. And secondly, even if 102.168 is read to implicitly apply to presidential electors, why is it not judicial review given to the circuit court and not this court, since the only means by which there is a right to appellate review in Florida is through the state constitution? Would you please address that? And I would like the other counsel to address that.
Yes, Your Honor. First, with respect to whether the appropriate forum is the District Court of Appeal or is this court. The District Court of Appeal has, of course, certified this issue as a matter of great public importance and a issue that needs immediate attention.
I understand that jurisdiction. My question is appellate review, where that is not expressly given in 168.
We would say, Your Honor, that under 168, this court has the power to review both directly because it has been certified up and under this court's mandamus power, which we've also alternatively put forward in our brief.
Where do we get our right to review the appellate review? From the rules and from the Constitution? And doesn't that create a federal question?
I don't think so, Your Honor, because what you're doing is you're reviewing and reviewing in an ordinary judicial interpretation way the statutes of this state. That is, I don't think the Constitution of the United States in any way means that the legislature has to sit both as a legislative body and a judicial body just because an election of presidential electors is involved.
Well, why isn't this like sovereign immunity, where the courts only have such power to resolve disputes and claims that is expressly given to it by the legislature, where if the legislature in this state says courts are not to decide claims in excess of $100,000, those are matters that are taken to the legislature in a claims bill. Why isn't this analogous to that?
Because what I would respectfully suggest, Your Honor, is that the legislature has provided this court with the authority to interpret these laws. And whenever the legislature passes a law, what the legislature is doing is passing a law that is known to be going to be interpreted by the courts. That is, in terms of Section 168, this is a law that the legislature did not say we're only going to apply this law to non-presidential elections. Prior to this case, I don't think anyone would have contemplated that this law did not apply to presidential elections, and certainly no one, not this court and not either party, so contemplated the last time we were here before the court. This is a situation in which you have a statute that the legislature has passed that provides very specific remedies. And we think that those remedies are the remedies that this court has the jurisdiction to enforce, both in terms of appellate review and under its original mandamus authority. This is not a situation in which the Constitution of the United States has said a state legislature has to sit as a judicial body in enforcing the laws with respect to elections. It has merely said that the legislature can specify the manner of appointment of the electors. Incidentally, the manner of appointment, not the time of appointment. The time of appointment is something that is reserved for Congress. And we would suggest that Congress has set that time, and that time was November 7th. So
you would agree that when the United States Supreme Court has said that there is plenary power in the appointment of electors in the state legislature, that that means that they've got full power?
Well, Your Honor, I think they have the plenary power to determine the manner of the selection. I don't think they've got the plenary power to determine the time of choosing, because that, under the United States Constitution, is reserved to the Congress of the United States. And the Congress of the United States has selected the time of choosing, which was November 7th. So I think there is a distinction between the time that the electors have to be chosen and the manner that they've been chosen. The legislature of this state, of course, selected the manner in which electors were to be chosen, and that manner was by direct election by the people. And pursuant to that decision by the state legislature and the decision by the Congress of the United States that the time of that selection was to be November 7th, there was an election on November 7th. And we think that is the issue that is before the court now, which is a contest of that election, where we have identified separately 5 groups of ballots that we believe either should have been received and were not, or in one case were received and should not have been, under specific Florida state law.
If we accept this, your jurisdictional position, we get across the jurisdictional issue, the concept of rejection of legal votes is somewhat concerning. We can look to other states. New Jersey has a similar, although not identical. And the application becomes pretty clear when individuals are prohibited from tendering a ballot. However, it becomes less certain when there is something with regard to how that ballot is read. Here you're challenging, it seems, a category of undervotes. And that's not the same as one person coming to the precinct seeking to vote. If the category exists, it seems as though it must exist statewide. If we have undervotes in one location and those are considered, then you've demonstrated that there's legal votes that have not been counted. Why would that not exist in other counties? And why would this not require, if any judicial relief, that be applied in a statewide undervote?
I think there are 2 questions there. Let me try to address them separately. The first question is whether a rejection of legal votes applies to the undervote category, or whether it only applies when somebody comes to vote and is turned away. I think going back to 1917 in Darby against State, this court has looked at the rejection of legal votes category as meaning where somebody has come, submitted a ballot, but for some reason that ballot has not been counted. In the early days, it was often that the X was on the wrong side of the paper or underneath the elector's name, or maybe it was circled instead of crossed out. And in each case, this court held that that was a rejection of a legal vote where the intent of the voter could be made clear. Jumping from the early days to the most recent case, which is the Beckstrom case, in that case, the court looked at ballots that these were optical ballots, not punch card ballots, but they were optical ballots that had been defectively marked. That is, they had not been used a number 2 pencil, they'd been circled or filled in ink, but in some way they had been defectively marked so they could not be machine read. And this court held that those ballots could not be rejected. So I think that in terms of what constitutes a rejection of legal votes under 168.
Mr. Boyce, Justice Harding.
But why does that not have statewide application?
Your Honor, I think that it does have statewide application if anybody contests ballots other than in the particular categories that we have contested ballots.
But, Judge Sauls, in his order, referred to the opinion of the Attorney General that indicated that if this type of result happened, that there would be serious or potential federal and state constitutional questions, and that the vote would be in jeopardy.
Your Honor, I think there are two points to that. First, if merely having a manual recount in some areas and not in others would make the election defective, then this election would already be defective, because there were manual recounts in a number of counties that were included in the certified results of the Secretary of State. Second, with respect to the Attorney General's opinion, I think that opinion was pointed to the point that if a manual recount was requested and received in one place and requested and not received pursuant to state law in another case, that would involve a disparity. I don't think that opinion addresses the situation where you have a request in certain counties but no request in other counties. There's never been a suggestion under the state law that you should have a recount where it was not requested.
But
Go ahead.
Mr. Boyce, the 168 in its present form has only been there since 1999. Now, this court said in 1981 that there's no common law right to contest votes, that judicial restraint should be exercised because of the fact that elections are political questions. We said in board right before that we would get involved, courts would get involved if there were allegations of fraud. Now, we lowered that threshold somewhat in Beckstrom by saying that we would get involved, courts would get involved if there was substantial non-compliance with election laws. But aren't what you're asking this court to do is to have the courts of this state get involved in any instance in which someone comes in and merely alleges that there needs to be a count because there were legal votes left out, not going through the canvassing boards, but legal votes left out. And then, that would have to do with an election. Someone would say they lost by 130,000 votes in Dade County. And we'd have to have the court count those votes.
Your Honor, I don't think that's what we're arguing. This is not a situation in which somebody has simply come in and said, we've lost, we'd like to have a recount under the contest statute. This is a situation in which we have identified specific votes, many of which were agreed by the district court, were votes in which you could clearly discern the voter's intent. You had 215 ballots that are not included in the certified results in Palm Beach County, where the circuit court found on undisputed evidence that there was a clear voter intent expressed on those ballots, and they were not counted. You had 168 ballots in Dade County that were counted before that county prematurely stopped its count. Where the circuit court found that these were ballots that expressed the voter's intent, that the canvassing board had properly identified those ballots. So these are ballots where we know that if you look at the undervotes, you find ballots that can clearly have a discernible intent of the voter found from them, and yet they're not counted. This is a situation in which the evidence is clear and undisputed that there are voter errors and machine errors that create this undervote in punch card equipment. In fact, the court found, the district court, the trial court found at page 10 of the opinion that this had been known to county officials for many years. So this is not a situation in which you simply have somebody coming in and saying, we lost and we want to have another chance at it. This is a situation.
What do you contend then is the standard that we have to apply to this in order to get a recount? There are two issues here. One is whether or not you demonstrated you were entitled to a recount of those 9,000 votes. And the other issue is whether or not you would actually win the contest, which I think are two different issues. So what is the standard to apply to the first one? That is, are you entitled to a recount? And what did you demonstrate to the trial court that you contend to us demonstrates that entitlement?
We demonstrated first that there were a large number of ballots that were not counted by the punch card machines. We demonstrated second that when you have a very close election, you have to have a manual review of those ballots in order to have an accurate tally. That was not just our expert, that was their expert, Mr. Amon, who testified that you had to have a manual recount in a close election.
But why wouldn't that apply to all the other counties, at least the punch card counties, where there are undervotes, and those votes also haven't been counted? If we're looking for accuracy, which is what has been the statement from day one, then why isn't the request made, and wouldn't it be proper for any court, if they're going to order any relief, to count the undervotes in all of the counties where, at the very least, punch card systems were operating? In other words, is there something different about Dade, Broward, and Palm Beach and their use of the punch card than the 17 other counties that also use punch cards?
I think the first difference is that that's where ballots were contested. That's where first a manual recount was requested, and that's where ballots were contested. And throughout the interpretation, not only of the current version of 168, but prior versions of the contest statute, this and other courts have looked not at the entire type of ballot that may have been involved, but only those ballots that were actually contested by a party.
But we've never had a statewide contest, have we, in this state?
Well, actually, back in 1916, in the gubernatorial race, there was an attempt to bring a contest by mandamus to this court. But in the modern era, I think the court is right. You have not had a statewide contest. But the statute doesn't make a distinction.
Is there a connection then between the protests? You contested these ballots through the original protest. So do you have to have done that in order to bring a contest? A party could not bring a contest without having gone under Section 166 previously?
No, I think, Your Honor, a party could have brought a contest without having gone the 166 route.
But not of the ballots?
No, I think you could contest the ballots. Even if you had not protested the ballots, I think 168 and 166 are alternative remedies, and I think this court so held the last time we were before it, that those are alternative remedies, and I don't think a 166 protest would be a condition.
However,
we did both.
Where there has been a protest, isn't 168 and 166 aren't inextricably linked? I mean, what we've got is that you bring the complaint within 5 days after the protest has been completed by the last canvassing board. The party defendant in the action is the is the county canvassing board and the election canvassing board. Seems to me that that statute now, since 1999, contemplates an evaluation of the county canvassing board if there has been a protest. Why is that not true?
Because, Your Honor, the 168 statute clearly provides for the canvassing board to take certain actions. In 168, it's a protest, or excuse me, a contest of the election, and there is no discretion or other responsibilities given the canvassing board there. The contest period is a period that, as I think this court last held when we were before it, is designed to allow any candidate to challenge judicially the vote, and it provides alternative approaches. One approach is, of course, misconduct. That's subsection A. But subsection C, which is what we're providing, simply talks about the rejection of a sufficient number of legal votes.
Justice Shaw.
Can we return for a moment to Judge Saul's order? He makes certain findings. For instance, he finds that there was no credible statistical evidence and no other competent substantial evidence to establish by a preponderance of a reasonable probability that the results of the statewide election in the state of Florida would have been different. Do you see that as a finding of fact or a finding of law?
Well, Your Honor, I think that it's a mixed question of law and fact to the extent that it relates to the factual issue. For example, at page 442 of the transcript, Mr. Amon, who was their witness, testified that you needed to have a manual review of the ballots. Mr. Burton, who was their witness, Judge Burton, who was their witness, testified that they were able to identify 215 ballots where they could clearly ascertain the intent of the voters that had not been counted by the machines. We have 9,000 ballots in Miami-Dade that are alleged that have not been registered by the machine that have never been manually reviewed. Every time any board has looked at these issues, they found ballots, they found votes.
But when you put on experts and the judge listens to these experts and then he makes a determination based upon that, normally isn't that a question of fact?
It is, Your Honor, but here the court expressly based its conclusion on 3 errors of law. First, that you have to do a statewide recount, which we think there's no support for it in this or any other state. Second, that under 168, it's an abuse of discretion standard. Again, we don't think that there's any case that says in terms of what a ballot means, whether a ballot does or does not reflect a voter's intent. That is something that in the judicial proceeding of a contest, discretion resides in the canvassing board. And third, that in order to even look at the ballots, which are already admitted in evidence in the case, you have to show a reasonable probability that you will change the election before you even look at the ballots. And again, we think that is inconsistent first with the standard in 168, which says or place in doubt, and is inconsistent with the way a trial goes, which is that you look at the evidence before you reach that conclusion.
You are in your rebuttal time, but Justice Harding has one question.
Talking about looking at the ballots, I know they were introduced into evidence before the trial judge, and I probably asked this question as well, I was going to say old, but as a former trial judge. Did anyone ever pick up one of the ballots and hold it up and show it to the judge and say, this is an example of a ballot which was rejected, but which a vote is reflected?
Not a particular ballot, Your Honor. We offered the groupings of ballots that we had segregated. All of those, of course, in order to prevent contamination, were not given to the lawyers. They were kept under the control of the clerk of the court.
And but nobody asked the court for permission to do that or showed him one of those ballots?
Not an individual one, although we did tender them in evidence, and we did ask him repeatedly to look at the ballots as part of the evidence.
You're deeply in your rebuttal time, Mr. Weiss. Oh, I'm sorry.
Is that all right? I'll forego my time. I was going to address remedies in any event, and the court has addressed the other questions.
Thank you, Mr. Douglas. Mr. Richards.
It please the court. I'm Barry Richard on behalf of George W. Bush and Richard Cheney.
Mr. Richard, let me start with my question that I asked Mr. Boyce. When this case was here before, counsel for Mr. Bush did not present any argument on McPherson versus Blacker, yet when it got to the Supreme Court, counsel for Mr. Bush forcefully argued McPherson versus Becker. Now I know, Blacker, now I note that it's not argued again here. Is it the position of Mr. Bush that that case does not have any bearing on this matter?
Oh, Your Honor, I think that the case has substantial bearing on the matter. I think that what McPherson v. Blacker tells us is exactly as Your Honor suggested it, which is that this court does not have the ability in this particular case involving presidential electors to disregard the statutory scheme and fashion a remedy based upon extraordinary equitable powers of the court set forth in the Constitution.
Do we have the right to review the action of the circuit court?
Indeed you do, Your Honor, but we come here in a significantly different posture than we did before. What we come here with now is belied by the nature of the litigants and the public interest. In fact, this is nothing more than a garden variety appeal from a final judgment by a lower court that reviewed after an entire full evidentiary hearing.
But the legislature, having plenary power, said that the circuit court will make that determination.
Well, I agree with you, Your Honor, and I would not suggest to this court that the circuit court is not subject to any appeal. I believe that the circuit court is subject to appeal, but in a very limited fashion. And I also think that one reason that we have not placed emphasis upon McPherson versus Blacker is because, in fact, this court said the same thing in an earlier McPherson case, which Justice Wells referred to, McPherson versus Flynn, in which this court said, since there is no common law right to contest elections, any statutory grant must necessarily be construed to grant only such rights as are explicitly set out by the legislature. The legislature in Section 168 has given us 5 and only 5 grounds for an election contest, and one of them is not that there is a close election in which vote-o-matic machines are used.
Well, the bottom line, if I understand it, though, of your answer to the Chief Justice's question is that this court does have appellate jurisdiction over the trial court's ruling. Do I understand that to be your answer?
I think that this court has limited appellate jurisdiction
and that the McPherson case, the federal McPherson case, not this court's McPherson case, does not affect that appellate jurisdiction.
No, sir. I certainly believe that this court has the ability to review what a circuit court did to determine whether the circuit court violated the traditional rules.
Much in the way we would be reviewing it if it was another county commissioner or an election for some other office, a member of Congress, and a contest was brought.
Precisely, Your Honor. The court is the great leveler in the sense that it doesn't make any difference whether we're talking about school teachers and laborers or presidents and kings. The rules are the same. And the rules in this case are very clear. There are 2 questions that this court must answer. Was there substantial competent evidence in the record below to support the judge's findings? And did the judge properly apply long-established law?
Referring to the substantial competent evidence issue, isn't it highly unusual for a trial court to admit into evidence certain documents that one party claims will be controlling with reference to the claim they bring to the court, and yet never examine those documents before making their decision? And didn't that happen here with the trial court admitting the disputed ballots into evidence, but yet never looking at those documents?
Well, I think that the trial court theoretically admitted the ballots for purposes.
Well, theoretically, or did the trial court either did or did not admit the ballots into evidence? Did the trial court admit those into evidence?
My recollection is that the trial court did. There were thousands of ballots which were embargoed, and my recollection is that the trial court did, there was not a substantial dispute over whether or not the court could technically admit them into evidence.
Did the trial court examine those documents?
No, Your Honor, because I think there was no basis in law for the trial court to do that until after the plaintiff had carried its burden of proving that there was some necessity to do so, and this leads to the core of
Then what does subsection 8 mean? The subsection that was specifically added in 1999, and you've told us we've got to follow this statute, that the section that says that the circuit court is to do whatever is necessary to ensure, which is rather unusual language to use in a statute, to ensure that each allegation in the complaint is investigated, examined, or checked. If it isn't to mean that the circuit court is to look at the very ballots that have been brought to the court for investigation, what does that section mean in the context of this litigation?
Your Honor, this brings us back to McPherson versus Blacker. Neither the circuit court has no greater power than this court to disregard the scheme that the legislature has provided us with, and that scheme is crystal clear. In fact, this court recognized it 10 days ago in the Harris case when it said the decision whether to conduct a manual recount is vested in the sound discretion of the board, and cited Hogan. The Hogan case was indeed precisely the same as this case. It was a case in which the canvassing board elected not to conduct a manual recount, and this court referenced that case in which they said that the application of Section 168 does not change the necessity to show an abuse of discretion when it arrives at the court. We had an absolute failure on the part of the plaintiffs here. This court gave the plaintiffs the opportunity to have a trial to prove their case, and there was an absolute failure in the record of this case to establish an abuse of discretion by any of the challenged canvassing boards.
Well, excuse me, counsel, you seem to be suggesting then that you can never have a contest unless what has occurred has already been through the protest process under 166. What would counsel do to circumstances that come to light later? For example, the precincts of one ballot, the ballots of one precinct just simply did not get included in the certification. That would not be part of the protest. Situations where it comes to light that violence is used to keep people away from the polls, that would not come to light during a protest. Are you suggesting that those kinds of circumstances then cannot be addressed under a contest?
No, sir. We don't find ourselves in that posture. We find ourselves in a posture in which canvassing boards to which the legislature has delegated the authority have made decisions, and this is no different than any of the hundreds of cases that come to our district courts of appeal and ultimately sometimes to this court in which an administrative agency given discretion has exercised the discretion, and the rule for time immemorial has been that the standard of review is whether or not that agency has abused its discretion, one of the highest standards known to the law.
So we have a ruling here, do we not, from a district court of appeal that on an application for mandamus that has said that the Dade County Canvassing Board had a mandatory duty to continue the counting of the ballots once they decided to have a recount, and that only because it could not meet a filing date would they not grant a writ of mandamus. So indeed we have a review, do we not, of the very specific canvassing board that made a decision here, and we have a legal ruling by a district court of appeal, as you say, that has held that they erred in that they did have a mandatory obligation to continue the count. How can we overturn that ruling?
The district court of appeal determined not to continue the count for two reasons. The first reason was that there was...
The district court of appeal or the canvassing board?
The canvassing board determined not to continue the count for two reasons. The first reason was that after they had done the initial 1% three-precinct count, they found 6 votes difference in favor of Vice President Gore. The canvassing board made the determination that based upon that 6 votes, there was no reason to believe that there would be a change in the result of the election, one of the critical elements of subsection 168. Now, that issue was tried before Judge Saul's, and he resolved conflicting evidence in favor of the fact...
Where is there any finding by Judge Saul's that the reason that the recount was discontinued in Dade County was because the canvassing board had initially decided that there would be no merit to having a recount. Is there such a finding?
He does not make that finding, but he does make the finding that there would not have been a difference in the result, and that was within his discretion to make that finding because he had conflicting evidence.
Do you agree that in the 3rd District's opinion that they only set out that there was a single reason for stopping the recount, and that single reason was the inability to meet a deadline?
Yes, sir, and I will address that reason as well, but after...
Help me with the record in this case that we have, where it shows a contrary finding or holding with that holding of the 3rd District Court of Appeal.
Well,
in other words, where would I look in this record?
Let me address both of your questions. And so let me begin with the one that you asked. The canvassing board, it is beyond dispute, made the decision not to continue because they determined that once this court had set a deadline of November 26th, that they could not possibly meet that deadline. Now, I pause here to note that in retrospect, they apparently made the right decision because Palm Beach County, which is a smaller county, was well into their count as of that time and was unable to meet that deadline. And the law of this state from time immemorial says that no governmental agency and no person is required by law to engage in a futile act. That alone is sufficient to uphold the decision of the canvassing board because they clearly, one cannot say that reasonable men could not differ as to that decision.
Would you hold that thought for a moment? Because in our earlier decision interpreting the statutes with reference to the filing date, we in essence said that the Secretary of State could refuse a filing, okay, by a particular county only if, one, it would interfere with the federal obligation to have the electors determined by a fixed date, or two, that it would interfere with a contest. Now, has there been any showing in this case that either of those issues would apply to the decision by the canvassing board to stop their counting?
No, sir, but this court also said you must have your votes in by November 26th. The canvassing board, having made the decision it was impossible, had two choices. One was to not submit the certificate, not to continue the count, and the second was to send up a partial count, which, according to the evidence before the board, would have cut off a substantial number, not only of precincts that might have been significantly different in the result, but also that would have disenfranchised a particular minority within Dade County. One cannot say that reasonable men and women would not be able to differ as to the decision of that canvassing board. But the other point that I would like to make is that subsequent to the decision of the 3rd District Court of Appeal, there was a trial. And in that trial, Judge Sauls resolved conflicting evidence as to the question of whether, in fact, there would have been a change in the election regarding Dade County, and determined that there would not have been. There was substantial competence.
Just let me, you keep on using the language that there should be a reasonable probability of a change. And you've said that, again, we've got to stick to the statute. My reading of the statute says that it says sufficient to change or place in doubt the result of the election. Place in doubt is a different standard than a reasonable probability of a different result. Do you agree with that?
I'm not sure, Justice Periani, but I don't think we need to address that issue at this time because there was virtually no evidence in the record upon which one could conclude. There was no evidence of any single voting machine that misoperated. There was no evidence of any voter whose vote was not properly recorded.
So your position is that in the contest that errors or undervoting, as we've been referring to it as, that is the failure of the machine to read a vote that might otherwise be properly cast for a candidate, that it is not the role of the judiciary in a contest to evaluate undervotes. Is that your position today?
Well, my position is twofold. The first one is... Was that
one position? That is that this election contest statute does not vest within the judiciary the authority to review votes that were properly cast but never counted.
Well, number one, it is not the role of the judiciary to do so when a canvassing board has already done so and has made a reasonable decision, and that happened in Palm Beach County. And I can conceive of no standard that this or any other court would impose upon the Palm Beach County canvassing board.
Let's stay with Dade County, where it's undisputed that 9,000 votes that have been the subject of requests since November 9th have never been counted.
Well, I think it is disputed, Justice Barriani. All we know in Dade County is that the voting apparatus, which nobody proved was defective, determined that 9,000 votes were not properly recorded by the voter.
But we know that in the first 20%, that 434 something more or less were legal votes were recovered. You've already said that we shouldn't challenge Palm Beach County. We know that somewhere between whether it was 174 to 215 votes were recovered, and Broward County, whose certification has been included, has several hundred votes, all with the same type of machine. Are you really saying that the votes, the 9,000 votes in Dade County, which are the exact same votes that were looked at in Palm Beach County and Broward County, should not be looked at in a contest action?
Not at this point, Your Honor, for two reasons. The first is that the canvassing board made the judgment that at the deadline that this court set for everybody, they could not conceivably complete their count. And I would suggest to this court that based upon what the Florida legislature has told us, that they did not have the authority to submit a partial count, only a full count, and had they done so, they probably would have violated the Federal Voting Rights Act and the United States Constitution. That's the first reason, and this court has no basis in this record to determine that the canvassing board abused its discretion in making that decision.
Let me get an understanding of what your position is that we're talking about when we say an undervote. Have these ballots been sent through the machine?
They have, Your Honor.
I got from reading somewhere that what we're defining, or what's being argued here as an undervote, are ballots which have not been manually counted. Is that?
That's correct, Your Honor. The record indicates that every one of these votes was sent through the machine. They were rejected by the machine because of the parameters that had been set. The machine determined that the votes had not been properly marked on the ballots.
Well, that goes to the rejection issue. You would agree with that? Is that you're saying that they've gone through the equipment, so therefore they were not rejected? Is that a fair reading of your argument?
Yes, Your Honor. It's the same. Let's
go to the one next statement, and let's take it one step further. If that is not accepted or is contrary to Florida law, that those are considered to be rejected, do you agree with the standards that have been applied in other states with regard to very similar statutory language as to what you do to determine if there could be a change in the election or a doubt as to the result in the election, i.e. look to see as to first just whether there's enough votes that were not counted, not as to who they would be for? Do you agree with that standard?
I don't agree that it applies under these circumstances, Your Honor.
The standard is what I'm looking to. Do you disagree with that standard, or what standard would you have applied if you assume that they were rejected? How does one prove that there would have been a change in result or doubt as to the result?
Well, if we are in a circumstance in which it is appropriate to look at ballots, then it is the job of the canvassing board to do precisely what the Palm Beach canvassing board did, and that is to use the standard that the Palm Beach canvassing board used. Now, I pause here to point out that it's our belief that the Palm Beach canvassing board violated federal law because they changed the rule in midstream and in fact should not have counted any dimples. But having said that, assuming that you're going to make a decision, you use the standard that the Pullen case used and that this court, by reference to Pullen, adopted as the appropriate standard. The record suggests that that's exactly what the Palm Beach canvassing board did. But we never reached that stage. There are 64 counties in the state of Florida that did no manual recount. And what Mr. Boies is suggesting is that every one of those counties, simply because they had a punch card system, must automatically do a manual recount.
I'm not speaking of the standard of evaluating the ballot.
Yes,
I'm
sir.
speaking of the standard with regard to how does one demonstrate that there would be sufficient to change or place in doubt. For example, New Jersey seems to suggest that in interpreting a very similar statute, that you would look to just see if there's enough votes there and assume that they would be for the challenging candidate, and that is enough to place that it could change the results. Are you suggesting a different standard than that?
No, I think the standard is the same standard of burden that every plaintiff carries in every case, which is to come into court and to prove that there is something wrong with some ballot or some machine somewhere, and that there are enough of those that we can say that whatever we call it, it would place the election in doubt. This plaintiff did not do so.
Well, if you accept that first prong that Justice Lewis has asked you if you have agreed with, and at least, and I'm not sure whether it seems that you have said that you do agree with, and that is that other courts have said that first you have to show that there are a sufficient number of contested or challenged or questionable ballots that would make a difference. Now, if you do accept that standard that has been set out in some other state courts' decisions, wouldn't you agree that at least, and for that preliminary step, that the plaintiffs here have met that? That is, they have submitted that there are like 9,000 or whatever the number is, challenge ballots, and that there is a difference in the outcome of the election that is presently measured only in hundreds of ballots. So at least that preliminary step of saying the number of challenge ballots would place in question the outcome of the election, that they've at least met that preliminary step.
No, sir, I emphatically disagree with that.
All right, and do you disagree on the basis of applying that standard, or do you disagree on the basis that they haven't met that standard?
They have not met their burden of proof, and the reason is the only thing they did was put two witnesses on the stand to say that they were speculating that vote-o-matic machines are inherently unreliable. And so in essence, what Mr. Boies is saying to this court is any time there's a vote-o-matic machine in a close election and somebody says count all the ballots, you must do so. This court in the Flaudel case several days ago said that voter confusion and voter mistake is not sufficient to throw out a ballot. And
Justice Shaw has a question.
Yes, sir.
And then I think your time.
With Justice Ansted's question, seemingly early on, Judge Saul's set a threshold and said that, in effect, that the plaintiffs could not prevail, even if no evidence was put on, until they met this threshold. And ultimately, he decided that he did not have to look at the ballots because that threshold has not been met. Is that a correct statement? What did you see the threshold as being?
Well, it's being the same as every plaintiff carries in every case, and that is to bring in sufficient evidence to meet the elements of the case. In this instance, to show that there was any reason to believe that any voter was denied the right to vote because of something other than the voter's own fault. There was not a single shred of evidence in this case on a single voter to show that. There was nothing here but the speculation of two witnesses that vote-o-matic machines do not always show the voter's intent. That's all there was.
The statute is that standard that you have to show that a mistake was made through no fault of the voter. It seems to me that we've gotten off of what the standard is for showing the rejection of votes. And it seems to me that the statute, subsection 3, says that rejection of votes which may put in doubt the result of the election. And so that is not that you have to demonstrate that the election really, that I'm going to win, but is in doubt that I did not win. So isn't that a different standard? I'm really having a problem with the reasonable probability of a different result standard that Judge Saul talks about versus the rejection of votes that would put the election in doubt. Could you explain the difference in the two?
I don't think it's necessary for us to distinguish given the razor-thin record we have in this case. The only way that one can conclude that either of those standards was not met in this case, based upon this record, is to conclude that in every case in which a vote-o-matic machine is used and the race is close, that we must manually recount in every county that used those machines, because that's what the evidence was that was used in this case.
We better give Mr. Glock a chance.
If I may, Your Honor, there's just one other issue, too, that I think we cannot lose sight of.
I want to warn counsel, we're going to observe our time limits here, so you and Mr. Glock proceed. But
this will take 1 second, Your Honor, and that is that you also have to establish the second element, which is that in whatever standard you use, it would have changed the result of the election. If you look at the evidence here and you look at the lower court judge's determination, no matter which standard you use, there was insufficient evidence to indicate that. And this court cannot reverse the lower court judge unless there is a complete lack of substantial competent evidence in the record to support his decision, regardless of the standard. Thank you.
Mr. Clark.
May it please the court. I think I remember the first question. We did not argue Blacker in the Supreme Court on behalf of the Secretary and the Canvassing Commission. But I think the answer to your question is this, that the judiciary obviously has the appellate power to review what a circuit court does. There is a constriction, however, and I think that constriction is picked up in the language of the Supreme Court, and that has to do with the concern in this kind of election having to do with presidential electors, which is different than the other kinds of elections, for instance, referred to as by Justice Anstead, and that is the language on page 6 of the slip that says, since Section 5 contains a principle of federal law that would assure finality of the state's determination if made pursuant to a state law in effect before the election, a legislative wish to take advantage of the safe harbor would counsel against any construction of the election code that Congress might deem to be a change in the law. So I suggest that is the restriction that you would have. The legislature has the power to select electors. In Florida, the legislature has allowed the people to make that choice, but I think, Mr. Chief Justice, that what you need to do is you need to be careful in terms of construing statutes or remedies to not do anything that would constitute a change in the law, because if that is done, then that places in jeopardy either the safe harbor, if the Supreme Court limits itself to that, or the concept that any kind of change of law is barred by Section 5. Why hasn't that been accomplished in our previous decision that gave due regard to the fact that you have a federal scheme that has certain fixed dates or a calendar in place, and that we have interpreted the statute to be certain that the votes are counted and finally counted before that fixed date comes into play? Why doesn't that take care of that? Justice Anstead, I don't think there's...
I don't know that you're saying that it doesn't. I'm asking you.
No, Justice Anstead, I think the problem is there's no way of reading Harris. I mean, Harris was not limited to dealing with presidential election contests, obviously. The Supreme Court of Florida was dealing with issues that had to do with the Florida Election Code.
And the Florida Election Code, as enacted by the legislature, is a single election code, is it not? That is that the Florida legislature, after submitting to the voters of Florida the authority to pick their presidential electors, has not said we're going to have one election code now to review that election, and we're going to have another election code to review all other elections, have they?
Your Honor, the Florida Election Code is a short form for including all the various statutes that deal with elections in Florida. There is one collection of laws that deal with that, but there are different provisions that deal with presidential elections in 103 than deal with other elections. I think the difficult...
Well, in terms of any of the issues that we've been talking about, as far as counting votes and ballots and filing them and returns and all of those things, there is simply a single scheme, is there not?
Your Honor, I don't think that there really is. I think Harris is a substantial departure. If the test is...
Tell me where there is a separate scheme for considering the outcome of the electors for president. And this proceeding is a good example of this, and that is that we've had a contest, filed in the circuit court. Mm-hmm. Do you agree that the contest statute applies to the selection, the election by the people of Florida of their presidential electors?
I think that the contest statute can apply in this situation if it's applied properly.
Okay, does it apply?
Yes.
Okay, and it is a contest statute that applies to all elected officials, does it not?
No, but Your Honor, the problem is that you then can't take the next step. The fact is the court can't change the law. If the court changes the law, then you run afoul of Section 5 and the safe harbor.
But you're not suggesting that the interpretation or construction of a sentence is a change in law, are you? The problem, certainly,
Justice
the
Lewis,
first time, if a dispute arises, somebody must say, if the legislature has written the sentence and two sides don't agree, it seems as though a court must try to do its best to see what that legislature wanted done.
But Justice Lewis, there's just so much baggage the word interpretation can carry on its back before it becomes more of a change than it is an interpretation. And that's the situation we have here. And not unfairly to the court. Again, the court was dealing with a situation in front of it. But interpretation going from 7 days to 19 days, that's a lot of baggage for the word to carry in that regard. I think that the Harris decision was bottomed on a number of principles, common law principles, equitable principles, constitutional principles, but forget all of that if you want to. If you want to try to go back to just statutory construction, you have a problem because the interpretation is sufficiently broad that I think fairly viewed it constitutes a change in the law under Section 5 of Title III.
Thank you, Mr.
Today, just looking at 168, that's what I'm looking at is the one sentence that seems to be the really dispute here, and that is whether legal votes were rejected and it would have made or changed the result or place in doubt the result. Now, is it impossible for this court to apply that to the facts that we have without doing a change in the law?
Yes, Your Honor, because the problem is that you have to create a pile of law to do it. You have to do a number of things. You have to first find that in a presidential race where you are electing 27 electors, that you can do it on a county-by-county basis. Then you have to figure out a way of having the contest statute used to establish a standard when the only standard that applies anywhere for a manual recount, which, as we argued before the court previously, was limited to the situations in 166 which were brought about because of mechanical problems. But put that aside. The only basis, and as dehors the common law, obviously, to have a manual recount is in Section 166. And that calls for finding the voter's intent, but it also adds 3 specific people that are on a uniform basis throughout the state. The combination of whatever the voter's intent is plus the 3 people is what is done there. We go from there to a circuit judge in Leon County who then, I suppose, has to come up with a standard that is not articulated in the law. And as Your Honor pointed out, each time you asked the question, you talked about legislation in other states. That's where it has to come from. There is no indication that the Florida legislature intended, by acknowledging and respecting the power of the state judiciary to interpret laws, that the judiciary would be in a position of having to create the standards that would be applied in this kind of situation. And that's the problem we have.
Your time is up. Thank you very much. Mr. Boyce, I will give you 1 extra minute since Mr. Locke's answered that question.
Thank you, Your Honor. Let me begin by emphasizing what I think all 3 counsel who have spoken today agree on. First is that this court has jurisdiction over this case. Second, that 168 applies to presidential elections. A third point that I think there is agreement on, and that is that this court should not change the law. It may have to interpret the law that exists. It should not change the law.
Mr. Boyce, let me ask you about the part of that U.S. Supreme Court opinion of Monday that Mr. Clark just referred to, and that is that the U.S. Supreme Court did say that a legislative wish to take advantage of the safe harbor would counsel against any construction of the election code that Congress might be deemed to be a change in the law. However, doesn't that also mean that if we're going to have it take advantage of Section 5, that all of these contests have to be concluded, as you told me before, when we were here before, by December the 12th. And we don't have a remedy here that can do that by December the 12th.
Your Honor, I think you do have a remedy that can do that by December 12th. I think first, almost all of the issues in terms of number of issues, although not in terms of number of the ballots, are now legal issues before the court. The 215 ballots in net votes for Vice President Gore that have already been identified as legal votes by the Palm Beach Canvassing Board and are not disputed by the defendants.
Just on that, there was in Governor Bush's brief a reference to an audited return that showed 174, and since numbers seem to be pretty critical here when there's such a small difference, do you agree that with that later number from Palm Beach County?
We don't agree to it, but even their offer of proof, which was submitted after the trial was over, and which is where that number comes from, I think only related to the numbers submitted as of 5 p.m. The 215 number is a number that goes through 90 minutes afterwards when they completed their count.
And that information's in this record?
That's in the record. It's in the Palm Beach answer to paragraph 60 of the complaint, and it was in Judge Burton's testimony at page 278 of the trial transcript.
And the only reason that was rejected was because of the deadline that this court had set of November 26th for the certification.
Yes, and as this court said in Harris, the certification is one process, but the contest is another process. If those votes existed and had never been certified or never been counted, but we knew those votes were there, under the contest procedure, they would have to be included.
Let me ask you another question, realizing time is short, but going back to a couple of the questions that Justice Lewis asked about the purpose of this particular provision in the contest statute, as far as legal votes not being counted or illegal votes being counted. Why do you think it would be that the legislature would set out a totally different scheme for recounts that to be decided by local canvassing boards in one section, and therefore have a procedure in place for recounts and undervotes and that kind of thing, and yet still reserve in a contest statute allowing a circuit court to do it all over again, or to do it in any case? Does that really make sense in an overall scheme here? I want you to address that question, and then my second question to you is, why wouldn't we conclude here that at most all that you have demonstrated in the trial court is a possibility that there may be a difference in the outcome? Because as you have conceded, no one has looked at the 9,000 votes that you're talking about. Could you answer those two questions?
Sure. With respect to the reason for 166 and 168, we believe that 168 was intended by the legislature to promote the certification process, to get that process done, and that's the responsibility of the canvassing boards. As this court held in Harris, once that certification is done, the responsibility shifts from the canvassing boards to the courts. Now, there aren't very many contests. Usually people accept the results of the canvassing boards. You have a contest only when some party believes that they've got a legitimate reason for it. And that goes to the second question that you asked, and that is, why do we believe we've shown what we've shown? And we've shown the 215 and the 168, and that gets you up to 380.
You still have to get to the Dade County votes, do you not?
You still do, but at that point you're down to 100 votes, Your Honor. Well, when you get to the Dade County votes, you're down to 100 votes. And remember, Dade County was finding about 1 out of every 4 undervotes to be a vote. But under procedures
Mr. Boyce,
approved by the court.
If we're looking at this through the protest statute, then it's certain that the only manual recount that there could be done under the statute would be to recount all the ballots. That's specifically what the statute says, is it not?
Your Honor,
shall manually recount all the ballots.
What the Dade County Board had done is to say, before they stopped on November 22nd, they had decided what they were going to do was count all the undervotes. We think that would have been an acceptable
But that would
result.
definitely be a change in the law, because the statute says they can only, if they decide upon a manual recount, manually recount all the ballots.
But I think that's right, Your Honor. I think that you could interpret the law that way. I think you could also interpret the law in the sense of saying all of the ballots that were requested to be manually recounted. If neither party requested the others to be manually recounted, and if the machine was recording votes, I don't think you would necessarily, under that statute, have to interpret it that you would have to do that. In any event, the court below ruled that the Dade County Board had discretion to make the decisions that it made. One of the decisions that it made, that the district court below, the trial court below, said it had the discretion to make, was the decision to simply manually recount the undervotes. And they stopped only because they didn't have time. And
is that undisputed on this record, or do you agree with Mr. Richard, your colleague here? That is that he says that that is not the only reason that there was not a recount in Dade County?
I don't think there's any other reason on the record, Your Honor. First, Miami-Dade questioned whether to do a manual recount. They then decided to do a manual recount. They were undertaking a manual recount. On the morning of December 22, they said they were going to manually recount all of the undervotes. They then stopped 12 hours later.
Is the transcript of all three of those decisions by the Dade County Canvassing Board in the record?
It is, Your Honor.
And speaking of time, and going back to what Justice Wells was asking, in terms of the remedy, and now we're specifically as to the Miami-Dade votes that you are contesting, what is the time? We're here today, December 7th. What is the time parameter for being able to complete a count of those undervotes?
The record shows that the canvassing boards were doing about 300 an hour, 250 to 300 an hour. That was with 3 people looking at every ballot. That was obviously slower than it would be if it were being done by one judicial officer. We believe these ballots can be counted in the time available. Obviously, time is getting very short. We have been trying to get these ballots counted, as this court knows, for many weeks now.
With the Chief's indulgence, one last question, and it really ties in to something actually that you brought before the court in the first oral argument that we had here. And that is of this problem that continues to reoccur in the case of not having recounts in other counties where the same voting mechanisms were used and where there may have been undervotes, but that the proportion of votes, for instance, may have favored your opponent. And that we're now here on December the 7th with December the 12th, fast approaching. At the last proceeding, neither side took us up on whether it was an offer or not. At least it was a concern of the court in terms of the appearance of fairness or equity. How can we resolve an issue like that at this late date?
2 points, Your Honor. First, there's never been a rule that says you have to recount all the ballots in an election contest. In fact, every case that we've cited has been a case, including the Beckstrom case, where only the contested ballots were reviewed. To make a different rule would be a change in the law. The second point is that every party has a right to contest, but no party is required to contest. What the sense seems to be is that somehow Governor Bush's campaign should be protected from Governor Bush's lawyers, that they didn't ask for a recount, and therefore there should be a recount anyway, even if they didn't ask for it.
Thank you, Mr. Boyce. I think your time is up. We very much appreciate all counsel's assistance in the court's resolution of this matter. Now, per the instructions at the beginning, if everyone will remain seated until counsel and the parties have exited the building, and then we ask that you be recede in an orderly way, and we appreciate very much the order and seriousness with which everyone has addressed this matter. Court will be in recess.
So there you have it, and now it is time for the post-game show. You've seen arguments before the Florida Supreme Court. The Gore team wants permission to go ahead and do a selective recount of so-called undervotes, specifically in Miami-Dade County, but also some options of reviewing some of the recounts in Palm Beach County as well. That offer was rejected by a Florida county district court, and that you've just heard the appeal of that decision. Now we're going to talk with some legal experts who can help us make sense of what we've just seen for the past hour. First, I'm going to call upon Judge Andrew Napolitano, the host of Power of Attorney. Judge Napolitano, how did you view the questioning? Is there anything that we can divine from the questions being asked of either side?
Yes, I think there are a couple of points, Tony. I think the most important feature that comes across pretty clearly in the questioning that the 7 members of this court, all members of the court, put to both lawyers, is their now overriding concern for the mandate visited upon them by the Supreme Court of the United States, namely that we, the Supreme Court of Florida, cannot change the law, and that the legislature has primacy, that the legislature is superior to us, the Supreme Court of Florida, when it comes to determining when votes are counted and how they're counted and when the votes are due. I counted 6 times, Tony, that the Chief Justice addressed this issue, including the first question he put to David Bowies and the first question he put to Barry Richard. And it basically was, why are we here if the legislature is superior to us? The Supreme Court has said that it is, and the legislature has said the votes were due 7 days after Election Day. So that is obviously on their minds. Now, I also detected in Justice Pariente perhaps a strong desire to order a limited recount, but I did not detect that in questioning from any of the other justices. The rest of them seemed profoundly concerned with the federal implications of what they might do. That is, might they be stepping on the toes of the Florida legislature, and might they be changing the law as the Congress has said they can't do?
Okay, Paul Rothstein of Georgetown University Law Center, do you agree?
In general, yes, but there was something remarkable that I must remark on here. The Chief Justice and some of the other justices attempted to hand Mr. Bush's lawyer, Barry Richard, a brass ring that would win the case for Mr. Bush. What they said to him was, the United States Supreme Court said this case must be decided based on legislation, not based upon the Constitution of Florida. The legislation governing this mentions only the circuit court, Judge Saul's court. It mentions no jurisdiction, nothing about us, the Supreme Court of Florida. Therefore, if we are to follow the mandate of the United States Supreme Court that we must follow the legislation, we have no role here. And therefore, Judge Saul's decision, which is for Mr. Bush, stands. For some inexplicable reason, perhaps because lawyers are always very busy and thinking and nervous, and human beings can't compute everything that's thrown at them. For some inexplicable reason, they did not grasp that, and they said, we're not sure we agree with that. So I think that was like a big mistake myself.
Okay, we're going to take a break from our analysis here. We're not going to leave, though. There you see Bill Daley, who's the campaign manager for Al Gore. He's getting ready to make some comments to the press on the steps of the Florida Supreme Court.
Al Gore and Joe Lieberman made their case to the Florida Supreme Court, and it was made very well by Mr. Boyce and Mr. Russell and Mr. Berger, the entire team. We are very grateful to them. The entire proceeding has been based on one premise, that every vote should count. We look forward to the decision of the court. We respect them. Obviously, this was those who watched it were most impressed by the presentations, and also obviously once again by the questions and by the statements of the justices. So we thank them for the seriousness in which all are approaching this issue. And again, we, on behalf of Al Gore and Joe Lieberman, thank our legal team for the tremendous presentation. Thank you. Thank you.
Chairman. Okay, well, we learned a lot from that. That was Bill Daley doing the normal spin on that, and we'll probably also be hearing from the Bush team presently. Let me go to Andrew Napolitano. Paul Rothstein has just raised an interesting prospect, which is that they tried to hand Barry Richard the whole case, and he wouldn't take it. Was that your reading as well?
Well, part of that was my reading, and I made some notes. It was Justice Harding who started with this, and I think that type of questioning shows the influence that the United States Supreme Court opinion of earlier this week has had on these 7 justices, that they are now prepared to show such deference to the legislature that they would deny themselves the jurisdiction to hear an appeal. I think that Barry Richard gave the correct answer because he showed due deference to the court that you always have the right to hear an appeal. It is so obvious, so apparent, so universally accepted that the legislature doesn't have to lay it out. But the underlying part of Paul's observation I agree with, and that is namely, A, the Florida Supreme Court is looking for finality.
Andrew, I'll tell you what, I'm going to cut you off. Barry Richard's now commenting.
And I was pleased with the argument. That's my statement, unless somebody has a question.
What's the next step for you?
Well, my next step is to go see Judge Clark, who's having closing arguments at 1 o'clock on her case.
How do you feel that case is going?
I don't think that there was any evidence presented that would justify a ruling for the plaintiffs yesterday.
Thanks very much, everyone. Were there any questions you got that concerned you?
Okay, and there you see the Bush legal team having offered no more information than the Gore legal team did. They're hustling off, as Barry Richard mentioned, to Leon County Circuit Court, where there's going to be a hearing on absentee ballots in Seminole County before Judge Nikki Clark. Barry Richard has to make closing arguments at 1 p.m. Eastern Time. And so that's where he's headed. Andrew Napolitano, I cut you off when you're busy talking about the deference that the Supreme Court seems eager and willing now to pay to the Florida legislature based on the Supreme Court decision earlier this week.
And to that extent, I agree with Paul Rothstein. I think they are now more than eager, A, to bring an end to this, and B, to show deference to the Supreme Court of the United States, and C, to do it in such a way that they escape with their excellent reputation intact. And I think it would have been a little silly for Barry Richard to say, hey, you guys don't even have appellate jurisdiction anymore because the phrase Supreme Court is not in the statute. But it does show how sensitive they're getting to what the U.S. Supreme Court has done.
Let me ask Paul Rothstein about that, because let us suppose this court finds for Al Gore and says, that the recounts are legitimate. Could the Bush team then appeal to the U.S. Supreme Court and say, wait a minute, they didn't pay attention to your original ruling, and could it not also be the case that the Supreme Court could, on a very fast track by next Tuesday, December 12th, then reverse once again?
Absolutely. I think that is a possibility. I think there is a way Mr. Richards could have paid deference to the dignity of this Florida Supreme Court and still said you don't have jurisdiction by grabbing on to the notion that the court handed him, that the right to appeal to the Florida Supreme Court is only in the Constitution of Florida. It is not in the legislation, and therefore he could have said, at least, Your Honor, there is a question as to whether you have jurisdiction. I think what's going to come out of this court, the Florida Supreme Court, is a mixed decision with some dissents. I think it will be basically against Gore on a variety of different grounds that resonated with different justices, each one having a different grounds. But I think the basic problems in the Boyes-Gore proposition was a time problem. There's not enough time to do what they want. A selectivity problem that it counts particular Gore counties differently than other counties, and a problem that they have essentially made the proceedings thus far and the canvassing boards useless. They're giving no effect to what the canvassing boards has done, and yet the statute says, it puts that procedure in there for some reason, the canvassing board procedure.
Andrew Napolitano, there was a bit of intensely practical questioning, especially by Chief Justice Wells, where he said, look, we're not going to make it by the 12th. You can't do a full recount. The real question is, based on the law, is it necessary, if they want to do a recount of Miami-Dade County, to count all the ballots, nearly 700,000 of them, or can they restrict it to 9,000 so-called undervotes?
Well, the legislature has said you have to count all the votes, and a recent opinion by this very Supreme Court, which is articulated nicely in the Republicans' brief and addressed as well in the Democrats' brief, says they have to count all of them, and that's what Judge Saul's ruled. So I think that the last statement made by the Chief Justice was pretty much, we can't give you what you want, David Boies, even if we wanted to, because there just isn't time to do it. Let me also say, I agree with Paul as to what the likely outcome of this will be. I would add one point. This is an appeal of a trial, and in that trial, the Democrats offered zero evidence that any votes were not counted. They just put two experts on, neither of whom was from Florida, neither of whom was involved in the election. And so there's ample evidence for Judge Sauls to have ruled as he did.
Okay, Brett Baer was in the courtroom while the arguments were proceeding. He's now outside in front of our cameras, and he can give us a flavor of what was going on. Brett?
Well, Tony, it appeared that the justices were far more divided than the first oral arguments we saw in front of these 7 justices. As you mentioned, Chief Justice Charles Wells very concerned with the U.S. Supreme Court remand and wondering if they would be stepping on the toes, essentially, of the state legislature. Also, Justice Leander Shaw brought up the fact that Judge Sauls said there was no credible evidence, and he was concerned about getting into this based on the fact that this was dealt with on facts by Judge Sauls. But 2 other justices, Justice Peggy Quince and Justice Barbara Pariente, seem to suggest that they believe that this election has been placed in doubt.
Are you entitled to a recount? And what did you demonstrate to the trial court that you contend to us demonstrates that entitlement?
We demonstrated first that there were a large number of ballots that were not counted by the punch card machines. We demonstrated second that when you have a very close election, you have to have a manual review of those ballots in order to have an accurate tally. That was not just our expert, that was their expert, Mr. Amon, who testified that you had to have a manual recount in a close election.
They have submitted that there are like 9,000 or whatever the number is, challenge ballots, and that there is a difference in the outcome of the election that is presently measured only in hundreds of ballots. So at least that preliminary step of saying the number of challenge ballots would place in question the outcome of the election, that they've at least met that preliminary step.
No, sir, I emphatically disagree with that.
All right, and do you disagree on the basis of applying that standard, or do you disagree on the basis that they haven't met that standard?
They have not met their burden of proof, and the reason is the only thing they did was put two witnesses on the stand to say that they were speculating that vote-o-matic machines are inherently unreliable. And so, in essence, what Mr. Boies is saying to this court is any time there's a vote-o-matic machine in a close election and somebody says count all the ballots, you must do so.
That was Justice Harry Anstead at the end with that line of questioning. As we've said all along, you can't determine by the questions how these justices are leaning, but it appeared in court that they were divided, at least more so than that first oral argument. Also, a little note here just to show how Barry Richard is tied between courtrooms. Right before this session started, he walked back to his wife and wished her a happy anniversary. And she said, oh, you remembered. You were in court all day. I didn't know you'd remember.
Okay, Brett, stand by. Paul Rothstein has a comment he wants to make based on something you were just talking about.
By the way, that's a nice guy, Barry Richard, to do that. There's been a lot of talk in that last segment we just saw, and also in some of our discussion, that all the Boies Gore team, that they didn't have any evidence that there were any votes that hadn't been counted. I think that's not quite right. I think they did have a little bit of evidence. There had been some hand recounting of some ballots in some of the counties or precincts that had been rejected by the machine, and they did surface some votes for Mr. Gore. So I think that's a suggestion that there must be some buried votes for Mr. Gore and Mr. Bush, too, in some of these ballots that the machines rejected. So I think that it does give you a little bit of a reason to think maybe there were some more votes that should have been counted, but it doesn't tell you if you did it on a statewide basis, which is the proper way, I think. It doesn't tell you whether there would be more for Mr. Gore or Mr. Bush. Probably they would be in equal proportion to the votes they already got, so it wouldn't change the election.
Okay, Brett, let me ask you a question. You were inside. You've observed these proceedings before. Tell us about the body language of both sides. Is there any difference between the body language of the Bush and Gore teams in this hearing and the earlier hearing before the Florida Supreme Court?
A little bit, Tony. You know, when you get the specific questions and the interruptions, you have some wincing on either side sometimes when the line of questioning is going the other way. But, you know, just better to talk about that is George Terwilliger. He is an attorney for the Bush campaign, joining us here. We were talking about the different signs that you see from either side. How did you think this goes?
I thought it went well for us. The questions that the justices were asking, which, as you noted a moment ago, are not an indication necessarily of where they will come out. But the questions that they were asking were about the issues that we argued in the trial court and in our brief. Can you grant the relief that the Gore campaign is asking here without doing it on the basis of a statewide standard? Can you grant the relief they're asking for without counting all the ballots, at least in these counties, if not beyond? So I think all in all the argument was positive.
You had Justice Periente, Justice Quince, and Justice Anstead all really hammering home about these undervotes and whether there are indeed enough votes in there to change the election. Did that indicate to you that they were leaning that way?
I think it's tough to read those kinds of tea leaves. I think they were exploring possibilities, but the more important question was the first question that was asked by Chief Justice Wells, and that is how broad is our authority to review and grant relief of this matter, given that it is an election for presidential electors and what the Supreme Court has already said concerning the restrictions on their authority in the U.S. Constitution and federal law. I think that question will control the outcome here.
What happens happens, if these 7 justices come in and rule in favor of the Gore side, do you appeal this to the U.S. Supreme Court?
We'll make decisions about what we do next when we see what happens next.
Okay. All right. Tony, I understand you have a question for
Yes,
George.
I do, Brett. Very quickly, Florida legislation, the Florida statutes, do not automatically grant the Florida Supreme Court the right to review Judge Sanders Saul's opinion. Is it George Terwilliger's opinion that, in fact, the Supreme Court does not have significant appellate powers in this case, that it doesn't have the power to review Judge Saul's finding?
Tony's asking whether the Supreme Court really has the power to review Judge Saul's finding, to step into this appellate process. He's citing some Florida statutes that perhaps suggest otherwise.
Well, I think the question that Chief Justice Wells asked, in which Tony's referring, was whether they have the power to perform appellate review here, since their appellate review authority comes from the Florida Constitution and not from the election code itself. And the Supreme Court has raised a question as to whether or not powers that come from the Florida Constitution can be exercised in regard to a presidential election. And I think the answer to that is that it's probably unclear at this point. I think all the parties in the courtroom treated the answer to that as affirmative and went on and argued the merits of the appeal.
Okay. George Terwilliger, thanks so much for being with us.
Thank you.
Again, so that's one perspective, one side here, Tony, and we'll, of course, bring you more as they come by.
Okay, Brett, thanks so much, folks. We're going to take a break. We'll be back with more of today's hearing before the Florida Supreme Court. We'll also keep you apprised of what's going on in some of the county circuit courts as well. Stay right here.
From New York for her marriage to the Prince of Monaco, the beautiful Philadelphia motion picture star Grace Kelly is interviewed aboard the liner Constitution, producing a mob scene that must remind her of the movies.
Well, Jinx, as I said before, just getting married is a very big step for any girl, and of course, I have a great many feelings about that, and it's a very exciting thing, and I'm very, very happy. Of course, I'm a little sad to be leaving home, but I hope to be back quite often.
And almost all the Kellys are going except one, Lizanne. She can't make it.
My sister's expecting a baby the first part of May, and she's just heartbroken that she won't be able to
would
be
you
with
repeat
us.
for us the status of your citizenship now that you're going to Monaco?
Oh, when I'm married, I will have a dual citizenship. On marrying His Highness, I will become monegasque, but I will also retain my American citizenship.
Does that go for your children, too?
I don't know about that yet.
Kelly, how's your French?
Comme ci, comme ça.
Loveliest of the lovely, as seen here in the role of a non-competitor, she leads an Atlantic City beauty pageant. Marilyn Monroe is mourned by the world, particularly by a host of veterans of the Korean War. One of her many generous givings of her presence to beguile with her charms and divert with her humor fellow citizens, many of whom had a rendezvous with death. A symbol of all the girls back home, Marilyn's talent did not go unrecognized.
Here's a quick update on what's been going on the legal front today in Florida. Starting at 8 a.m. Eastern Time in Leon County Circuit Court, Judge Terry Lewis began hearing arguments that Republicans improperly helped fill out applications for absentee ballots in Martin County, Florida. That hearing is going to continue until about 12 o'clock Eastern Time. Then everybody's going to scram out of that courtroom, and they're going to give lawyers and everybody else an hour to come back in, where Judge Nikki Clark will be hearing a similar case involving Seminole County, Florida. Now, Barry Richard, who has just completed arguments for George W. Bush before the Florida Supreme Court, will be making arguments before Judge Nikki Clark in that Leon County courtroom starting at about 1 o'clock. So we have the Martin County case that is still going on. It will continue until noon Eastern Time. In addition, we have just heard oral arguments before the Florida Supreme Court. The Gore legal team wants to challenge a lower court opinion that Al Gore does not have any right to manual recounts, principally in Miami-Dade County. In addition, Judge Nikki Clark will begin holding her hearings at 1 p.m. Eastern Time on the absentee ballot situation in Seminole County. Now, our Steve Brown is standing by down in Tallahassee, and he can give us a little sense of what's been going on, specifically with Judge Terry Lewis and the Martin County case. Steve?
It is very confusing, and I've figured out that the only two things that they're missing out of that courthouse right now, Tony, are cots for the lawyers to sleep on in between arguments and perhaps a revolving door so people can get in and out a little bit faster in there. But basically what has been going on there is they have been talking about, a good chunk of the time today anyway, have been talking about relief. The Gore Campaign lawyers have been talking about, well, if the judge should find in our favor, what kind of relief can we receive? So to help them calculate exactly that, they brought in a Harvard statistician. The problem is that the applications in which there is question about who filled out the information and were they complete or incomplete and are they valid or not valid are now separate from the ballots that have been cast. So now they have to guesstimate how many votes they would deduct, or ask how many votes they could deduct from this total in order to get a certified election. So they've been going back and forth on that. Now, easily the star thus far today in that particular court proceeding has been Peggy Robbins, the supervisor of elections in Martin County. And she did acknowledge that some of those ballot applications missing some key information were taken from her offices, the missing information put on the applications and then resubmitted. She was questioned both by the Gore attorneys and then by the Bush attorneys, and then Judge Lewis himself got into the act, asking questions of his own.
For the testimony, that's one and the same thing. We did process. Your office is required, is it not, whenever somebody makes a request, to make a record of that request?
Yes.
Okay.
It did seem that Ms. Robbins was a little bit thrown, but the questioning went on for a couple of minutes with the judge asking several questions. Of course, the judge in this case is the jury. This is a non-jury trial, so he wanted to get some issues squared away and make sure that if documents need to be reviewed in order for him to be able to make a decision in this case, that they were accessible and they were handy to him when this all wraps up. As you point out, Tony, about noon, a little less than a half an hour from now, they got to start clearing that courtroom because they got to get ready at 1 o'clock for the Seminole County case. Judge Nikki Clark coming back into chambers to hear closing arguments in that particular case. It's going to be a very busy afternoon in that courtroom inside the Leon County Courthouse. Reporting live from Tallahassee, Steve Brown. Tony, back to you.
Okay, Steve, let me ask you, in the Martin County case, before Judge Lewis, we're all having trouble with this Lewis and Martin thing, but Judge Lewis, have we yet gotten to the point where the Bush team is bringing up its witnesses, or are we still hearing from the Gore team's witnesses?
To my knowledge, we may just have started with the Bush witnesses, but there was some concern by the Bush attorneys, the Bush legal team, about whether or not they would be able to quickly get to their witnesses. We don't know that they have a particularly long list of witnesses. Their stance is that the Florida law is clearly in their favor on this particular case, and that you can't toss out actual real votes based on some inappropriate or perhaps rule violations in regards to the applications in which the people who did the voting were not a party to it.
Steve, does that mean that at noon they're going to quit hearing from witnesses, they're going to adjourn, and they're going to come back later to hear final arguments? Or is it possible that they're still going to be grilling witnesses after Judge Clark adjourns today?
It sounds like it is possible, although the situation is not clear to us right now whether or not there will be a lengthy amount of time afterwards or any amount of time afterwards in order to bring the teams back in and still hear witnesses and closing arguments and wrap things up by at least the daylight hours of today anyway.
Okay, Steve Brown, thank you for the update. We are going to take a break. When we return, we're going to hear from both the Bush and Gore camps. So stay right here.
We've made most of these arguments.
Yeah, I mean, you both did a good job of putting your trial briefs in your
presidential election. Joining us once again is constitutional scholar, Emory Law Professor Robert Shapiro. We talked to you before the arguments. We have you back now. You said that you heard a lot of discussion, a lot of questions about a time factor. Justice is asking, do you even have enough time to fix this?
That's right. Certainly in the rebuttal period, I think the Chief Justice made that very clear to David Boies. Can we really give you the remedy that you seek? And I think that would be alarming. In some ways, actually, what might have been alarming for David Boies during his initial presentation was that there was not that much discussion of the remedy phase, which might lead him to believe the court won't need to get to the remedy. But it was clear that time, the December 12th deadline, very much on the mind of the court.
But that has to be very frustrating for attorneys like David Boies and the Democrats, saying, well, we might want to fix it, you might be right, but there might not be time.
Absolutely, and you could see that with David Boies saying, we've been trying to get these ballots counted for a month now. We just need a few more days. But December 12th seems to be the deadline that everybody's agreed on, and that's a problem for David Boies.
And then there's the issue of why these lawyers were before this Supreme Court once again, because the U.S. Supreme Court had kicked it back to the Florida Supreme Court. Did you get a sense that the justices sitting up there had a sense that the U.S. Supreme Court was looking over their shoulder today?
Well, I think so. That is, the last time the Florida Supreme Court dealt with a slightly different issue of the certification deadlines that ended up being vacated by the United States Supreme Court. And you could see a concern by the justices. In fact, the very first question, I think before David Boies got to say anything,
even
was
his whole name.
That was
I don't think
exactly was about the significance of this prior Supreme Court ruling. So I think the potential federal issues and the potential review by the United States Supreme Court later was very much on the mind of the Florida court.
Robert Shapiro from Emory Law School, thanks for stopping by. Really good to have your insight here this morning. Right from here in Atlanta, we go right up to Washington, D.C. Our CNN senior political analyst, Bill Schneider, standing by. Bill, I think we need to pull your famous arrows, ups and downs out of the drawer for this use right now. Who in which camp is getting an up arrow right now and who's getting a down arrow?
Well, it's kind of hard to tell. I mean, you've got so many actors playing in this thing. What the Gore campaign is waiting for is for that Florida Supreme Court to say three little words. Not "I love you," count the votes. Once the court says count
which would
the
be
votes,
like "I love you."
Well, that would be the equivalent of that. If they say count the votes, they unlock the door on that depository, they sit down, they start counting the ballots. The December 12th date, they're supposed to have it counted by then in order for the electors to enjoy protection from immunity from a challenge by Congress. But you know what? If they're counting those votes, it's going to be kind of hard to stop them and say, sorry, time's up.
Well, you might have time up on, you might have the clock ticking on one end, but as we've seen from the Florida Legislature, they've said if you're not ready by December 12th, we just might take over from here.
Yeah, if the court says count the votes, and they start to count the votes, even if they don't finish, then you could get into a very sticky situation in which the legislature names the Bush slate of electors, as is their right to do under law, and the votes are being counted, and that could end up with a Gore slate of electors being chosen, and then the whole thing will shift to Congress here in Washington on January 5th, which will have to make a decision which slate of electors to accept, and if you have a Republican House and a Democratic Senate, and they can't agree, then the slate of electors under the law that's accepted is the one that Governor Jeb Bush signs. So therefore, he would become a player. Everything gets more complicated if those three little words are spoken, count the votes.
And we'll have to just wait and see what the Florida Supreme Court has to say this time around. Bill Schneider in Washington, D.C., thank you very much. Stephen.
From the Florida State Supreme Court now to the Court of Public Opinion. Jeff Flock has been gauging that for us in Chicago in the middle of a snowstorm there. And let's turn to him for some sense of how that's going now. Jeff, good morning again.
Good morning again to you, Stephen. Indeed, we've been taking the public temperature for weeks now, and I'm trying to get a sense of it. It's very cold right now as a part of the temperature, but we've got some disgust on the part of some people, yes?
Yes, very much so.
Sorry about that.
I'm tired of it. I'm ready for it to be over.
Okay. In what fashion?
Well, I would like to have a good decision, and I really don't know. I think our legislators are going to have to work this out. because we need some final answers. Let's not do this again another year.
And we got other people that are willing to let this process play out. Yes, sir?
Yes, I'd prefer to see it be carried out. Part of the arguments that were made before the Supreme Court is to allow the contest to start. And essentially that's what we're going through. Yet. No, that's essentially what we're going through. And if you had a chance to see the trials that are being carried out on C-SPAN, etc., where they're contesting some of these votes that were counted, we would be circumventing basically the laws of Florida if we allowed those votes to be counted. So, I mean, I think there are a lot of issues that need to be resolved before the legislature steps in. And we have until December 12th before this needs to be decided.
Do you think the clock is ticking now? Are you worried about how long it's taking?
I think it's taken too long right now. I think it should have been over with when the election took place. I don't know. I just feel that, we're going into Christmas now, and not having the president of the next 4 years is nuts, personally.
If it goes, you voted for George Bush, you told me. If it goes the other way, can you accept Al Gore as your president?
Yes.
And you voted, you tell me, for Al Gore. If it goes to Bush, can you accept him as your president?
Absolutely.
Final word. And you are a Bush voter as well?
Yes, I am. I voted for Bush, and I would go either way. I feel that either man would do a good job for our country.
Wonderful. Folks, appreciate it. Thank you so much for standing out in the snow with us. We'll let you get back to work and shopping. Real life, they say, needs to go on. That's the latest from Chicago. Back to you, folks.
Jeff, thank you.
Thank you very much. Once again, oral arguments wrapping up at the Florida Supreme Court. No word on when they will have a decision, but as soon as I do, you'll hear it here on CNN.
Also, there's still court action underway. The Martin and Seminole County absentee ballot applications case is still being discussed at this hour.
And we're monitoring those. We'll bring aspects of that for you live. Also, we are not excused from the table. We continue on doing Newsday today. We'll be back at the top of the hour.
See you then.
Great, the popular film star and famous home run hitter are off for Japan. The trans-Pacific flight that ends in a Tokyo welcome second only to those that the Japanese reserve for their emperor. Pure pandemonium reigns in Tokyo as Joe DiMaggio, the once great Yankee Clipper, extends the field of the Monroe Doctrine by bringing his beautiful star bride to the land of the cherry blossoms. Having demonstrated how to marry a millionaire in a comedy masterpiece of film, Marilyn shows she knows how to manage millions by taking her multitudinous reception in stride. There hasn't been anything like Marilyn and Joe in all of Japan's history, and the photogs make the most of it.
One of the greatest pennant runaways that baseball has ever known, New York's Yankees came surging back to the top to participate in their 12th World Series, while Brooklyn's Dowdy Dodgers won their first league flag in 21 years. Managers Joe McCarthy and Leo DeRocha were the masterminds. Joe DiMaggio was the Athlete of the Year. Dolph Camilli copped a Player Award. Reeser was the Rookie. What the Hot Stove League remembers is that fearful moment in the 4th series game when Mickey Owen drops the ball. It leads to misery for Brooklyn's fans as Keller's double off the right field screen brings Henrik and DiMaggio in, and the Yankees take a stranglehold on the series at 3-1. Then the 5th and final, and the Yankees have done it in 4 out of 5.
The Bush and Gore legal teams went before Florida's Supreme Court again this morning. At issue now, whether to recount thousands of ballots. We're going to hit some highlights of a highly charged session and see how some experts think it'll all end up. So what are the candidates themselves doing while all this legal wrangling is still going on? We're going to check in with both camps, and we'll see how Wall Street is reacting to the crucial events that are unfolding in Florida and throughout the nation today. Our Karen Gibbs will drop by for a look at the marketplace and your money. Hi, everybody. I'm David Asman. Our Team Fox coverage kept kicking off with our own Brett Baer, who joins us live from Tallahassee. Hi, Brett.
Hi, David. Being in the courtroom, you saw a much different set of 7 justices than you did this time when the oral arguments were being made in that first case before this court. The justices seemed a lot more divided as to whether to grant the Gore team this appeal of Judge Saul's ruling. Of course, the Gore campaign wants some 14,000 contested ballots recounted because they feel that there are enough votes inside there to give Vice President Gore the win. Now, Chief Justice Charles Wells was very concerned that they would be stepping on the toes of the state legislature. Meantime, Justice Peggy Quince, Barbara Perriente, and Justice Harry Anstead were saying that perhaps, indeed, there is some doubt about this election in those uncounted or unmanually counted ballots from Miami-Dade County and Palm Beach. So the bottom line, though, Justice Wells, Chief Justice Wells, at the very end said, okay, say we give this remedy. Say that we say that indeed Vice President Gore or the Gore campaign should have these ballots counted. Could we just run out of time?
All of these contests have to be concluded, as you told me before, when we were here before, by December the 12th. And we don't have a remedy here that can do that by December the 12th.
Your Honor, I think you do have a remedy that can do that by December 12th. I think first, almost all of the issues in terms of number of issues, although not in terms of number of the ballots, are now legal issues before the court.
That was David Boies, the Gore campaign attorney, who was arguing that they do indeed have the time. The Bush side arguing that these recounts can't go forward, basically, first of all, because there's nothing in Florida statute that says they can go forward, and secondly, it would be unfair to all 64 other counties that are not involved here. Basically, the same argument that they made before Judge Sanders Saul's. So, again, we'll have to wait and see, and it's tough to say by the exact questions from the justices, but it seemed that this court was far more divided than they were in this first ruling when they sided for the Gore campaign the first time around. David?
Certainly did seem that way. Brett, about the time question, of course, December 12th is looming large. It's not that far away. They have 1 million ballots up there in Tallahassee. Is there any way to count all of those ballots in time for that December 12th, or only a part of them?
No, the Gore campaign concedes that they couldn't get 1 million ballots counted in time, but they just want those 14,000 ballots counted. And really, even if it came down to just the 9,000 from Miami-Dade, they believe at the rate that Palm Beach was going, 300 an hour at the end of their counting, that this Supreme Court, the Florida Supreme Court, could get it done with enough clerks and court administrators.
Of course, Sanders Saul says just to count some of them would be unfair and, in fact, unconstitutional. And that's, I guess, what the debate is about.
What standard do you use to count all of those? That's the biggest question.
Whose dimpled standard do you use? All right, Brett Baer from Tallahassee. Thanks, Brett. And for Florida's Martin County, a hearing now about how absentee ballot requests were handled. Al Gore supporters are trying to get thousands of those ballots tossed out. Our own Steve Brown is in Tallahassee, keeping an eye on that trial. He joins us now live with the very latest. Hi, Steve.
Hi, David. Yes, so we're in the final minutes, actually, of this case. We are in closing arguments. This case moving along rapidly through the morning. Let's go to a live picture inside the Leon County Courthouse where Judge Terry Lewis is hearing this particular case. We understand that Darrell Bristow is making closing arguments to the judge in this case. They moved rapidly through their witnesses, reading some affidavits aloud, questioning some witnesses on statistics earlier today, and they've moved rapidly through this, and they are expected to wrap up. As a matter of fact, they have been ordered to wrap up by Judge Lewis by quarter after the noon hour East Coast time, so that they can begin deliberations and start clearing the decks so that some of these attorneys involved in the Seminole County case can get themselves ready, because that picks up at 1 o'clock, where closing arguments in that case are expected. In total, 25,000 absentee ballots. The Democrats here in Florida have asked for them to be tossed out, citing irregularities with the applications, missing ID numbers filled in, in by Republican operatives here. The question is whether or not that the threshold is strong enough to have those tossed out. Legal experts say it is not likely, but there is going to be a wrap-up of both of these cases in terms of courtroom presentations by this afternoon. David?
All right, Steve Brown, we'll keep an eye on it. Thanks very much, Steve Brown from Tallahassee. And still ahead, a crucial day for Al Gore. If he loses his appeal, will he fight on, and where does he go from there? We're going to take a look at the courtside action today with an expert who's had a view from the bench itself, a former Florida Supreme Court justice, coming next right here on Fox. Of business in Florida's state capital. This is also in Tallahassee, but it concerns a case in Martin County, Florida, a case where the Gore folks, or folks who supported Al Gore, suggest that there were mistakes made on applications to ballots. Summaries being made right now before Judge Terry Lewis. You may remember his particular ruling, which went against Gore, was overturned by the Florida Supreme Court. Now he is back in a courtroom, a very busy one, because they have to vacate in just a few minutes. And then at about 1 p.m. Eastern Time, about a half hour from now, Judge Nikki Clark will be seated in the judge's chair to listen to the Seminole County case, a similar case. Let's listen in a bit of closing arguments here.
Legislative staffer wrote. But when you read it, you see it applies to the ballot process. It makes no reference whatsoever about the application process and to what extent that's directory or mandatory, even if it had any weight in the first place. But here is the proof that, in fact, this is to be interpreted in a mandatory way, is that in 9814, the Secretary of State Division of Elections before this election so interpreted it. In the letter that's in evidence from Clay Roberts to the secretaries to the various supervisors of elections, he said completed forms only. That's his word. You get properly completed forms. And the supervisor of elections in this very case treated it as mandatory. She would not process these applications unless it strictly complied. That is the interpretation we're dealing with. That is what happened in this case. They tried to abrogate that through intentional misconduct. You asked, second point, you asked the question, Your Honor, about 101.162, and is there anything in it that matters, or they say that they seem to think the whole thing can just be ignored. Clearly, that's not the legislative intent. Now, if there was some clerical error, perhaps, by the supervisor of elections and no intentional misconduct, this could be a different situation. But that's not the case. We have, as we've argued all along, various elements of intentional misconduct by violation of all these various statutes. And on this point, we cannot emphasize heavily enough that this was done in a partisan way. Given to Republicans, the stipulation is clear on its face, paragraphs 41 and 42. Democrats did not receive the opportunity to correct their ballots.
And that is the summary of the argument being made by the Democratic side in a Leon County courtroom, again, before Judge Terry Lewis, this concerning Martin County. And in just about a half hour, the same courtroom will hear arguments about a case, similar cases in a different county, Seminole County, that before a different judge, Nikki Clark. And we will be covering bits of that as well live. We're dipping into final arguments now, which is what you just saw. Well, while all these legal battles play out in Florida, the Gore camp quietly working on its possible transition team out of the public eye. Our Steve Centani has been keeping tabs on the vice president. He joins us now live from Washington. Hi, Steve.
Well, hi, David. A fairly quiet day for the Gore family. They stayed at their official residence at the Naval Observatory here in Washington and watched the Supreme Court oral arguments from Florida on TV. The vice president, along with Tipper and with the vice presidential nominee, Joe Lieberman, sitting at home quietly without aides, just a family gathering along with Joe Lieberman to watch that on TV. Now, they had sent Bill Daley, the campaign chairman, down to Florida to watch the arguments in an official capacity. He was there, and after the hour-plus arguments were over down in Tallahassee, Bill Daley came out and talked to reporters briefly, and here's what he had to say.
The entire proceeding has been based on one premise, that every vote should count.
We look forward to the decision of the court. We respect them. Obviously, this was those who watched it were most impressed by the presentations and also, obviously, once again, by the questions and by the statements of the justices. So we thank them for the seriousness in which all are approaching this issue. And again, we, on behalf of Al Gore and Joe Lieberman, thank our legal team for the tremendous presentation.
Now, Daley didn't exactly characterize how he thought the arguments went, but there were a few justices on the Supreme Court panel down there who thought that a hand recount might be possible. They were asking questions like, what kind of a deadline do we have, and do you think this is doable? But they seemed inclined to order one. But by the same token, there were other justices who were asking whether or not they even had jurisdiction to intervene in this case at all, or whether or not ordering a recount would amount to an illegal change in the law, which, as you know, the U.S. Supreme Court talked about in its ruling on Monday. So they were very careful about all of that. For the Vice President, no official schedule today. He's going out to lunch with Joe Lieberman and Tipper Gore at a place here in Washington. After that, he does not have anything else on his schedule. David?
Okay, Steve Centani from Washington. Thanks very much. Well, Mike Emanuel's been keeping tabs in the Bush camp. He joins us now live from Austin with the very latest on that camp. Mike?
Well, hi, David. The Bush camp keeping close tabs on all the legal matters in Florida. No official comment from here in Austin, but they do sound pleased by some of the questions coming from the Supreme Court justices. Governor George W. Bush went to his office at the state capitol this morning. He didn't say anything to reporters, just smiled and waved. Bush is working on state business, has been meeting with prominent Texas Democrats the last couple of days, and meeting with his chief of staff, Andy Card, today. George W. Bush also received another security briefing from the CIA earlier this morning. At this point, there are no formal plans for any comment coming from Austin or from the Bush transition headquarters in McLean, Virginia. We can tell you Dick Cheney has been back in Texas. He had a retirement dinner thrown by his former company, Halliburton, last night. A very private matter. He is flying back to the transition headquarters in Northern Virginia today and will be there later this afternoon. At the transition headquarters, they've been sorting through some 15,000 emails and job applications. On the Bush-Cheney transition website, they put up the opportunity to apply for White House jobs, for administration jobs, and apparently they've been getting a lot of applications for work if indeed there is a Bush administration. But again, no official comment coming from Austin at this point. We know the governor has tended to refer all legal questions to James Baker, who's been observing all the legal wranglings in the state of Florida. And at this point, any immediate reaction, we are understanding, will come from Tallahassee. David, back to you.
All right, Mike Emanuel, thanks very much from Austin. We should mention, by the way, Judge Terry Lewis down in Tallahassee concerning that Martin County case of absentee ballots has just said he should have a decision on that case in Martin County tomorrow at around noontime. Of course, we will be covering that here live. And still ahead, so how are your 401ks doing today? Will your nest eggs recover from the election blahs? We've got a live report coming up on Fox.
Greg Wood, at the ripe old age of 39, finally tossed off the jinx that had dogged his trail and garnered that most coveted of all golf awards when he journeyed to Fort Worth, Texas, and despite a back ailment, toured the course in a 4-round total of 284 to win the National Open crown by a 3-stroke margin. The hoodoo shaken off for good. To Victor Gezi went the PGA Championship. To Bud Ward went the laurel as King of the Amateurs. On the distaff side, it was Betty Hicks Newell, a most important year for Betty for 2 important reasons. She won the Women's National Amateur and lost to Daniel Cupid. For it happened during 1941 that Betty Hicks became Mrs. Frank Newell. But here's the story twist. Mr. Newell is an amateur. Mrs. Newell will become a pro.
About 10:30 Sunday morning, I noticed a car parked on that hill, a man and woman in it. I never paid very much attention to it. They were fooling around the car like picnickers on an outing or hunters or something. And I went to haul rocks on that hill up there, and I was right at that orchard about 30 feet from the car. And I could see the clothing. The woman was dressed in a brown suit, and the man had on a blue shirt, khaki riding breeches.
And here's the notorious couple Farmer Schieffer says he saw. Bandit Barrow and his girl companion, Bonnie Parker. These photographs of the outlaws are being circulated by the police through the Southwest to aid in their identification. The girl always carries at least 2 guns. With Barrow, she's accused of another killing after that of the motorcycle cops that Schieffer describes.
One was standing on either side of the car. They reached down and got the gun and came up when they was about 10 feet away and says, boom, 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 boom. The automatic shotgun. The man on the steering wheel side shot the man in front. The one on the other side shot over the radiator and shot the man in the rear. The man in front fell flat on his back. The other man sort of spun around and fell with his face down the other way.
Money. Well, Tuesday was payday on Wall Street, but yesterday the market took more than it gave. So could you actually gain from some of the losses you've suffered in the market? Senior business correspondent Karen Gibbs is here to tell us if that's possible with today's Cashing In segment. Sounds good, Karen.
Hi, David. Yeah, it does sound good. We'll tell you about that in a moment. But right now, let me give you a real quick market update. The tone of the market, especially in the technology sector, has soured again today after mobile phone giant Motorola warned that sales and profits will fall shy of street estimates due to shortfalls in its semiconductor and personal computer segments. Motorola, the most actively traded on the New York Stock Exchange, losing 8% of its value to a new 52-week low before bouncing. Now, that warning weighed on other phone makers, Nokia and Ericsson. But the Dow is on either side of unchanged. In fact, right now it's off about 9.5 points, hurt by tech components Microsoft and IBM, but supported by those old economy safe haven stocks such as Procter & Gamble and Eastman Kodak. David, got to get back to you right now. David.
All right. The Democratic legal team for Al Gore is about to talk about today's hearings in the Florida Supreme Court. Let's take a look and listen in.
Good afternoon. We're here, and we're open for questions.
What happens if the state Supreme Court denies your appeal? What do you do? What does the Gore team do?
Well, we'll meet and discuss what direction we take.
Would that include filing appeals in the U.S.?
We'd have to consider that if any were available. We'd have to wait and see. We're not anticipating they're going to rule against us. We haven't really considered that at this point. Obviously, we had considered it in the lower court because we became aware toward the end what the result was going to be, and we were prepared to appeal.
Mr. Douglas, there's a sense of how things went today. There was some sense after oral arguments last time that things had gone well for your side. There seems to be a different impression this time because the court asked a lot of questions about the U.S. Supreme Court.
Well, I guess those perceptions are in the eye of the beholder, always. I think my own perception was that when we got to the merits, rather than the issue that was injected at the beginning of the proceeding, which neither side had briefed, that when we passed that hurdle, which I think Mr. Boyes answered very well, and I thought that he did a good job there. When we got to the merits, such as do you count the votes and this sort of thing, I thought the questions indicated a very knowledgeable, great knowledge of the issue by the courts, which we think when they do get the knowledge, obviously we think that brings them ultimately to our position. We hope so. We want to make it clear. We do not comment and nor do we speculate on what the court did or will do insofar as expressions they might make on the bench. You were there, you heard them, make your own choice. I'm beginning to sound like I've done this before, haven't I?
I'm confused by your answer to the first question about what happens when you reach the Supreme Court, because I thought if you lost the Supreme Court, it was over.
Well, you thought that, and we might have thought that, but it might not be. And I'm going to give you an answer that's ambiguous because until that unlikely event, we hope, occurs, we won't make a decision as lawyers to make a recommendation to our client. Obviously, what goes forward at any time is in the hands of our clients.
Are you indeed making the recommendations to your client, or is your client dictating to you what he wants?
That's enough questions like that. Obviously, we're lawyers. We make recommendations. The client makes final decisions. You'd want it that way, wouldn't you? All people are entitled to have lawyers that do that. There is one thing I do want to point out. before I turn this over. We were prepared today on the issue of what remedy might be available in the event they decide to recount these votes. The real issue that's facing the court is how can you get them counted in 4 or 5 days, assuming that you're able to count the way we have, the ones we've contested, which are the ballots in Dade and Palm Beach counties. That gives us those undervotes of about 10,000 in Dade and I think 3,300 that we want to reevaluate in Palm Beach. To do that requires some logistical planning and support. I call your attention to what the clerk of the circuit court in Leon County said in the press, which you probably all saw, that he, anticipating that this might occur because he was the clerk and it was pending in the court, had already made plans to do this rapidly. In fact, my recollection, and you'll have to check the article, it was in the Tallahassee Democrat, and I think it was either in Sundays and maybe last Wednesdays. He said he'd already arranged for 25 counting teams, complete with Republican and Democratic observers, and he had arranged a facility in the Leon County Library with public rooms that could be secured, and that the Sheriff's Department and other law enforcement would secure the whole place, and they could count around the clock, including his 188 employees that he could assign to the job. You must remember, and I'm sure you do, that in the case in Volusia County, the most recent contest case in the sheriff's race, where they counted not the whole large group of votes like this, but a small group which they were trying to throw out, the absentee ballots, the clerk was appointed by the court, the clerk of the court, to do that. We would hope and suggest, and we're going to suggest to the Supreme Court, which we did not get to do in this argument, that they consider this and perhaps make a direct assignment to the circuit court to begin counting with these people. That would answer the question, is how do you do it in 4 days? You can ask Mr. Lang, because I can't tell you, but he's familiar with this. I believe he'll tell you that with the setup that he's proposing, if they get the instructions as to how you count the votes, which would come from the court, you know, the Chads, Dimples, and those things, that they can begin and then have a determination in disputed ballots made by the court. I think that's important, and that's the one thing I wanted to add to whatever was said today. And I bet your question is going to be for David Boies. He's my favorite lawyer.
Special session your reaction to that, how to change your tactics?
My reaction to that is the statement that the lawyers are going to make on that, Mr. Boies made to the Supreme Court in response to the question. One of the things I think you all should recognize as lawyers, we have been very careful, and I think you will agree with this, not to inflame the rhetoric. When we get up and make statements about our case, we try our best not to make them personal, not to attack anybody, but to defend our legal position and explain it. We've been fairly successful at that. We get accused of not doing it, but I can assure you that we've done it, and for the most part, certainly Barry Richards has done that. And we're going to continue to try to act like lawyers and not like public relations people. We're going to give you the straight answers that we can, and Mr. Boies has just done a wonderful job with that. And besides, I went to get a haircut with him yesterday, and he had more photographers following him than I've had around me in 20 years.
Talk specifically to the special session tomorrow, how that would change your as lawyer.
Wouldn't change mine. I'll let Mr. Boies answer that.
I don't think that changes our legal position, and I don't think it changes what is in front of the Florida Supreme Court either.
Mr. Boies, do you think the judges seem critical of you and your team? There was no live witness who actually made a mistake on a ballot and undervoted, that there wasn't enough evidence for them to make a determination. I mean, in 2020 hindsight, do you think you should have had that live witness?
I don't think that they were critical of that. I think they were asking whether or not individual ballots had been examined, and I think when we pointed out that the ballots that we were contesting had been put in evidence, and that we'd asked the judge to examine them, and that indeed we didn't have really access to individual ballots because of the need to preserve the integrity of those ballots, and although we didn't say, we might have, that every time anybody had come any place near those ballots, the defendants had suggested that somehow the ballots were contaminated. I think they would understand that the way that you approach evidence in this particular case is by giving the court the ballots as evidence. They were admitted as evidence, and then having them reviewed. That's what was done in the Beckstrom case. That's what's traditionally been done. The burden is carried when you introduce the evidence. In other words, when you introduce evidence at a trial, you can wave it around in court, you can show it to people, or you can simply introduce it and let the judge decide. In this case, the evidence was introduced, but unfortunately the judge never looked at the evidence. Well, I think what the judge should have done is either directly or through a judicial officer. You remember in the Beckstrom case, it was assigned to the clerk of the court. Visually examined the ballots. That's what has traditionally been done in Florida. That was what was ordered to be done in the Pullen case from Illinois that now everybody is familiar with. So I think that the issue is to visually review the ballots and try to determine the intent of the voter. You'll recall that there are 9,000 ballots from Miami-Dade that have never been visually reviewed by anyone. So that those are ballots as to which there has been no discretion exercised.
Mr. Boyd, in previous statements, your legal team has said that no one is contemplating an appeal above the Florida Supreme Court. I'm sorry to ask this again, but has that changed?
No, I think that what we said from the beginning is our expectation is that this is a matter of Florida law. It's Florida election law, and the Florida Supreme Court is the final arbiter of that. That's the position that we've taken repeatedly in the Florida Supreme Court. It was the position we took in the United States Supreme Court.
There's other cases.
I'm sorry, what?
When you say here today that December 12th is the drop dead date?
The Florida Supreme Court sets the drop dead date, and they don't make arguments for me, and I don't make decisions for them. But I think that what they have consistently said is that they expect this to be over by December 12. We believe it can be over by December 12. And if they come out with an order that says we're not going to count any ballots, that's going to resolve it by December 12. If they come out with an order that says we are going to count the ballots and we're going to start now, we believe that can be resolved by December 12.
Following Monday night, if I recall correctly, you did stand in Leon County Patriot, and you said we all expected this. Both sides said that this would ultimately be decided in the Florida Supreme Court, and that will settle it. I think what we're all questioning here is we're not hearing it yet today.
You should be hearing it. You should be hearing it. You should be hearing that this is the Florida Supreme Court's decision. The Florida Supreme Court's going to make that decision. And I think that's going to be the end of it. Nobody can predict exactly what the Florida Supreme Court is going to say. For example, one of the things that is possible is the Florida Supreme Court could send it back for the ballots to be counted by the Leon County clerk or something like that. When we've said the Florida Supreme Court is going to settle it, what we've meant, and I think everybody's understood, that this is not going to be taken up to the United States Supreme Court. We're not meaning that the Florida Supreme Court did not have the option of utilizing the facilities of the circuit court to count ballots.
So you're saying if the Florida Supreme Court comes back and upholds Judge Saul's decision, that you will not appeal this to the U.S. Supreme Court?
That certainly is my recommendation. That is certainly what I've said before. Absolutely. I don't know of a basis for appealing that decision to the United States Supreme Court. If the Florida Supreme Court were to say something like, we'd like to do this, we think we ought to do this, but the United States Supreme Court, in their opinion, indicated we shouldn't do that, that might be a different situation. But as long as they decide this based on Florida election law, we've said from the beginning the Florida Supreme Court is the final arbiter of that, and we're going to accept that decision regardless of what that decision is.
It seems to me that those are issues like concern. This is a chasing court that sounded really reluctant today to even take this on. How worried are you about just that threshold issue?
I think that's an issue that lawyers try not to be concerned with. What we hope and expect is that the courts are going to insulate themselves from the political pressures that swirl around them, no matter how difficult that may be. This is a court that both in this litigation and in other litigation has shown itself to be tremendously dedicated to the rule of law. And we hope and expect that that dedication will continue. Nobody underestimates the extent of the political turmoil that is there. However, I think that courts, particularly Supreme Courts of the states and the Supreme Court of the United States, recognizes that its job is to make decisions based on the law, on the rule of law. That's what everybody looks to the courts for. And I would hope that everyone, once we get that decision, would respect that decision and respect it as the rule of law.
Mr. Boies, a complaint has been filed.
Go in your favor, whether or not it's this case or the one that you're not officially party to in Martin or Seminole counties, and the Florida State Legislature decides to certify a slate of electors for George W. Bush. What are your legal options?
In terms of legal options, obviously you have the legal option of challenging that in some forum. What we've said from the beginning is that we really hope that the Florida legislature is not going to take what would be really unprecedented action to try to take the election of the presidency of the United States away from the people and solve that in a partisan legislative chamber. On the other hand, we've also said that we're not going to speculate on what we might do if they took that step.
What's available to you? I'm not trying to understand. Obviously, we could challenge it. Tell us exactly what's possible.
Well, I really don't want to get into the legal options. I think you can get that from sort of lots of lawyers, election law lawyers and constitutional lawyers. And one of the problems with my speculating just as an abstract matter as to what legal options may be is that somebody is going to misunderstand that in terms of what our position might be. And what we've said from the beginning is that we're not going to assume that they're going to take what we think would be a very unfortunate act.
Would the Secretary of State have the discretion not to certify votes that may be or can be counted by this court? I mean, could that be another delay?
I don't think so. In this country and in this state, people do not have the option of disobeying court orders.
Mr. Boies, a complaint has been filed against you with the Florida Bar accusing you of unprofessional conduct concerning the use of what they term as an old affidavit. I'm wondering, are you going to stick with the original affidavit, and what is your response with that filing to the Florida Bar?
I think the Florida Bar will resolve that issue. I don't think there's any merit to that issue, and I think everybody associated with that has indicated that there is no merit to the issue. If it's the affidavit that I'm thinking about, it is an affidavit, the affiant of which has been deposed. And the affiant has said that his affidavit was true and correct, that he told us it was true and correct. The affiant also said that he was thereafter called by a reporter who read him selected but not all the pages of a transcript that caused him to question one portion of the affidavit. He then put in another affidavit, which he also believed at that time was correct, and that we presented that. Now, that affidavit, of course, was never submitted either initially or in a revised state to the Florida Supreme Court.
Can you talk about the Florida Supreme Court justices asking questions regarding statewide versus the select examination of ballots?
Sure. One of the arguments the defendants have made is that if you're going to have a recount in these three counties, you need to have a statewide recount. I think there are three basic answers to that. First, there's nothing in either the statute or in Florida precedent that would support that. Indeed, every case in which there has been a recount, the recount in the contest stage, that is where you're counting contested ballots, has been of a subset of the ballots. That is, no one has ever before suggested that you have to count all the ballots, and indeed the contrary has been what people have done. The second point is that everybody has offered Governor Bush's team the opportunity to have a statewide recount. Vice President Gore made that proposal 2 or 3 weeks ago. The Florida Supreme Court made that proposal more than 10 days ago, 10 or maybe even 2 weeks ago now. In each case, they've turned it down. The third point is that the statute in the election contest context provides that the court reviews the allegations of the complaint. The allegations of the complaint relate to these 3 counties. That's what the court is obligated to do. The basic argument, and I adverted to this in the Supreme Court, is that now Governor Bush's lawyers are arguing that Governor Bush has got to be protected from the mistakes that his lawyers made. His lawyers had a perfect opportunity to ask for a recount of any state they wanted, any county they wanted. They didn't do that. There's nothing in Florida law that says that a candidate represented, particularly a candidate represented by as many lawyers as Governor Bush is, needs to be protected from those lawyers' advice.
It has been said, and granted perhaps by pundits, but it's been said that the arguments that you just finished making before the 7 justices are the last best hope for Vice President Al Gore. He's going to keep alive his hopes for the presidency. Would you agree with that assessment?
I don't know if I'd want to characterize it that way, although we have said that this is our election contest. We haven't filed any other. We've also said that the Florida Supreme Court is going to be the final arbiter of these election contests. So I think that if the basic question is the decision that we're going to get from the Florida Supreme Court sometime soon a very important event, I think it is.
Why did the Vice President watch?
What?
Vice President watch?
Yeah, just, yeah, I don't know the answer to that. I would assume so, but I don't know the answer to that.
Yeah.
Let me just get back to this, okay?
Is it the end of the line?
I wouldn't want to say that it's the end of the line because there are things that the court could do, like, for example, directing that the count take place in another forum, like the circuit court clerk. The court might very well conduct the count itself. The Massachusetts Supreme Court in the Delahunt case did the count itself. The Supreme Court in the Pullen case, the Supreme Court of Illinois in the Pullen case, reviewed the count itself. Now, there were only 956 ballots at issue for the Massachusetts Supreme Court to review in Delahunt, and there are obviously more to be reviewed here. But one option is for the Florida Supreme Court, if it decides that a review of ballots is required, would be to do it under its own auspices. Another option would be to send it to the clerk of the circuit court, which is what was done in the Beckstrom case 2 years ago. In that case, the circuit court clerk did the ballot review, the visual ballot review.
Mr. Boyce, as long as this case remains pending and perhaps even after its decision, where does it leave the remand case? It's still before them.
I think it is still before them. That was separately briefed, and the court indicated it was not going to take oral argument on that case.
What is the significance of that once this case is decided?
In a sense, there isn't any significance because the certification phase, which is what that case was about, has now been superseded by the contest phase. And, for example, take Palm Beach. Palm Beach has certain ballots that we say have been identified as legal votes for Vice President Gore and Senator Lieberman. Those ballots have to be counted in the contest phase whether or not there was ever a manual recount in the certification or protest phase. So there is a sense in which I think that what's important is the issue that's now in front of the court, because the contest issue is going to resolve things. Having said that, it may very well be that the Florida Supreme Court, given the fact the United States Supreme Court has asked for clarification, will at some point provide that clarification.
Two more questions.
When you came before the court the last time, there were a number of logistical questions related to scheduling, contest players, and so forth. This time there were very few such logistical questions from the court. Why should we not interpret that to indicate that they are not doing a lot of consideration for logistics involved in recount?
Well, I think there are two reasons. First, because we've now had a trial, most of the issues that were relevant before have now been resolved. For example, there's now an undisputed record that the 215 net ballots that were counted in Palm Beach County should be included, that they're legal votes, and that the 168 ballots, net ballots for Vice President Gore and Senator Lieberman that were counted in Miami-Dade County should be included. And we've made the legal arguments with respect to Nassau County. So that all that remains are the issue, or is the issue, of the counting of the 3,300 ballots in Palm Beach and the 9,000 ballots in Miami-Dade. Since the issues as to the logistics of that have been addressed in the brief, and there were a couple of questions about how much time it would take, and we talked about 300 ballots an hour in terms of the canvassing board's progress. And since we think that it's clear that those ballots could be counted in a variety of different ways within the time available, I wouldn't read anything into that. You have to keep in mind that out of the millions of votes that were involved in this election, we're now down to only about 13,000 or 12,300 votes that are contested. There are a variety of ways that those could be counted. They could be counted under the auspices of the Supreme Court itself, as has happened in the Delahunt case and the Pullen case and other cases. They could be counted under the auspices of the clerk of the Leon County Circuit Court, which is what happened in the Beckstrom case.
We're at a point where Chief Justice Wells was very interested in scheduling logistical questions the first time we were here before him. And setting some of the other justices, this time he showed no interest in such questions.
No, I don't think that's right. I think he did ask a question about that. I think he asked a question about that today. I think he was interested in it before. I think both he and other justices made those inquiries today. There was a question right here.
We're at that number of 13,000 because those manual recounts were conducted in Palm Beach County, so on and so forth. If the U.S. Supreme Court somehow continues to vacate or permanently vacates the Supreme Court, the state Supreme Court's decision to extend that manual recount, doesn't that in fact then wipe out the validity of your argument about the dispute ballots?
No, because even if they weren't certified, they've still been identified as legal ballots. In other words, once you identify something as a legal ballot, for the contest phase, that has to be counted. You cannot reject legal ballots, regardless of whether they were identified in the certification phase or not. Just as an example, suppose that Miami-Dade, there'd never been an extension of the certification date. And Miami-Dade started its manual recount, didn't certify any results, finished its manual recount. It's now got a stack of ballots that it has identified as votes for Vice President Gore and Senator Lieberman. Under those circumstances, those ballots must be counted under Florida law in the contest phase, whether or not they were certified, whether or not they could have been certified, even whether or not they should have been certified.
Roberto?
The justices seem extremely mindful of the U.S. Supreme Court's admonitions about changing rules and endangering the safe harbor for Florida electors. Can you tell us how they could possibly fashion a remedy you want in terms of counting ballots under a standard that has never been applied up till now in this election?
Well, first of all, the premise of the question that it has never been applied up till now in this election, I think, is not right.
count ballots the way you're suggesting they should count them?
Well, for example, in the Beckstrom case, and that was an optical ballot case as opposed to a punch card ballot case, but I don't know of any principle of law that says you look for voter intent only in optical ballots. What they did was they took ballots that had been mismarked, defectively marked, in which the Supreme Court said not once but 3 times that the voters had not followed procedures, had defectively marked their ballots, and had marked their ballots in a way that could not be machine read. And what they said is that you've got to look at the voter's intent, and you've got to have a manual review of that. And in that case, they had a manual review of about 8,000 ballots by the clerk.
It's a matter of law, but the trial produced testimony very explicitly in the standards that were applied, for example, in Palm Beach, and specific standards applied in other counties. Your argument in Palm Beach is that those standards were defective and that other standards should be applied.
No, the argument as to whether or not Palm Beach applied the right standard or the wrong standard is really not critical at the contest phase. At the contest phase, we've got 3,300 ballots that Democratic observers looking at those ballots have concluded that they are votes for Vice President Gore and Senator Lieberman. And that's what a contest phase is. You take this information and you present it to a court, and the court tells you by looking at the ballots, are you right or are you wrong? This is not a situation in which you are reviewing what the Palm Beach court did. Any more than in Beckstrom, they were reviewing the Volusia County Canvassing Board. In either case, the Canvassing Board made a decision, but then when you go to the contest phase, the court or the court's clerk looks at those documents.
Can I have one other point and answer Roberto's question? First of all, you said no one counted the ballots in this case what we wanted. I disagree. In Miami-Dade and Broward, they applied a standard, they applied a consistent standard. It was the correct standard, and those ballots were counted. Miami-Dade abandoned the count, but they were counted under the correct standard. And in terms of your broader question about changing the rules in the middle of the game, we think the one change that was made in the rules were the changes made by Judge Sauls. We think Florida law is very consistent and has been consistent with the position we've been arguing in this case. The contested ballots are the ballots to be counted. They need to be counted under the established rules in the state, and that's part of what a contest is. So in terms of this argument about changing the rules in the middle of the game, the rules change, we think, came in Judge Saul's courtroom. That's the position we've put forward in our brief before the Florida Supreme Court, and the way to act consistently with the laws, the statute laws, and the case law in this state is to uphold our position, have these contested ballots be counted, and be counted under the established law of Florida. Thank you very much.
That was the Democratic team for Al Gore. David Boies, of course, Dexter Douglas, and Ron Klain, the political advisor for Al Gore. Interestingly enough, it seemed as though there may be a slight split between the thinking of David Boies and the thinking of Al Gore. David Boies saying that he doesn't know of any precedent for an appeal beyond the Florida Supreme Court if, in fact, the Gore team loses that. Al Gore hedged the other day, you might remember, when asked if he would take this thing beyond the Florida Supreme Court, setting the stage perhaps for a split between David Boies, the top legal man for Al Gore, and Al Gore himself. A lot of other things being said, but first we want to introduce our own Linda Vester to the team. Good to see you once again.
And good to be here for yet another very busy day, basically with court battles playing out in 3 different courtrooms. Shall we get started?
Well, at least one courtroom that's being seen double there. We have in the Leon County courtroom. Maybe we can take a picture of that. That's where earlier this morning they were talking about the Martin County case with Judge Terry Lewis. You may remember him from past cases. That same courtroom and that same chair, we'll see it in just a moment, Judge Nikki Clark, who will be hearing a similar case concerning Seminole County.
So with that, let's get right to our ground troops who are covering this story. Let's begin with the Florida Supreme Court. As we mentioned, the justices are deliberating as of this hour.
We kick off our live team coverage with our man Brett Baer. He is live outside the Florida Supreme Court in Tallahassee. Have you ever had more circles, more different shows going at the same time, Brett?
amazing. I mean, it's a legal circus, definitely. Different courtrooms battling at the same time. The Florida Supreme Court really being the end game here, even though you just heard David Boies say, quoting now, "I wouldn't want to say that it's the absolute end of the line." He said that at one point, suggesting that there may be some other remedies that the Florida Supreme Court could come up with here as far as counting the contested ballots. The key point the Gore camp wants to say is that the 14,000 contested ballots from Palm Beach and Miami-Dade need to be counted, and Judge Saul did not do that. So the Gore camp is asking these 7 justices to step in. Now, the justices seem split on this issue. I want you to listen to this exchange between Justice Harry Anstead and Bush campaign attorney Barry Richard.
And didn't that happen here with the trial court admitting the disputed ballots into evidence, but yet never looking at those documents?
Well, I think that the trial court admitted, theoretically admitted the ballots for purposes.
Theoretically, or did the trial court either did or did not admit the ballots into evidence? Did the trial court admit those into evidence?
My recollection is that the trial court did. There were thousands of ballots which were embargoed, and my recollection is that the trial court did. There was not a substantial dispute over whether or not the court could technically admit them into evidence.
Did the trial court examine those documents?
No, Your Honor, because I think there was no basis in law for the trial court to do that until after the plaintiff had carried its burden of proving that there was some necessity to do so.
Justice Anstead went on to say, isn't it highly unusual that evidence is admitted in a court procedure and never looked at? Also, Justice Barbara Pariente and Justice Peggy Quince also hammered Bush attorneys on the question whether there is a doubt in this election that there are still votes there that haven't been looked at that could possibly go to Vice President Gore. But Chief Justice Charles Wells also piped in, saying he's concerned that this court would step on the state legislature's ability and, under the law, legal duty to name the electors for the state of Florida. He also had a concern, if they side with Vice President Gore, about the timing.
All of these contests have to be concluded, as you told me before, when we were here before, by December the 12th. And we don't have a remedy here that can do that by December the 12th.
David Boies just said that he basically thought there was a time frame that all of those ballots could be counted if they put enough legal staff, court administrators, or even threw it back to the circuit court to do the counting. But a key point here is that Dexter Douglas was going to make a presentation in front of the 7 justices about a remedy, about doing a count, and they ran out of time. They never presented that case in front of the 7 justices. So there you have it. They are deliberating at this hour. It looked, at least from inside the courtroom, that they were far more split than they were earlier in the previous oral arguments the last time. David, Linda?
Brett, a question about this little delay, I guess, when things got running so long that Dexter Douglas didn't get a chance to give this presentation for the remedy that they wanted. Do they feel like, does the team feel like that they were substantially hurt by that because they just didn't get the time?
No, talking to them quickly right afterwards, they thought that that was just a matter of timing as far as their arguments go. They think the justices can make the decision on their own about a remedy and how everything would go, but they said they really would have liked to tell the justices what they thought about that entire scenario.
Got it. Brett Baer in Tallahassee, we'll check back in with you in just a little bit. Thanks.
Thanks, Brett. Well, one court, 2 judges dealing with 2 different counties, a lot of different suits going on, asking for thousands of absentee ballots to be thrown out. This is a Democratic charge. They charge Republican tampering with ballot applications.
We're talking about the Seminole County and the Martin County cases. Correspondent Steve Brown is also live from Tallahassee, just in a different place, and he's covering both of those court fights. Steve?
Good afternoon from good afternoon from Tallahassee. Yes, we're expecting any minute now for Judge Nikki Clark to take the bench and begin closing arguments in that case involving the Seminole County absentee ballots. If we could punch up and go inside the courtroom, take a peek and see if those have started. Again, that's about 10,000 disputed ballots. We see some folks milling around the bench, but 15,000 absentee ballots in dispute here. Closing arguments were scheduled for 1 o'clock. It's a little bit after that. Of course, some of those attorneys might be a little bit late because they were involved earlier this morning in closing arguments and wrapping up the trial involving Martin County. Now, they were hustled through both sides. The Bush and the Gore attorneys were hustled through their arguments, hustled through their presentations and their closing arguments. Here's a little brief snippet of what both sides had to say at the tail end of that case.
There's responsibility here, responsibility of the voters to get it right. And when they mess up, regardless of whether the Republicans aided and abetting in the messing up in the first place, we can't have a partisan come in and bail them out.
They are wanting you, in effect, to declare something that would change the results of an election of the United States by saying, we don't want you to look behind the fact that these people voted.
Now, Judge Terry Lewis says he hopes to have a verdict. He said he had something for them, meaning a verdict, hopefully by tomorrow, he believes. But before he reaches his final conclusion, he wants to confer with Judge Clark in the Seminole County case. So if you will, it will be Judges Lewis and Clark kind of taking a look at this pioneering world of legal court cases and legal disputes involving state elections that will ultimately decide the occupant of the Oval Office. Reporting live from Tallahassee, Steve Brown, Fox News. Back to you in New York.
All right, Steve Brown.
Very clever observation.
If you want to go even older than that, Martin and Lewis, remember that team?
Oh, yeah.
Judge Lewis dealing with Martin County. Anyway, straight ahead, you are looking at live pictures. Let's see if we can take a look inside the courtroom. That's the courtroom where all the action has been taking place this morning and this afternoon. They're going to be talking about what happened in Seminole County. We're going to be covering that live.
Just to get you back up to speed, the trial began yesterday for Seminole County. Could we see that one end today and move us one step closer to the final end? We're going to bring you the latest right after a break.
Who's who of show business in attendance, Ed Sullivan's Toast of the Town starts an hour-long TV salute to 20th Century Fox production chief Darrell F. Zanuck. An amazing tribute by the new air medium to a great leader of arrival entertainment. And here's Victor McLaughlin for the Signal Tribute, followed by the irrepressible Jimmy Gleason. Dick Powell brings the Missus, June Allison, with Edmund Gwen beamingly following. And here's Sonia Henney of film and ice rink fame. And Merle Oberon with Dr. Ross. Herbert Marshall's too. And this popular twosome, Clifton Webb and Tyrone Tower, who like many others in attendance need no introduction. Certainly a highlight of a brilliant career.
The Commander-in-Chief motors to West Point from his nearby country home and says, "You're in the Army now."
This is peculiarly your day. Nobody else's, not even the President's. It's your day. The greatest need of the world today is the assurance of permanent peace. An assurance based on mutual understanding and mutual regard. If you strive at all times to promote friendship, to discourage suspicion, to teach respect for the rights of others, and to decry aggression, to oppose intolerance with a spirit of mutual helpfulness, then indeed your services will be of full value to your government and a source of satisfaction to yourselves.
this hot off the wires. A federal appeals court has accepted the notion that Dick Cheney is a resident of Wyoming. As you might remember, had he been assumed to be a resident of Texas, that would have been a problem because the Constitution forbids the vice president and the president being from the same state. So a federal appeals court has cleared the way, at least in terms of residency concerns, for Dick Cheney to become the next vice president if, in fact, that election mess is all resolved. And now back to Linda with some more on today's legal battles. Linda?
All right, David, thanks. We want to go back now to the 3 different court battles that are going on in Florida today. Joining us now to put in lay terms where we stand in each case is former New Jersey Superior Court Judge and Fox News legal analyst, Judge Andrew Napolitano. Thank you for staying with us throughout this day, Judge. Let's start first and foremost with the Florida Supreme Court, which a lot of people are calling at this point Al Gore's last stand.
Right.
We may have a decision, you think, maybe by this evening.
Well, there's a couple of factors. I think if they're going to order a recount, they need to rule today so that the recount can commence.
Right.
On the other hand, if there's going to be a dissent, if it's going to be 5-2 or 4-3, and it appeared as though they were not unanimous this time, it's tough to author both the majority opinion and the dissent in a few hours' time because of the technicalities of having to go back and forth, and each side gets to see basically what the other's going to see. But I think we're going to get a ruling quickly, within 24 hours of the oral argument, either way.
Judge, if you would, just stand by with us. We want to go now down to Tallahassee, Florida. Correspondent Jim Engel has an exclusive interview with 2 of the key players here in the Gore legal team. David Boies to his right, and I believe Dexter Douglas to David Boies' right. Jim, over to you.
That is right, Linda. You're exactly right. David Boies and Dexter Douglas. Gentlemen, let me ask you, first, you were saying a few moments ago that even if the court were to order a recount at this point, that you do believe that it would be possible to complete it by next Tuesday, December 12th. How is that possible?
Well, remember, it's now narrowed down to about 12,500 ballots. And you've got a situation in which we know that canvassing boards, even with 3 people looking at the same ballot, one by one, we're able to do 250, 300 ballots or more an hour. Now, what that tells you is that you've got approximately 40 person hours of ballot review. Now, if that were done by one person working 10 hours a day, it would take 4 days. On the other hand, if it were done by 2 or 3 or 4 people, obviously you could get it done with just 4 people. You could get it done in one 10-hour day.
Now, if you're talking about 4 people, though, what standard will they employ in deciding what is a vote and what is not a vote? As you know better than anyone, there was a different standard in Palm Beach County from Broward County, a different standard in some counties from the beginning of the count to the end of the count. So what kind of faith would we have that 4 or 5 people would be employing the same standard, and which standard should it be?
Well, I think the basic standard is the standard that was applied, I think, in all counties at the end. It was implied by Broward County from the beginning. I think it was applied by Miami-Dade County during the period that they were actually counting. And I think it was applied by the people in Palm Beach at the end. The problem is not so much what happened at the end. The problem in Palm Beach is what happened at the beginning, which is why you have to go back and look now at some of the ballots that were not counted, that were put in the contest pile in the early stage when they were using a very restrictive standard.
You want a more liberal standard,
well,
like all of the contested votes.
Yeah, I think the standard really under Florida law is the intent of the voter. And you look at the ballot and you determine the intent of the voter. And remember, in most of these cases, it hasn't been that hard to do that. The Delahunt Supreme Court of Massachusetts did it.
Well, but in Delahunt, there was only one race there was only one race in the election, and it was in the middle of a thunderstorm. So anybody who went out, you presumed, intended to vote.
Well, but you had still a lot of undervotes that were non-votes even after all the review. In other words, they didn't count in Delahunt. They didn't count all the votes.
Right.
They didn't say we're going to find an intent to vote here. They didn't count some votes. They counted others based on the voters' intent.
Let me ask you one thing, then I'll get Mr. Douglas in here.
I was going to say on Broward.
Okay.
That vote has been accepted. We're not contesting that vote.
You're not contesting
Neither is anybody else.
The Republicans, as I understand it, have contested Broward and Pinellas.
Be a new one. If they
no, I believe they filed that last week.
I'm not sure it was a contest.
Yeah, I didn't see a contest filed.
What was it filed?
Declaratory judgment.
There was a affirmative defense, a motion to dismiss based on the affirmative defense filed in our case, which the court dismissed. but maybe they found something that didn't serve us.
That we don't know about. But
Now, we just have about 30 seconds left. You seem to say that the law could be interpreted that manual recounts have to be of all votes, but you argue that it's only contested votes. But you seem to be open to the fact that it could be, in fact, all votes.
Well, I think it's only the contested votes. I think that's what the law is.
Okay.
I think you'd have to change the law to make it anything else.
Okay, thanks very much. David Boyce, Dexter Douglas. We're going to break. Thank you very much, Linda.
Correspondent Jim Engel live in Tallahassee. Jim, thanks very much. We're going to go to a quick commercial break. Much more live coverage right after that.
Wearing a century-old lace veil over a filed taffeta and lace dress, Grace Kelly is escorted by her father to the altar of Monaco's St. Nicholas Cathedral. The moment for the ultimate church wedding that will complete a romance between the 26-year-old American and the 32-year-old ruler of the little principality. And Prince Rainier III has a smile for the vision he will make his princess. Bride's parents are intense spectators as the ceremony begins. Performed by the Most Reverend Gilles Barth, Bishop of Monaco, and consecrated according to the rites of the Roman Catholic Church with double marriage rings. At the low mass that follows, the happy pair make a solemn but handsome appearance. Partaking in a papal blessing with reverence and humility. At long last, all the arduous ceremonies are over, having gone through with their civil wedding a day earlier. Only a ride through the cheering Monegasques remains. Then they're off on Prince Rainier III's yacht for Pollença in the Balearic Islands.
New York, the Roosevelt Memorial Building at the Museum of Natural History to the memory of Theodore Roosevelt. And President Roosevelt dedicates it, honoring a preceding president and kinsman. It's like a family party. Colonel Ted, fourth from the left, son of the great T.R. The president speaks of the memorial building, its meanings, and its decorations.
They depict the construction of the Panama Canal, in which he was the dominating spirit. The Treaty of Portsmouth, which ended the Russo-Japanese War. The quest for scientific knowledge, which carried him into the African jungle. Symbolic figures of fauna and flora to tell generations to come of his interest in nature and in conservation. All these bear witness to his intense vitality and to his varied contributions to our national culture.
Lead members of Al Gore's legal team have graciously agreed to stay with our own Jim Engel for more of his interview with him. Jim?
Thanks, David. One of the things we were talking about a moment ago is that the Supreme Court justices were pretty tough taskmasters. They said the briefs have to be 50 pages, that's it. Neither one of you started off with a 50-page brief, am I right?
I think that's right. In fact, we both asked the Supreme Court to give us additional pages.
Both being the Republicans, not both of us.
No, both of us, too.
Yeah, right.
And they turned us all down. And indeed, both we and I think the Republicans, too, had to cut a brief from maybe 65 to 70 pages down to 50 pages the last 3 hours before it was filed.
And in the Republican brief, they still had...
Yeah, I think that's right. Yeah, they still in the table of contents.
They had a little thing that page 67 was their conclusion or something.
We almost had that, too.
Yeah, only
we caught that going out the door.
Now, let's go back to the standards question. Do you expect this court to say, not only must you determine the voter's intent, but here is how you must determine the voter's intent?
I think the court may give guidelines. I think that the guidelines are less important if it's done under the court's own auspices, because the court will be directing that count, just as I don't think there were specific guidelines in the Beckstrom case, because it was done there under the auspices of the circuit court. Now, in another situation, if you had 25 people doing it, then I think you'd need to have more specific guidelines. But here, in most cases, the intent is going to be pretty clear, and what's going to come back to the court, if the court were to send it out, for example, to the Leon County Circuit Court clerk, I think are a very limited number of ballots.
Let me ask you this. You were arguing that there was, in fact, it was clear this would change the outcome of the election. In Miami-Dade, the other side argued, you had the initial sample recount, which were precincts in which you had a 10-to-1 advantage for Al Gore, and still he only picked up 6 votes.
I can answer that. They had better machines, because when they counted 20% of the vote, it went up to what, 168. Yeah, for net 168.
But still largely Democratic precincts.
Well, a combination of Democratic and Republican precincts. Yes. And remember that you've got to look at it on a precinct-by-precinct basis. You heard some testimony during the trial that said, well, if you take all of the precincts and you lump them together, then Bush has 52 to 48% of the remaining precincts.
I don't think we want to get back into that argument. But
right. However, if you go precinct by precinct, the place where the undervotes are still Democratic precincts.
Okay, I need to go. Thank you very much. David Boies, Dexter Douglas from the Gore legal team. Back to you, Linda.
All right, Jim, thank you. And we thank both Mr. Boies and Mr. Douglas for taking time to talk to us. We know it's a very busy day for them. We also want to take you back now to another part of town.
Let's go ahead and say the pledge, Representative Frankel, and then you and I will have a discussion about the time frame. The members and visitors in the gallery will please rise for the Pledge of Allegiance to the flag, to be led by our own Representative Joe Negron from Stuart, Florida.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to announce the doctor of the day, again, is our very own Representative Frank Farkas from St. Petersburg, Florida.
All right, once again, the man in charge there got a telephone call. We don't think it's his wife calling with the grocery list. Let's listen in again.
Any resolution, we'll make sure that every member has a copy of the proposed resolution on their desk. Representative Frankel, do you have a motion?
Thank you, Mr. Speaker. I move to waive the rules to adopt the special rule.
Thank you, Representative Frankel. And the motion having been made, I would ask Representative Goodlett to explain the special rule and answer questions. You're recognized.
Thank you, Mr. Speaker. Members, if you will recall that during the organizational session, we talked about this special rule, 6.19 of the rules, and if you have the rules in front of you, it's on, it's 10.14 on page 60 of your rules, members. I wanted to just briefly summarize with you the process that Representative Frankel and Representative Wiles and Representative Cosmos and I and Representative Byrd have discussed over the course of the last few days that will govern these proceedings both today and when we reconvene. As was explained earlier, basically, members, for those of you who may be
viewers of C-SPAN, this special rule actually contemplates a process that's similar to what you see on C-SPAN. This will enable each of the minority and the majority to...
All right, that is Florida State Senate on the right, Senator John McKay. Let's listen in.
When the Electoral College meets on December 18th, I do not think that there is a member in this body who in his or her most honest moments believes that the controversy swirling about in the courtrooms of this city can be put to rest decidedly and without further challenge within the next 96 hours, particularly since new lawsuits have been filed in just the past few days. If such finality cannot be achieved, and believe me, I hope it is, there is a significant risk that this state's electoral votes may not be counted. I cannot abandon my constitutional duty. We cannot abandon our constitutional duties and let the 6 million Floridians who voted for the candidate of his or her choice not be heard. Although others suggested earlier action, now is the time to be prepared to exercise the unique authority and responsibility given directly to this body by the United States Constitution in order to call this special session for the purpose of making those 6 million votes heard. While some will say that our actions over the next few days will be a partisan exercise, my view is that they are not. Rather, I'm here performing my constitutional duty as I see it. Nothing more, nothing less. Let me read a portion of a letter that I received from Senator Rosen the other day. I think contemplation of his words will benefit this body. He wrote as follows: "It is my true belief that great men are not born great. Rather, they are put in positions of historic proportions and then make decisions no one expected they had the capacity to make. If events unfold that require me to vote for someone other than George W. Bush, so be it. I'm prepared to do that. So if that's what it takes to protect Florida's 25 electoral votes. I will not allow Florida's 6 million voters to be disenfranchised. Our journey will at times take us into uncharted waters, but we must not let ourselves be drawn into personal squabbles that would negatively affect our ability to work together. Once the television cameras have been turned off, we will have much work to do, and we must do it together if we're going to effectively address the needs of our state. A comment I made nearly 3 weeks ago when I assumed the office of Senate President bears repeating. When we show respect to each other, we show respect to those that elected us. The task ahead of us will at times be arduous, but it should at all times be in a manner that reflects the respect and friendships that we have made on this floor. I would like to remind you again of the spirit of our friend, Senator Pat Thomas, who believed that cordiality, decorum, and respect were not just words used to describe the Florida Senate, but were in fact the very heart of the Florida Senate. I look forward to your joining with me in Senator Thomas's spirit over the next week. Thank you for your attention.
All right, that is Senator John McKay from the Florida Senate. He was reluctant to get into this, but now he is going whole hog, announcing again, along with the House of Representatives in the state of Florida, that indeed they are going to pursue their own course of action to appoint a set of electors. Let's listen in again.
We'll meet on Monday, December 11th from 11 a.m. to 7 p.m. in the Pat Thomas meeting room, Knott Building, room 412 of the Knott Building, to consider Senate Concurrent Resolution 2A. The amendment deadline for this reading will be 9 a.m., 2 hours prior to the meeting on Monday morning. Then, Mr. President, in the event that the Senate receives a message from the House of Representatives containing a concurrent resolution passed by the House, the Ethics and Elections Committee will meet again Wednesday, December 13th from 9 a.m. to 11 a.m. to consider any measures received from the House and referred to the committee by the President. The amendment deadline for that Wednesday meeting will be 7 a.m., 2 hours prior to the meeting. The notices for these meetings will be filed with the Secretary and posted on the Legislature's website and on monitors in the Capitol Rotunda and in the Knott Building. The Rules and Calendar Special Order Subcommittee will meet at 7:30 p.m. or 30 minutes following the adjournment of the Ethics and Elections meeting on Monday, December 11th, to set the special order calendar for a session on Wednesday, December 13th at 1 p.m. A notice of this meeting will be filed with the Secretary and will be posted on the website and on the monitors in the Capitol Rotunda and in the Knott Building. The amendment deadline for the 1 p.m.
And joining us now from inside the Beltway, a congressman who has a particular interest in what's going on in his home state of Florida, Peter Deutsch, joins us now. Peter Deutsch, thanks a lot for staying with us.
Thanks.
Let's ask first the whole question of what exactly is happening now in the House and Senate of Florida. What's wrong with them appointing their own set of electors?
Well, I think a couple of things. First of all, they have electors. Secretary Harris has sent up electors literally to Washington that are in the National Archives right now because she certified an election. So there's no risk at all, zero risk, that Florida will not have electors.
But
Florida
Congressman, you don't doubt, excuse me, their constitutional right. Let me just, the U.S. Supreme Court affirmed that constitutional right on Monday. They said, quote, the legislature is not acting solely under the authority given it by the people of the state, but by virtue of a direct grant of authority made under the Constitution itself. So they clearly have the authority to do what they're doing.
They have the authority when there are no electors. Okay,
it doesn't say that, though, does it? It says specifically they have the authority, whether there are or not.
Okay, let me tell you, they could do anything they want. The good news is that Congress is the ultimate body that accepts electors. And let me tell you that if Al Gore ends up, getting votes counted and winning the state of Florida and getting Florida electors, whether it's December 11th, whether it's December 12th, because that's not a hard and fast deadline. It could be December 17th. It could even be December 20th. If Florida ends up being counted, more votes for Al Gore than George W. Bush, and Al Gore's electors are sent to Washington, there is no way Congress is going to accept electors appointed by 140 Republicans in the Florida legislature.
Congressman, if you could hold on just a minute, we want to go back to the Florida House and listen to Tom Feeney, who's speaking right now. We'll get back to you. Thank you very much.
The chamber of this great institution of the Florida House is absolutely essential to our ability to fulfill our responsibilities under both the Florida Constitution and the United States Constitution. I love and respect this great institution of the Florida House. When I do my job here, upholding the integrity of this great institution is more important than who wins or loses on any given issue or debate. I hope our new 63 members will grow and come to revere this House and the people we serve the way that I do. The rule continues, in quotes, the Speaker shall see that the members conduct themselves in a civil manner in the chamber of the House in accordance with the accepted standards of parliamentary conduct, end quote. And I'm confident that all of our members, no matter what the circumstances, will conduct themselves in a civil manner. I fully intend to assure, and I'm confident, that our respective partisan leaders, Representative Frankel, Representative Fasano, who, by the way, in front of the world cameras, have done a remarkable job of advocating for very different positions in a very civil, polite, and respectful manner. But I'm confident they will help me in assuring that all of our debate will be conducted in this chamber in an atmosphere of respect for each of our fellow members. It is my goal that the commentators around the country that often complain about the decline of civility in American politics will be able to point to the forthcoming debates that we have here in the House as examples of how people can disagree deeply and yet be civil and respectful to one another. Leader Fasano, Leader Frankel, while passionately advocating their position, have done a tremendous job outside this chamber, and I know all of us can do a great job inside the chamber. Mason's Manual of Legislative Procedure, which we rely on as an authority on construction and application of our rules, sets out good guidelines for our behavior. And I quote Mason's, members must not be permitted by their conduct to deny to others that which they may claim for themselves. It is the duty of all members to conduct themselves so as not to obstruct the like rights of other members. Freedom of speech involves obedience to all of the rules of debate, end quote. And so it may be that our civil behavior in this legislative debate is a great golden rule for the country to watch. Churchill, in referring to his country's legislature, said, in quote, "The object of Parliament is to substitute argument for fisticuffs." We're not going to have any fisticuffs here. We may have a great debate, and I hope we do. You'll be judged by your colleagues in the House, not just this week, but perhaps for the rest of your stay. Not so much based on which side of an argument you take, but the demeanor in which you press your case and the statesmanship and character you display in expressing your views. Let me add that the powers of the Speaker to preserve decorum inside the House also include the power, if necessary, to clear galleries in the case of disturbance or disorderly conduct. Just as decorum requires the cooperation of the members, so it also requires the cooperation of the public that may wish to view us. We've never had, quite before, found ourselves in quite this exact situation. Today, literally much of the world is watching, and history is watching us as well. We have before us duties under the Constitution of our state and nation. And members, we also have a duty and a grand opportunity to be an example of representative government at its best. Thank you, and we'll probably refer to that again before the debate on Tuesday. Representative Frankel, do you have a comment? You're recognized for comment.
Sir. Thank you, Mr. Speaker. Well, you know, I have a vigorous disagreement with the necessity and the legality of this legislature appointing electors, but and getting along doesn't mean going along, but I agree with you. We do need to get along. We're not here to burn bridges, but to represent our constituents in a thoughtful and conscientious manner. I want to thank you, Mr. Speaker, for the courtesy that you and your leadership has extended to our leadership in getting to this point in this very difficult issue. And I want to echo you, and I want to just say to the members, we are going to have some very, very passionate differences of opinion on this floor. But I want to remind you that when all the cameras leave us, we are going to remain behind to work together for the citizens of Florida. And what I want to say to you is this, that when this is over, I know that we will rise above the partisanship and work for our constituents. And say to all of you that while the world may be watching us, I know that each one of us inside ourselves are going to do the best that we can. Thank you, Mr. Speaker.
Thank you, Representative. Are there corrections to the Journal of November 21, 2000, the organizational session? There being none, show it approved. Take up introduction and reference.
By Representatives Cantens, Byrd, Goodlett, Diaz-Balart, Fasano, Rubio, and Maygarden. House Concurrent Resolution 1A, a concurrent resolution providing for the manner of appointing electors for President and Vice President of the United States, providing for the appointment of such electors, providing for the filling of vacancies. Reading of the title, Mr. Speaker.
Thank you. John, what are you doing? To the Joint House. Before I refer that bill, Representative Cosmos, for what purpose do you rise? I'm glad you're not a new member. I recognize you, Representative Cosmos. For what purpose do you rise?
Thank you, Mr. Speaker. For a point of order.
State the point.
The point that I'd like to bring up, and I think as has previously been stated here, the magnitude of that which we are about to embark is greater than any that we probably in our careers will come upon. I think that we need to point out to the members, particularly the 63 new members, that we do operate within our House rules that we adopted last week, and that a concurrent resolution as described in our House rules is not within the scope of what we are about to receive. The resolution that we received, the concurrent resolution that we received about an hour ago, deals with matters of substantive rather than procedural legislative issues. It violates Rule 5.10, which specifically describes the instances in which a concurrent resolution is permitted to be brought to the House. And if you would permit me to read those specific instances, I would. Concurrent resolutions originating in the House shall present only questions pertaining to extension of a session, enactment of joint rules, ratification of federal constitutional amendments, communication with the judiciary, and other procedural legislative matters. It is difficult for me to construe this resolution before us as a procedural legislative matter. The manner in which it, for all intents and purposes, evicts the current slate that we have certified to the archives in Washington, and the manner in which it construes the legislature to have the ability to reappoint at this stage is more akin to...
We're very sorry for that. But the judiciary needed a little more time.
Can you explain the reason for the delay? Quite simply, the judge... The question was, can we explain the delay? One of the judges, who I'm not going to tell which judge it is, but one of the judges needs more time to finish her ruling. Yes. And that is absolutely the reason why. She says, I need more time. And obviously, she wants to make it right. He wants to make it right. She and the others wants to make it right. Once again, I've not had the opportunity to pose that question to the judges as to whether or not they have been in a consultation. They certainly have shared some views in the past, but I don't know whether or not they have since last night to this morning.
They brought the attorneys in. Why did they bring them in?
We brought the attorneys in as a courtesy to the attorneys. Typically, if you guys were not all around, we would notify the parties before we released it to the general public, essentially what the essence of the ruling was. Obviously, in this case, we have an enormous number of attorneys, but we still would like to give them that same privilege before we release it to the rest of the world. And we ask that you accommodate that request for us as best as possible.
Why don't you bring the attorneys if they're not finished with the opinion?
Well, because we thought that we were working under the same assumption all of you were, that there was going to be a ruling, and that's why the parties were brought in. Yes. So they understand that there will not be one until a little later this afternoon, 2:15, and the parties will be back there.
Is there a ruling in one of the cases?
Not that we know of.
Right.
Are the attorneys going to be commenting?
Yes, they are here. The attorneys are here, so they may very well be commenting.
Yes.
Okay.
Yes, we've asked that they come down here if they have any questions.
Thank you very much.
We'll be back 2:15. Thank you. I apologize.
2:15 p.m. All right, that is about an hour and 45 minutes from now. So the Leon County decision has been held up because of one justice, and apparently a poor PR person, sometimes they slip out a little more than they plan to. Apparently one of the female justices, he did reference with a pronoun, a feminine pronoun, as to one of the justices who needs a little more time to think things over before coming to a decision in these two cases. Again, in the Seminole County case and the Martin County case, but we know for a fact that if it was the female judge, it was Nikki Clark, and that is the case that involves Seminole County. We have Judge Andrew Napolitano, who's been standing by watching all these developments. It's too bad. Sometimes you hate to be a PR guy if you let something slip out like that, but we know now that Nikki Clark, who was of the two judges, was the one who said, you know, it's probably... Wait a minute, I'm sorry. We're going to switch from this to listen to one of the lawyers. This is the Gore lawyer in the Seminole County case. Let's listen in.
Judges haven't yet rendered their opinion together. One may be taking slightly longer than the other.
What?
We don't know specifically the reason for the delay, other than it's going to be at 2 o'clock, and both judges may not have rendered their opinions, and they both want to come out together.
Is your understanding that they're conferring right now and trying to come up with a joint ruling?
Understand, we have no knowledge whatsoever as to whether they're conferring or not. It could be purely administrative. We don't have any information on that at all, and I wouldn't speculate about that.
If you lose, will you appeal?
Pardon?
If you lose, will you appeal? Are you prepared to go that far?
I am certain that both sides have their appellate papers ready to go instantly, whichever way the ruling goes. And we are prepared. We will be prepared. We think we're right. We intend to take it up. If we lose, but we're optimistic that we're going to win.
Are you upset over the fact that these two judges have conferred about their ruling?
I don't read anything into that. I can't guess as to what it's about. It may be purely administrative.
Sir, have you received any indication that if you lose and you do appeal, whether the Gore team will join in with that appeal?
No indication at all. We've said repeatedly we have no direct relationship to the Gore campaign. We represent an individual who's protesting what happened in Seminole County, where essentially the Republican Party turned that office into an instrument of the party in altering things that by law they had no right to do. Once somebody goes ahead and does an absentee ballot request by law, that's it. When they've signed it and it comes in, nobody should have a right to change it. Nobody should have a right to go into the election supervisor's office for 3 weeks and sit there and change those cards. And that goes to the very integrity of the election process. Whatever happens here, we honestly believe that the only issue for this judge ought to be what remedy ought to occur in this case, because the fact that a wrong has occurred and that it was disparate treatment with regard to the Republican Party is essentially admitted in the facts. And we've proven that they attempted to cover it up. The question I can understand any judge struggling with is, what do you do in terms of the remedy? And the Florida precedent says all 15,000 ballots have to be thrown out. In other states, there is some precedent for saying that the judge can do it proportionately. There is authority under the Florida law that says that the judge can order other relief. So the judge has some equitable discretion. We don't know how that's going to be exercised in this case.
Mr. Richmond, should your case be at all commingled with the Martin County case?
No, they're two separate cases. I think the facts are similar, but there are differences.
So then should the judges be conferring with each other?
I can't comment on that. It's not customary for judges to confer, but judges do confer from time to time in cases.
Mr. Richmond, have you had discussions with the Assistant State Attorney for Seminole County about pursuing criminal actions against Ms. Gore?
We have not, and candidly, there's just been no time to do that. This has been a unique, fast-track case. I don't think anybody's ever put together and tried a case as fast as we've had to do it in this case with the Seminole and Martin County cases.
Either way, what happened with the civil case? Do you intend to do that, pursue with the State Attorney's Office?
That will be up to my client. The State Attorney's Office will have all the facts, and we do believe that the conduct occurred in this case on the part of the Republican Party and on the part of the Republican-elected supervisor, who's supposed to be a neutral, is illegal.
Mr. Richmond, have you read the Bay County dismissal yesterday, which says that, a rather caustic opinion says that third party, any wrongdoings by third parties, not the voters themselves, cannot result in the invalidation of ballots. Why should that argument not hold in this case?
Has absolutely no application, because the wrongdoing here goes to the integrity of the process. If you take a look at the City of Miami case, the wrongdoing was on the part of third parties. And what ultimately happened in that case is you've got so-called innocent voters, because the entire pool is tainted. They ended up throwing out 40,000 ballots in that case.
To appeal this case?
We're ready to do what's necessary. Yes, sir. We're ready to take an appeal. Yes, we are.
What about criminal charges against the election supervisor? What are your thoughts on that?
That's up to the state attorney. We believe that they've got the basis.
What would you encourage the state attorney to do in that respect?
We would encourage appropriate charges to be brought, because it goes to the very integrity of the process. Anything else?
Thank you.
Thank you.
Is lawyer Gerald Richmond. I misspoke, excuse me, moments ago when I suggested he was acting on behalf of Al Gore. He's acting on behalf of Harry Jacobs, who's a citizen who claims that there was mischief afoot when, in fact, those ballot applications for absentee ballots had numbers written on them by Republicans. We have Judge Napolitano back in the courtroom, our own courtroom right here in Fox News studio. Now, Richmond himself, we should mention that even though he is representing someone who is not officially with the Gore camp, there have been Democratic officials brought in either as witnesses or as people who have spurred on witnesses. I'm thinking of this guy named Head, the Democratic head of Orange County.
Right, and then the vice president himself outside the White House 2 days ago
encouraged and seemed very hopeful about the prosecution of this case.
And re-explain why it is Al Gore's team is anxious to disassociate themselves with this case, even though they wanted to win.
Because Al Gore's team and the vice president himself have been preaching for 30 days now, count all the votes. And the essence of this case is to uncount 15,000 votes, to literally throw them out and deduct them from the vote totals. It's the opposite of what the vice president has been preaching in the cases in which he's a part.
Now, we are following about 6 or 7 different things at the same time here, so forgive us if we jump around. But the Florida State Legislature, again, deciding to appoint their own set of electors. We just heard a congressman from, Democratic congressman, say that was inappropriate at the moment, even though it might be constitutional. Is it inappropriate in any way?
It is not inappropriate, because the Constitution says they can do it, and the Supreme Court, as recently as 4 days ago, interpreted the Constitution in such a way as to say they can do it. I think what Congressman Deutsch means, and he and I rarely agree, but I think what he means is it may be a little early for the legislature to do it because there already are 25 Republican electors designated by the state of Florida to cast their votes in the Electoral College. But it will take more than 5 minutes to do it, and the legislature wants to be sure, if something bizarre happens with the Supreme Court, that they're ready to move.
All right. Well, the ringmaster of the circus that's going on in Tallahassee right now is our own Brett Baer. He's been following all of the different rings of this circus.
You're looking at a live picture of the rotunda in the Leon County Courthouse. Less than 2 minutes from now, we should have a spokesperson come out there and speak to reporters and tell us what the decisions are from the judges in the Martin County and Seminole County absentee ballot cases. Again, that's less than 2 minutes away from now. So as soon as that happens, we're going to go live. In the meantime, we're going to try to get a little bit of analysis on what kind of effect the court rulings will have for both Al Gore and George W. Bush. Joining us now from Washington to help us sort through some of the proceedings is William Lash III. He's a law professor at George Mason University. Thanks for being with us, Professor.
Hi, Linda. How are you?
I'm good, although we're all pretty much in suspended animation watching these decisions. Since we have these things coming maybe a minute and a half away, let's try to go straight to that. You've been seeing that the judges in these two cases conferred and that they're issuing their decisions at the exact same time. Do you take that as any prediction of how they're going to rule?
It would be unlikely they would come out with different opinions, but they may be tweaking the language a bit. Again, the facts may be slightly different. And they may have a difference of opinion as to the nature of sanctions. Some people believe that only a proper remedy might be a fine or a sanction on the election officials, not the voters.
Right, and there has been a question about this. Plaintiffs have been asking for all of the ballots, the absentee ballots in each of those counties, 15,000 in the case of Seminole and 10,000 in the case of Martin, to be chucked out. And it seems, at least Judge Clark was saying, how can I penalize the voters for something, for a mistake or something, or an error of some sort that was made by the elections officials? Is there anything provided for in law that would allow, essentially, for the voters to be penalized by having those votes tossed out?
Absolutely not, especially under Florida law. Remember, the earlier Florida Supreme Court opinion spoke very eloquently of the importance of suffrage, to vote is to be heard. Well, to throw out those votes is to silence all those voters without any due process.
Even the question of throwing out a portion of it, both plaintiffs in both cases were saying, okay, well, if you don't toss them all out, then how about just a portion of them? That seems like a bizarre solution. I have never heard of anything like that. Is there any precedent for that?
Absolutely not. This idea of selectively throwing out votes, maybe in the case of fraud, but here's no fraud. Remember, the allegations where there was touching or writing on the applications. The actual ballots are absolutely pristine.
There have been talks by people saying, oh, we're finally reaching finality. We may be seeing the end of the line, all the cliches and metaphors that you can toss.
Make this a Category 5 cyclone, the most severe.
That they're ready with appeals. So
absolutely right.
So it's not really the end of the line, is it?
No, it's not the end of the line. It's not going to be over till the Florida legislature steps in and ends it for us.
So the Supreme Court, in effect, its decision may be, although the Florida Supreme Court may have some sense of finality, is it possible that these separate cases in Martin and Seminole could prolong it?
Oh, it will prolong it, but look at the calendar. There's no way they can get this case argued, briefed, and decided before December 11th. Now, the Florida legislature has got to act before that happens to make sure that Florida is not ignored and not represented at the Electoral College. So I think it's designed by the Gore team and the Gore supporters to make sure they have to act so they can then cast the legislature in the role of somehow grabbing the election.
So just to sort of go back to the Gore campaign's connection to the plaintiffs in the Seminole and Martin County, we had it confirmed by Jim Engel and Brett Baer that definitely there have been some talks between advisors for the Gore campaign and the plaintiffs, or at least the plaintiffs' lawyers, in these cases, although they're not in any way acknowledging any sort of formal connection. It sounds like this remains the Gore campaign's unofficial Hail Mary pass. Do I have that right?
Yeah, it sounds much more to me almost like Mission Impossible. You know, if you are caught, the secretary will disavow all knowledge. In this case, you know, Mr. Jacobs is very much a very active and very financially involved Gore supporter. So they're doing it to benefit Al Gore. And Al Gore has changed his tune from count all the ballots to let's see what the Florida Supreme Court does in all these cases.
Now, another question of sort of personalities. Judges always pledge to be impartial. But this morning on the front page of the New York Times was smack right on front of this article about Judge Sandra Sauls and how he had been taken to the woodshed a little while ago by the members of the Florida Supreme Court, and that it was an ugly case, that there were really bad feelings on all of this. Is there any chance at all that the Florida Supreme Court's, the justices, that their decision may be affected by what may be a less than fantastic relationship with Judge Sandra Sauls, who decided the case?
No doubt at all. I think there's really, basically a smear tactic against Judge Saul. And it's unfortunate. The opinion stands for itself. They may give it more scrutiny if they believe, he's autocratic, like that. But his courtroom was run on the air. I mean, how much more democracy can you get? If there was any criticism of him, you had plenty of chance to see it. He's not the one facing the ethical charges, is he?
Speaking also of being taken to the woodshed, in a way, the Florida Supreme Court was taken to the woodshed, too, by the U.S. Supreme Court when they got the remand. It sounds like, from what we heard from the Chief Justice of the Florida Supreme Court, that they are really reluctant to get themselves in a sticky position once again. How much of that do you think, I mean, it's hard to quantify, but how much of that do you think will play into their decision if we get it today?
I think quite a bit, Linda. I mean, they are now on notice that the federal law it governs this whole dispute, which we've said all along. And not just the opinion from McPherson, which was now cited again, stating that the power to choose electors is set by the legislature, and they may resume that power at any time. So they are on notice on that. The second appeals and briefings came in again, reminding of the very limited state interest and reduced role when you're choosing a president. They will, I think, probably decide this case in favor of George Bush on heavily federal grounds. They may chastise Saul here or there on dimpled ballots in his review, but bottom line, I think the federal law is going to carry the day on this one.
Oh, let's just say, playing the role of devil's advocate, let's just say they don't. Let's say they rule against George W. Bush and in favor of Al Gore. George W. Bush was just saying today that he's already prepared to go back to the U.S. Supreme Court, but it seems like we're running out of time. How does that work if he decides to take it back to the U.S. Supreme Court? Wait, I'm sorry. Let me just, if I can interrupt you there, William,
sure.
and ask you to hang on, because we've just gotten word that Terry Cass, she is one of the spokespeople for the Leon County Court, is just approaching the podium in the rotunda of the Leon County Court. She has told us earlier today, that she's going to have the decisions in two separate cases to be read at the exact same time. Of course, this one being the Seminole County absentee ballot case, and then the Martin County absentee ballot case. We're getting some conflicting information as to whether she's actually approaching that podium, but she should be just steps away. We have a producer and a crew right in there, so we're getting some further word and awaiting further guidance on exactly where she is standing and stepping. I may have one last second to get in with William Lash before he. Nope. In fact, I don't. I want to thank once again William Lash of George Mason University for being with us and giving us some much-needed analysis and putting some of the legalese into plain English as we all try to make sense of the various legal battles and where they go from here. Once again, you're just looking at a live picture of the rotunda of the Leon County Courthouse. And at the risk of sounding terribly repetitious, here's basically what we're waiting for. We're waiting for decisions, twin decisions, two different cases, but somewhat similar. The Seminole County case, absentee ballot case, and the Martin County absentee ballot case. Both of them, different plaintiffs, have been asking for the absentee ballots to be tossed out. And we're talking about a total of 25,000 ballots there. 15,000 in the case of Seminole County. Martin County, we're talking about 10,000 ballots. The plaintiff's asking for those ballots to be tossed out because in the case of both counties, some information was added to ballot applications, not the ballots. There's a question about whether or not the judges will see that as deserving of any remedy. There seems to be some reluctance, at least by Judge Clark in the Seminole County case, to go there and toss out those kind of ballots because, in effect, it would be penalizing voters. Let's hang on for 1 minute as we're getting more guidance on Terry Cass, the spokeswoman for the Leon County Courthouse. I'm getting word from our producers that she is approaching now the podium at long last. All right, we're going to hear from her now. Let's listen in.
Ladies and gentlemen, Ms. Terry Cass, Court Administrator for the 2nd Judicial Circuit.
Good afternoon, ladies and gentlemen. We have a ruling in both the Seminole County case and the Martin County case. Based upon the evidence presented and in accord with the controlling legal precedent of the Florida Supreme Court, the trial courts in both the Seminole County case and the Martin County case have determined that despite irregularities in the request for absentee ballots, neither the sanctity of the ballots nor the integrity of the election has been compromised, and that the election results reflect a full and fair expression of the will of the voters. Accordingly, all relief requested by the plaintiffs has been denied and judgment entered for the defendants. Thank you.
Thank you very much.
All right, there you have it. The decision from the judges in the Seminole and Martin County cases amid some cheers there in the rotunda of the Leon County Courthouse. We want to go now to correspondent Brett Baer, who has been covering these cases as they've been working their way through the courts. Brett, what do you have?
Well, there you have the ruling announced by Terry Cass, the court administrator here at Leon County Courthouse. Both judges Terry Lewis and Judge Nikki Clark decided to side with the Republican side, saying basically that the validity of the votes cast cannot be compromised and that the sanctity of those votes is intact. The election result is okay, despite the fact that Republicans altered some absentee ballot application forms. They say the votes themselves cast by those people cannot be thrown out. At stake there were more than 25,000 votes, possibly, that the Democrats in those two counties, Seminole County and Martin County, wanted tossed out. The judges saying they just can't do that because those people meant to vote the way they voted, and those votes do count. Now, we can tell you that the Democratic side, the plaintiffs on both the Seminole case and the Martin County case, say they have already had appeals readied, and they will file those immediately with the First District Court of Appeals. They will likely be waived on to the Florida Supreme Court, and then the 7 justices there will have to decide whether they will take up an appeal of this case. Linda?
And Brett, just sort of a reality check. Although there was some slight hope that folks in the Gore campaign were putting in these cases, it doesn't sound like they were ready to bet the farm on them. It's not like they really believed they were going to get a favorable judgment from Judges Clark and Lewis.
All along, Linda, they've been saying that this is a legal long shot and that perhaps this case was standing on some shaky legal legs. But the Gore camp had embraced the fact that if they received the votes here, they would obviously take them if it changed the election. They were not a party to this case, but you heard Vice President Gore the other day speak out at length about these two cases and the fact that perhaps there was wrongdoing here. These two judges have stepped up and said, indeed, those votes have to count, and now it will be appealed to the Florida Supreme Court.
Brett, something I want to follow on something you and I were talking about a little bit earlier, which is just how much communication there has been between the Gore campaign and the plaintiffs in the Seminole and Martin County cases, because ostensibly Al Gore has been absolutely keeping his distance from this. And politically, it's unwise for him to be connected to it, but in reality, there seems to be much more communication going on behind the scenes.
We don't know if there was much more, but there was definitely some communication. At least one Gore campaign attorney talked to some of the plaintiffs in the Seminole County case, and we're told that there was some legal advice there, while the campaign itself has said they wanted to make sure that they were not listed as a party in this case. They obviously wanted to see these cases go forward. But now on appeal, both sides, the Martin County case and the Seminole County case, will take this case to the 7 justices of the Supreme Court in Florida, which obviously are dealing with another appeal from the Gore campaign, and that is on the question of whether to overturn Judge Saul's ruling that the hand recounts of some 14,000 contested ballots in Miami-Dade and Palm Beach County should be counted. So eventually, at some point, we will see the 7 justices in the Florida Supreme Court with a very full plate today.
Got it. Well, Brett Baer, with the 2 major legal developments of this day so far, the 2 decisions in the Martin and Seminole County ballot issues. Brett Baer, thanks once again. We're going to get some more analysis on the fallout since the decisions have just come down. Once again, to repeat, the judges have decided against the plaintiffs and for the defendants in the Seminole and Martin County ballot issues. Once again, those 25,000 ballots cast in both those counties, the absentee ballots, stand as they were cast in the election. More to come in just a minute.
Miami-Dade and other counties. The split decision also awards Gore nearly 400 votes that weren't part of the certified totals last month. We'll have a lot more after the news from New York.
Fox News Live, I'm Patty Ann Brown. After swinging and missing in so many legal battles, Al Gore finally hit one out of the park thanks to the Florida State Supreme Court. The state's high court reversed a lower ruling and ordered statewide manual recounts of so-called undervotes to begin immediately in all 67 Florida counties. The decision is a major victory for Gore, who has been relentless in using the legal system to get what he has called a full and fair count of the Florida vote. Today's ruling has also reduced the Bush lead to 154 votes. He had been leading by 537 votes. No word on whether the Bush camp will appeal. The ruling could not have come at a more critical moment for the Democrats. Earlier today, 2 judges in Seminole and Martin counties rejected a bid by Gore supporters to throw out 25,000 absentee ballots. These were 2 very serious setbacks for the Gore team, occurring less than 2 hours before the announcement by the Florida Supreme Court. Meanwhile, the Florida State Legislature has convened an historic special session today to choose a new slate of presidential electors. The Republican-nominated legislature will reconvene Monday for hearings on resolutions that would choose 25 electors who have pledged to vote for Bush. Our next update is at the bottom of the hour. Now, stay tuned for special report. Tony Snow has more on today's rulings.
Welcome to Washington. I'm Tony Snow in for Britt Hume. The Florida Supreme Court has ruled 4-3 that state officials must begin a recount of selected ballots in Miami-Dade, Palm Beach counties, and other counties in which so-called undervotes may have cropped up. The decision reverses the order issued earlier this week by Leon County Circuit Judge N. Sanders Sauls and comes on the heels of 2 rulings that rejected Democratic bids to disqualify 25,000 absentee ballots in Seminole and Martin counties. The Florida Supreme Court's order effectively adds 383 votes to the vice president's totals in the state. Fox News' Jim Angle has been following this story for us from Tallahassee. He joins us now. Jim?
Hello, Tony. Well, the Florida Supreme Court handed Al Gore a huge victory and gave him a new lease on his political life as it ordered a massive recount of ballots, primarily the so-called undervotes, those without a clear indication marked for president. The court's decision was announced by court spokesman Craig Waters.
By a vote of 4-3, the majority of the court has reversed the decision of the trial court in part. It has further ordered that the Circuit Court of the Second Judicial Circuit here in Tallahassee shall immediately begin a manual recount of the approximately 9,000 Miami-Dade ballots that registered undervotes.
Now, while that recount takes place, Tony, the court ordered the results of 2 partial recounts to be immediately credited to Al Gore.
In addition, the circuit court shall enter orders ensuring the inclusion of the additional 215 legal votes for Vice President Gore in Palm Beach County and the 168 additional legal votes from Miami-Dade County.
Now, the 215 votes from Palm Beach County came in after the court's own extended deadline of November 26th. They arrived at about 7 p.m. The court is saying those will now count for Al Gore. In addition, there were 168 from a partial recount in Miami-Dade County. They are saying those will also be credited to Al Gore. So, according to the Supreme Court at least, Al Gore is now only 154 votes behind George W. Bush. Now, the court's decision, as you heard, was a 4-3 decision with Chief Justice Wells and 2 others dissenting. And I want to read you part of what Chief Justice Wells said, Tony, after complimenting his colleagues and saying that he wasn't questioning their good faith or honorable intentions. He ripped their logic on how they reached this conclusion. He said he could not more strongly disagree with the decision and that it will prolong the judicial process. I also believe, he says, that the majority's decision cannot withstand the scrutiny which will certainly immediately follow under the United States Constitution, clearly suggesting that this could be reversed by the U.S. Supreme Court. He also says that the decision of the court had no foundation in Florida law as it existed on November 7th, 2000, or at any time until the issuance of this opinion. He says the basis that they are now ordering undervotes to be counted on the basis of unknown or at best ambiguous standards with the authority to obtain help from others, the credentials, qualifications, and objectivity of whom are totally unknown. This is but a first glance, he says, at the imponderable problems the majority creates, and goes on to say that there is a real and present likelihood that this constitutional crisis will do substantial damage to our country, our state, and to this court as an institution. So the court has decided to move ahead with recounts, but the Chief Justice has offered a stinging dissent here, Tony. One other point, the court did acknowledge something that was held by the lower court, which it is unfair to go ahead and do just some counts in some places. They have ordered all of Florida's counties with undervotes to begin an immediate recount. Now, the Gore people believe that that really only applies to 17 counties that use machine voting. And in those 17 counties, there are a huge number of undervotes, in some counties as many as 20,000. So this could be an enormous problem, and there are a lot of questions tonight about whether or not this can be completed by the December 12th deadline, one of the concerns that was expressed by Chief Justice Wells during the oral arguments. Tony?
All right, Jim, thanks. And folks, if you're looking, it's pages 41 and 42 of the opinion where Judge Wells lets it rip. Jim, well, we're going to come back to you in a couple of minutes. I want to go back to Brett Baer and figure out some other developments in Tallahassee. Brett?
Hi, Tony. We've just been told by Doug Smith, the spokesman for the circuit court here in Leon County, that there will be an announcement in about 25 minutes here. He said it's well worth sticking around for. Earlier, he said to us that the votes, the recounts of the Miami-Dade undervotes or contested ballots could start tonight. They were waiting for Judge Sanders Sauls to come back here to the courthouse. Then they were waiting for a fax from the Florida State Supreme Court to tell them exactly how that counting could begin. Now, you may remember the video of those ballots arriving here at the Leon County Courthouse about a week ago from Miami-Dade and Palm Beach counties. More than 1.1 million ballots offloaded here from trucks. Well, the contested ballots, about 12,000 of them, were transported over to the Florida Supreme Court, put in that clerk's possession for the oral arguments yesterday. Now, those ballots will be coming back here to the circuit court, at which time we believe the counting will start tonight. By what standard, they are going to announce all of that in about 25 minutes. Of course, the news here at the circuit court was that the Martin County and Seminole County absentee ballot application cases were rejected today by Judge Nikki Clark and Judge Terry Lewis. That was what we thought was going to be the big news from Terry Cass, the court administrator.
The trial courts in both the Seminole County case and the Martin County case have determined that despite irregularities in the request for absentee ballots, neither the sanctity of the ballots nor the integrity of the election has been compromised.
Now, those two judges, Nikki Clark and Terry Lewis, sided with the Bush campaign that those absentee ballots were, in fact, valid votes. The Democratic plaintiffs have appealed that to the First District Court of Appeals, but no word yet whether that appeal will be taken up. Of course, the big news, though, the ballot counting potentially tonight here at the Circuit Court. Tony?
Brett, I got a question. You may not be able to answer it. Maybe you can pose it when we do have the press availability in a little bit. Now, they've already done these partial recounts in Miami-Dade County. They've got 100 some odd votes for Al Gore. Have they already set aside the ballots that have already been counted, or have they been reincorporated to the so-called undervotes? And if so, wouldn't that be double counting some of these Gore votes?
No, Tony. We believe that the 168 that were already counted by the Miami-Dade Canvassing Board were set aside, and that the 9,000 undervotes, or what the Gore campaign says, never manually counted votes, were also in a separate stack. So those 9,000 are the ones that will have to be looked at according to the Florida Supreme Court.
Okay, so you don't have to conduct the full recount, which originally was what the court had ordered Miami-Dade to do.
No, not that we believe, and that I think will be clarified a little bit later when we get that spokesman from the circuit court here.
Okay, Brett, thanks so much. Now, meanwhile, perhaps expecting a ruling like this from Florida Supreme Court, Florida State Legislature's Republican leaders convened a special session Friday, drafting legislation aimed at ensuring the state's electoral votes going to George W. Bush with help from Republican lawyers. Members of the State House and Senate met to write resolutions certifying Bush's electors. Despite Democratic claims, the move is unconstitutional. Fox News' Steve Brown has the story.
Senate, please come to order. In light of the latest Florida Supreme Court decision, it may come down to the Florida Legislature to decide.
The clerk will read the proclamation.
Sunshine State lawmakers beginning a special session on Friday that could settle once and for all the presidential contest. The Republican majority in both Florida houses say they stand ready to send the existing slate of Bush electors to Washington if the newly ordered recount and ongoing legal wrangling stretch past the December 12th deadline.
I'm here performing my constitutional duty as I see it. Nothing more, nothing less.
Democrats in the Florida legislature see the special session as nothing more than an insurance policy for the Texas governor.
To make sure George W. Bush's votes are certified, even if in the end it turns out Vice President Gore was the people's choice in Florida.
I don't want to say window dressing, but it is a session with a predetermined outcome.
This is how the scenario could play out. On the deadline for settling disputes about state electors, the Florida House could select a Bush slate, then take the same piece of legislation, hand it off to the Florida Senate, and the Senate could pick that very same slate, and Republicans have the votes in both houses to do it. Will the Republicans move forward even if there is a recount? Yes, says the majority leader of the House, Mike Fasano. He says if they're going to start counting votes, they had better count all 6 million Florida votes, or the legislature will move forward. In Tallahassee, Steve Brown, Fox News.
One group interested in all these proceedings, the United States Supreme Court, which may have something to say about this in the end. Here to talk more about that, the Supreme Court's role and maybe its interaction with the Florida Supreme Court, are Jim Angle. Jim?
Tony, I'll tell you what, if you read this decision, it is clear that the Supreme Court justices here in Florida were looking over their shoulders, perhaps feeling someone breathing down the backs of their necks from the U.S. Supreme Court. As you go through this, page after page after page, there are literally dozens, if not hundreds, of references to what the legislature intended. Now, you remember the issue here was the Supreme Court was saying, it appears to us that you may have suggested in your decision that the Florida Constitution actually was trumping the right of the legislature. But the legislature's role in selecting the electors is enshrined in federal law and in the U.S. Constitution. So they are clearly looking over their shoulders here, repeatedly pointing to Florida statutes, the legislative intent. They even quote a session of a committee from the legislature to show that they're really paying attention to what the legislature did and giving some deference to legislative intent. Tony.
All right, Jim, one other point. What they also say in pointing to the U.S. Code is that contests and controversies may be resolved, quote, by judicial or other methods or procedures. And that's what they're hanging the whole thing on. Right, Jim?
That is correct. In fact, there's one section of Florida law that says in a contest, that gives the judge really sweeping powers to order, I think the language is, order any remedy deemed appropriate. It is a very broad power for the judiciary to step in. That's what they're hanging their hat on, yes.
All right, Jim Angle, thanks so much. Coming up next, a home run for the Gore camp, a disappointment for the Bush side. We'll have live reports from Washington and Austin, Texas next.
Fox News Channel Daytime.
Recounts. The final, of course, that last hurdle is the Florida Legislature, which is, they believe, will go ahead and name a slate of Bush electors regardless of whether or not this recount goes forward and regardless of whether or not that recount shows Gore to be the winner. So they know that they've got several big battles ahead. They can celebrate now, Bernie, but it's got to be a very quick celebration.
But, John, don't they have legal specialists who, prior to today's ruling, have been anticipating and working on some strategies that they're not prepared to talk about?
Oh, absolutely, Bernie. They have had a legal strategy in place. They have had people working on these issues, the next steps. Walter Dellinger, the former U.S. Solicitor General we talked about earlier, has been working with the Gore team now diligently for more than a week, getting ready for these next constitutional showdowns. They've got Lawrence Tribe waiting in the wings. They have been preparing their arguments. As a matter of fact, I spoke today with a member of the Gore legal team who told me that they were already prepared to fight this injunction stopping the recounts. This was before they knew that the Florida Supreme Court would rule in their favor, and before we know for sure that the Bush campaign would try to stop it with a court injunction. So they have been working on separate tracks here. They had a team of lawyers working on this case before the Florida Supreme Court, and they had a separate team working on the next steps.
Jonathan Curl, Candy Crowley, as we saw and heard, William Daley, the campaign manager for Vice President Gore, has addressed the nation, indeed the world. And as we've seen in this unfolding story, when one major spokesman appears, shortly thereafter, another one appears.
Usually, we'll be hearing from James Baker, who's the Bush team sort of main man overseeing the Florida events. So we'll hear from him shortly. I can give you a little reaction from the political arm of the Bush team. One top aide who has spoken with the governor, I said, well, just, you know, what's the gist of how you in the Bush campaign feel? And this person said, we've had every reaction imaginable in the last month. I am out of reactions. The common word, I'm told, around campaign headquarters was that it was unbelievable. And they said, you know, we didn't really know what to expect. Remember, this is the political arm, and they're taking their lead from the lawyers in Tallahassee. And they said, it's not fair to say we expected a victory or we expected a defeat. We didn't know what to expect, and yet we're all sort of sitting here in disbelief. There's a lot of logistics going on. Now, who do we need to send where? Where, you know, do we need more people back in Florida? We need to bring them up to Washington. How are we doing that? They're working that out. I will tell you also that they are taking great heart from the dissenting opinion of the Chief Justice at the Florida Supreme Court. It was pointed out to me, and I haven't read this, Bernie, you would know better than I, but it was pointed out to me that the Chief Justice said in his dissenting opinion that he did not believe that this particular opinion could withstand the scrutiny that will immediately follow under the U.S. Constitution. They say that the judge also warned, or the Chief Justice also warned, that he had a deep and abiding concern that this decision was going to propel the country and the state into an unprecedented and unnecessary constitutional crisis. So they are taking great heart in that dissenting opinion written in part by the Chief Justice at the Florida Supreme Court. Other than that, again, they believe that at least the political arm believes, from what they are hearing from their lawyers, that this decision does not have a basis in law. I would read that to believe that, of course, they're going to go on with an appeal.
Good evening, ladies and gentlemen. I know I don't need to tell you that this has been a rather eventful day here in Tallahassee. 2 circuit court opinions throwing out challenges to absentee ballots in Seminole and Martin counties. A federal judge ordering the counting of overseas absentee ballots in many counties that were not counted for technical reasons. And of course, the disappointing 4-3 decision of the Florida Supreme Court just announced, which will require manually recounting tens of thousands of non-votes and undervotes in all Florida counties that have not yet had a manual recount, and trying to do so by December the 12th. This is what happens when, for the first time in modern history, a candidate resorts to lawsuits to try to overturn the outcome of an election for president. It is very sad. It is sad for Florida. It is sad for the nation. And it is sad for our democracy. Today's ruling by 4 justices of the Florida Supreme Court is, of course, a disappointment. Its reasoning and result place the court once again at odds with sound judgments of Florida's lower courts, the Florida Legislature, local election officials, and, at least in our view, the United States Supreme Court. This action will unfortunately produce ongoing uncertainty, and it could ultimately disenfranchise Florida's votes in the Electoral College. The ruling of the Florida court's 4 justices is flawed in much the same way, we think, as its November 21 ruling that was vacated unanimously by the United States Supreme Court. Let me read you what Chief Justice Wells said in part of his dissent today. He said, "I believe that the majority's decision cannot withstand the scrutiny which will certainly immediately follow under the United States Constitution. The majority's decision to return this case to the Circuit Court for a count of the undervotes from either Miami-Dade County or all counties has no foundation in the law of Florida as it existed on November 7, 2000, or at any time until the issuance of this opinion." He further said, "The prolonging of judicial process in this counting contest propels this country and this state into an unprecedented and unnecessary constitutional crisis. I have to conclude," he said, "that there is a real and present likelihood that this constitutional crisis will do substantial damage to our country, to our state, and to this court as an institution." That was Chief Justice Wells of the Florida Supreme Court in his dissent. Obviously, we agree with the 3 justices who dissented from the action of the other 4. We think this ruling is inconsistent with Florida law, with federal law, and with the United States Constitution. Therefore, we have no alternative other than to appeal once again to the Supreme Court of the United States for relief. We have already put in motion the process to do that. Yes.
Chief Justice uses the word constitutional crisis. If this court ruling stands, is it Governor Bush's position here that this would create a constitutional crisis, and why?
Well, the Chief Justice has said it would create a constitutional crisis. At the very least, it creates sufficient uncertainty that I don't think that anyone could assure you that there is any certainty whatsoever that Florida's electors will have the benefit of the conclusive presumption provided by Title III, Section 5 of the United States Code with respect to whether or not they could be challenged if the issue ever came up. So, the end game has to take place by the 12th of December for Florida's electors to have the benefit of that conclusive presumption.
So do you see this decision then as somehow apart from the others, that there's been a change here, that there's, as opposed to that you really see now that we're on the verge of a crisis if this is not overruled?
Well, I don't think it's quite as important what I think as maybe what the Chief Justice of the Florida Supreme Court said. He's the one who said that. Obviously, we will, it seems to me, have a difficult time knowing by December the 12th whether or not the actions that are called for by the 4 justices can be concluded, and if they're not concluded by that time, there's a serious possibility that Florida's electors will not be entitled to that conclusive presumption. Yes, sir.
Isn't there, we have reports already that counties, some of these 63 counties, are already trying to start to count them, go in the count, and most likely won't be done by, say, Tuesday, you could figure. Aren't we going to be in the same situation then of having votes not counted? And
I think it's very likely that we will be in the same position of having votes not counted. We will also be in the same position that faced Judge Saul's below and that faced the Supreme Court in this appeal, and that is the provision of Florida law that says a partial recount cannot be accepted. But as my statement indicated to you, we think we're in the same position we were before the case went up from the Florida Supreme Court to the United States Supreme Court the first time. The law of Florida, as outlined by the legislature before the election, has been changed in order to, it would have to be, in order to give effect to the actions that have been ordered today by the Florida Supreme Court. Now, you've had a couple. Let me go over here.
Secretary, have you spoken to Governor Bush, and can you give us any indication of his reaction?
I've spoken to Governor Bush several times today. I spoke to him early this morning. I spoke to him after the results of the Seminole and Martin County cases were announced, and I've spoken to him in the aftermath of the Supreme Court's 4-3 decision, and obviously he was a good bit happier after the Seminole and Martin decisions than he was after this 4-3 decision for the same reasons that I've just outlined here for you. But Governor Bush is in fine spirits and quite prepared to see this through to its ultimate conclusion, because he feels very confidently that he has won this election and won it more than one time. As a matter of fact, right here in Florida, over a count, a recount, a manual recount, and perhaps another recount. Mike?
Mr. Secretary, some state lawmakers, Republicans, believe this decision is politically based, not legally based. Do you agree?
I've criticized the decision here, and I've tried to do so in temperate terms on the basis of the law, because I think it can be criticized on the basis of the law. I do not suggest that it is politically based, and I do not criticize it on political grounds. I think it is very vulnerable on legal grounds for the reasons I've just outlined.
Mr. Secretary,
yes, sir.
Have you been directly in touch with members of the Florida legislature? And if so, does this now lend more urgency to what they're doing?
Well, let me tell you, I haven't talked to anybody in the Florida legislature that I know is in the Florida legislature, other than I was introduced, I think, very briefly over in the offices where we're working, maybe on the 9th or 10th of November when I first got down here, to Senator McKay. Never met the Speaker, and I've never talked to anybody else in the Florida legislature. But I want to suggest to you that somehow the idea that it's inappropriate for us to talk to Florida legislators who happen to be of the same party or opposing party that we are is, I don't understand that. There's no reason, particularly since the Constitution itself, the United States Constitution, is what provides for the possibility of action by the legislature. The legislature is going to do whatever the legislature decides to do, but this certainly does create a great deal more uncertainty. And I would refer you also to the United States Supreme Court's opinion sending this case back, the first case back, to the Florida Supreme Court, when they themselves said the legislature has plenary powers in these matters. But in terms of my being in close contact with legislators, no, I'm not.
Secretary Baker, one quick thing. The 11th, we are told now just that the Bush campaign has filed an emergency appeal at the 11th Circuit Court. Can you tell us about that?
I cannot. Nope, I cannot. I haven't. I've been focused on the other cases that I mentioned today, but I have told you that we are in the process of appealing this ruling to the United States Supreme Court for the reasons that I've outlined here in some detail. Now, I'll take one more question, then I got to go.
Secretary, in a way, all these rulings seem to be saying the same thing, that you count votes even if there are procedural problems. Why is the Supreme Court ruling so different from the others? By your lens.
I'm not sure I follow what you're saying.
That you have votes, you count them. If you can discern the will of the voter.
I think everyone would agree that when you have votes, you count them. And here, we've counted them at least 3 times. It is not accurate to say these votes have never been counted. We hear that all the time from the other side. They have been counted. They were counted on election night. They were counted in the automatic recount. They didn't register many times, I'm sure, because nobody punched their stylus through the ballot card. But I don't think accurate to say that means they haven't been counted. They have been counted at least twice and maybe 3 times. Thank you.
James Baker speaking for Texas Governor George Bush, bristling with contempt, disappointment, and very controlled anger. He said the 4-3 ruling by the Florida Supreme Court is disappointing. He said the ruling is flawed. It is inconsistent with Florida law, he said, with federal law and the United States Constitution. We have some breaking news to report to you. Correspondent Mike Betcher actually posed it when he asked the question of Secretary Baker. Let's go to Atlanta and Charles Ewey. Charles.
Bernie, Secretary Baker didn't have any details about what the Bush people were doing. We have it. This has just been filed just minutes ago with the 11th Circuit Court of Appeals here in Atlanta, asking for an emergency temporary injunction that the court here block the counting of any sort of votes and ballots down in Florida until the U.S. Supreme Court can decide whether it will grant certiorari, whether it will hear the case. The attorney, James Bobb Jr., who was one of the attorneys who filed a suit that the 11th Circuit Court of Appeal turned aside earlier in the week, repeated many of those same arguments in filing for this temporary injunction. We're told by the court personnel here that there are judges still in the building. There is no indication at this hour on when or if they'll act on this request for a temporary injunction tonight, but the bottom line is that Republicans are moving immediately through the federal court system, first to the appeals court here in Atlanta, to try to get them to stop any sort of handling of the ballots whatsoever in Florida until the U.S. Supreme Court decides whether it will hear all of these issues. Bernie?
Okay, Charles, a couple questions now. Secretary Baker indicated that the Bush team had already put into motion, his words, their effort to fight this 4-3 ruling by the Supreme Court. They want an emergency action by the 11th Circuit Court in Atlanta until the Supreme Court decides whether it's going to take that case. So presumably they're going to go a step further coming here to Washington, are they not?
They indeed. That's exactly what they want, Bernie. It only takes one judge to issue that temporary restraining order to stop things down in Florida until the U.S. Supreme Court, until the justices of the Supreme Court in Washington can decide whether they're going to hear it. And they're repeating many of the same allegations they made in a hearing here earlier this week, some of the same allegations we've already heard, that the vote count, the hand recount, dilutes the importance of the votes from other voters in Florida, and that it is unconstitutional and illegal, and it should be stopped. They are repeating those arguments tonight in the request for a temporary restraining order, saying that the U.S. Supreme Court...
Is he doing a news conference?
Sir?
Okay, thank you, Charles Ewey in Atlanta. We're going to go now to Leon County in Tallahassee for a news conference by Terry Cass.
Absolutely, all of our stuff is random.
Terry, because of the judge's recusal, because of his decision not to hear this, so no decisions have been made yet about the count here in Leon County?
That's correct.
And a hearing tonight?
We are also reviewing the Supreme Court order on that.
Terry, how many votes will you be counting? Do you have a number of expectation how many votes?
Our understanding is the undercounts. We go by the Supreme Court opinion, and I believe it's laid out in there.
So tonight's hearing, the judge will be determined to start making decisions about this case?
Absolutely. There will be a judge sitting on that bench at 8 o'clock this evening.
Are all the ballots?
They're over the Supreme Court.
Do you have a venue set?
No, the ballots are not here as of yet that we're aware
Can you tell
of.
us how the ballots, you intend to move the ballots?
We don't have any information
No,
about
and that
any of
would not
right
be
now.
us.
But they're at the Supreme Court building.
Please come at 8 o'clock. We'll have our case management hearing. Thank you. 8 o'clock, 3D, courtroom 3D.
Okay, Leon County Administrator Terry Cass. If you missed the top of what was said, the news here, and this is really eye-popping news in terms of developments in this unfolding story, Judge N. Sanders Saul apparently has recused himself after suffering quite a reversal by the Florida Supreme Court in a 4-3 ruling. Bill Delaney, you're there. Bring us up to date. Bill, can you hear me? We see you, but can you hear me? If not, we'll come back to you very shortly.
Okay.
Gary Tuckman is on the telephone.
That's right, Bernie. Right now, I'm inside the Leon County Courthouse, and you're right. N. Sanders Saul has recused himself from the case. We asked why he's recused himself. They said they don't know. But what that means is absolutely no decisions have been made yet about how to proceed with this recount. This is where those 9,000 contested undervotes are from Miami-Dade County. It's the votes the Gore team wanted counted the most, and there's no idea how to start it yet. And this is an important point. Just before this news conference, 2 of Al Gore's lawyers walked into this courthouse, Dexter Douglas, and they came in and they said to the attorneys here and to the clerk's office that they were going to file an emergency motion asking for those votes to be counted immediately. They say they cannot wait till tomorrow for the votes to start being counted, so they have filed an emergency motion with the circuit court for the votes to be counted immediately. But as of now, there's no one here to make any decisions, so a hearing will be held tonight at 8 o'clock Eastern Time in the courthouse to appoint a judge in this courthouse to take control of these proceedings, which are taking a turn about every few minutes. Bernie?
Very, very interesting. Have you been able to talk, Gary, to any of the people on Judge Saul's staff?
Yes, we've been talking to the court administrators here who deal with Judge Saul's all the time.
Well,
and I should tell you, Bernie, they have talked with him on the telephone, and we had been told about an hour ago that there was a possibility he would recuse himself. We asked, if he's recusing himself now, why wouldn't he have recused himself before this case even started? And they said they really didn't know, and they don't know why he's recusing himself.
Okay.
Bernie,
Judy, did you have something?
Yes, I'm told that our senior analyst, Jeff Greenfield, in New York has some information for us on Judge Saul's decision. Jeff?
Well, if you remember a while ago, we talked about this extraordinary story that appeared in the New York Times today, in which Judge Saul's wife very bitterly criticized the Florida Supreme Court for how it had treated her husband, Judge Sauls, in a case involving his tenure as a chief administrator on that county circuit. And while I think it should be obvious that I have not talked to Judge Sauls, I think we can at least put on the table the possibility that that front page story on the New York Times indicating a deep division on both political and personal grounds between Judge Sauls and the Florida Supreme Court may well have propelled Judge Sauls to say, look, they've just reversed me. The majority had some very tough language about what I did. It's now on the record in public that the Supreme Court and I have had deep differences, that there's some really bad feelings. It's probably best that I step aside. I can't say for sure that that is the reason, but if you're looking for plausible explanations, that's high on the list.
It also reminds us, Jeff, when that case first went to Judge Saul's courtroom, it was the attorney for the vice president for Al Gore, David Boies, who, when Judge Sauls hesitated to order an immediate recount, which is what the Gore people were asking for, Boies turned to the state Supreme Court for immediate relief. So
That's
Sauls had that in his face, in effect, for several days, and yet he kept hesitating for his own reasons and saying, no, I want to go about this in an orderly manner.
And one other point, as we're getting reaction, and you heard former Secretary Baker describe his own reaction as temperate and not focusing on the politics of it. He said, I haven't criticized the Florida Supreme Court except on legal grounds. Listen to what House Majority Whip Tom DeLay had to say by contrast. He said that the majority distorted the judicial process into nothing more, this is a quote, than a mechanism for providing Al Gore with the victory he was unable to win November 7th. And then he said, the Florida Supreme Court has squandered its credibility. This judicial aggression must not stand. So while Secretary Baker is striking perhaps a temperate note, the third-ranking Republican in the House has quite a different tone.
All right, Jeff Greenfield in New York. We are going to, unless, Bernie, you have something else right now.
We're going to pause for a commercial break, and when we come back, Bob Novak will join us.
Because Judge Sauls seemed to be rather skeptical of the broader standards, the ones that were used in Broward County, when Judge Burton from Palm Beach County, who used a reasonable standard. What they did, Tony, was they looked at the ballots and they said, okay, if you punch out every Chad in all other races except president, and there's some mark on that ballot, It's clear that you knew how to punch out the chads. It's clear that you knew to punch out the chads. It's clear the ballot was in the right place. So a mark by the presidential candidate does not stand as a vote for president because you voted correctly in every other race. Now, they use the opposite standard in Broward County where they said, well, if you voted a straight Democratic ticket, then if there's some mark up by the president, clearly you intended to vote for the Democratic candidate for president. So two very different standards. When Judge Burton was on the stand in Judge Saul's case, he noted at one point that he had been blamed a lot for the way they had counted votes, and Judge Saul said, no, I salute you as a great American. It was clear that Judge Sauls thought that Judge Burton and those in Palm Beach County had exercised the correct interpretation of the law. The interpretation of the law, as set out by the Supreme Court and in Florida statutes, is if you can discern the clear intent of the voter with a reasonable certainty. Now, that is obviously open to enormous subjective differences, and there were huge differences between Broward County and Palm Beach County. Now we are going in here, as Justice Wells noted, handing over the vote counting to people whose qualifications and objectivity are not quite clear to anyone and asking them to count. And we've asked people before, if you were to go to a recount, how do you know what standard, if you're appointing people from the county clerk's office or whoever you're asking, how do you know that they'll all employ the same standard? No one can answer that question yet. We will see how many people are assigned to this, how fast they intend to do it, and of course, what they ultimately say the standard was. So still, lots of questions, but it is potentially damaging to George W. Bush to lose Judge Sauls, who seemed to think that the way Palm Beach did business was the right way to do it. We'll see what other judge we get. Tony?
Okay, Jim, is your understanding, based on what you just heard, that basically the judge in charge is the person who's going to be making up the standard?
Well, the standard is set out by the court and by Florida statutes. How do you interpret that standard is the question. And obviously, as we were saying, Broward County interpreted it one way, Palm Beach interpreted it another way. And every time I've talked to Gore lawyers, they'll say, well, the standard is you have to determine the voter's intent. Well, obviously, there's a big difference there. There's a huge difference. Now, the Gore people have argued, at least in public, but not necessarily in court, that dimpled ballots, that all of these legal cases indicated that you have to count dimpled ballots. That is not quite true. And when you question them, what they say is, well, you must.
And colleague Bob Novak joins us now. Bob, why is it so important to the Bush campaign to try to shut down any recounting of ballots?
Bernie, the Bush people that I talked to after this decision by the Supreme Court, they indicated that they would be just as tough as the Gore people were. They weren't going to retreat, but they were very worried about the recount starting because, as the Gore people have been saying for a week, once you start the recount, you can't stop it. And all these deadlines are not very important. Doesn't matter how long it takes. So what we have tonight is like something out of a movie. We have the Gore lawyers saying, start the recount right now, 8 o'clock. We don't have any standards. We don't know who's going to count. We don't have any training for the people. But start counting one way or the other. And at the same time, very dramatically, the Bush people are going to the federal court, the circuit court, the Court of Appeals in Atlanta, and asking for an injunction to stop the counting. So it is a critical tactical move on both sides with a tremendous tension of whether it really begins or not.
And of course, as we report right now in this breaking story, there are a lot of things going on. You have the 11th Circuit Court of Appeals in Atlanta. You have the United States Supreme Court and whether and when it will get involved in this. And you have Mr. Justice Kennedy, who presides over the 11th Circuit. Presumably, there's going to be some back and forth in the next 24 hours.
You know, Bernie, as tough as the Bush people are that I've talked to a few Republican politicians and supporters, and they're a little shaky, just as the Gore supporters were shakier than Gore. And they just wonder whether you can really elect a president if you get into this an effective president, a legitimate president, if you get into this ballot counting, if he is elected by the Florida Legislature, which is going to go ahead anyway, then you have the process in Congress. So the question of whether you have an official recount of this ballot, even if they break the deadlines, is very worrisome to many Republicans. But it's my feeling that George W. Bush is going to be just as tough as Al Gore and saying, we don't care what the mamby-pambies and the spineless ones think, we're going to go ahead with it.
Fascinating, compelling. Bob Novak, thank you. Judy.
All right, CNN's Chris Black. Chris Black, I think it's fair to say that the Gore people are facing of out-and-out revolt on the part of Republicans over this in the courts, politically, from every angle you can think of.
Judy, there's no question Democrats and Republicans alike here on Capitol Hill are just stunned, and they're steeling themselves for this bitter presidential race to come to Congress to decide in January, what both sides call the doomsday scenario. First, Republicans, you're right, they're furious. They had left Al Gore for dead on the battleground. They thought this presidential race was over. Senator Tim Hutchinson, a Republican from Arkansas, described the court ruling today as unbelievable, quote, a tragic decision. And he said there's not enough time before the December 12th date for choosing electors in Florida for those ballots to be counted.
I think there's no way you can complete a manual recount in all 67 counties, even on the undervote, by December 12th. So you're going to have contested slate of electors possible, and if that be the case, then you're likely going to have Congress involved.
Now, Republicans are also extremely critical of the Florida Supreme Court. They're calling it liberal, biased, and that real dirty word among conservative Republicans, activist. Senator Phil Gramm, the Republican from Texas, said that the court overstepped its authority and warranted a second visit before the U.S. Supreme Court.
At a court that was just warned last week about writing law rather than interpreting it, has written a lot of election law in this decision today. It's going to come next week to the Supreme Court. I believe the Supreme Court will overturn it, and that'll end this whole issue and settle the election.
Now, Democrats are equally surprised. They had thought this race was over. They were resigned to the fact that they thought Al Gore had lost, and there was no way he was going to get a successful court ruling in Florida. They say that the recounts of the votes should proceed as quickly as possible. And Senator Pat Leahy, the Democrat from Vermont, said that both sides should step back and respect the courts.
Remember, this is not who's got an advantage in the Congress or who has an advantage in the state legislature. This should be, who do the American people vote for? Did they vote for Al Gore? Did they vote for George Bush?
Now, Republicans, though, are fixing for a fight. They're showing no signs of respecting the decision of the courts or accepting any recounted ballots. And in fact, this week, Republican senators received a glossy briefing book on the historical precedents of Congress deciding presidential elections. And it included a very interesting speech by the last incumbent vice president who had to call the race for his opponent. It was Richard Nixon in 1961 saying that John F. Kennedy had won the race. Judy?
All right, Chris Black. And on that historical note, we will continue our coverage of these extraordinary political developments in just a moment. This expanded edition of Inside Politics will continue. When we come back, we'll have an interview with Democratic Representative Harold Ford of Tennessee and Republican Senator Kay Bailey Hutchison of Texas. If you're just joining our coverage today, late this afternoon, the Florida Supreme Court has given a major boost to Al Gore's hopes of winning the presidency by, in effect, cutting George Bush's lead in the state of Florida to just 154 votes and ordering a manual recount of ballots that had not been counted by hand. It had been counted as machine and so far counted as no votes or undervotes. Joining us now to talk about these surprising developments, to put it mildly, from the state of Texas, Republican United States Senator Kay Bailey Hutchison, and from the state of Tennessee, Democratic Congressman Harold Ford. Senator Hutchison, to you first. Should the ruling of the Florida Supreme Court be respected and abided by? Well, certainly there is an appeal from the Florida Supreme Court into the federal courts and to the United States Supreme Court. The United States Supreme Court remanded the previous Florida Supreme Court ruling because they didn't think it had a basis, or they wanted to see what the basis was, and the Supreme Court has not yet established the basis for changing the law after the election. So are you saying everything's on hold, that it should not be, that the vote count should not begin? Oh, I think that it's going to be very difficult to know what the standard is. The Supreme Court did not give a clear standard for determining the intent of the voter, and I don't see how you can have recounts when the people don't even know what the standard would be that would make every vote count the same. Congressman Ford, you hear Senator Hutchison and others saying, how can you count ballots when you don't know what the standard's going to be, or when there's a different standard for each county?
Well, one thing we do know, Ms. Woodruff, is that people went to the polls in Florida in all of these counties and tried to cast their vote in all of the elections there in Florida, and probably the presidential election as well. And if the will of the voter is going to be controlling, and Ms. Hutchinson, I would imagine, agreed with Mr. Richards' argument before both Judges Clark and Lewis there in Leon County when they decided not to throw out those ballots because you can't disenfranchise voters. I agreed with that opinion. I would have to think and hope that my Republican friends would want to ensure that whomever the next president is the person who actually received the most votes. And we're going to have the opportunity to find that out. I think the court has set a standard. I understand that Judge Saul's, I believe, I've not seen the reports, might have recused himself from overseeing this. I would have to hope that the next judge or whomever is charged with overseeing this would do it in a fair way and try to ensure that every voter in Florida has their voice heard. That's what distinguishes us as a nation, by allowing the people, the governed, to elect the governed, and fortunately that will be the case in Florida. Senator Hutchison, why is that an unreasonable argument? It's not an unreasonable argument. We do want every vote to count, but Florida had about 1.5, 1.6% of the people who chose not to vote for president, and other states had more than that. Why do we assume that because someone didn't vote for president that they meant to? Why do we want to go behind what is on that ballot and see if there is some kind of a dent but not a real vote, and try to examine whether the person changed their mind or decided not to vote for either person? Well, that's what this hand count will help determine. I'm not afraid of whatever the outcome may be. I would be afraid if we allowed George Bush to assume the presidency and the Miami Herald or some other reputable organization like CNN actually counted those votes, and we learned that the actual victor was Al Gore. We should all want this, and I can live with this outcome, and I can assure you so can Al Gore, and I would hope George W. Bush could live with the outcome as well. We'll know in a few days whom won Florida's popular vote. Al Gore won the nation's popular vote, and he might have won Florida's. He might not have, but one thing is for certain, we'll find out soon. Judy, I think you've made news. Maybe you can be the arbiter here and count these votes. I'll do it if you'll do it, Senator. Senator Hutchison, is there a concern? Do you have a concern at all, though, that by going to every length here to stop this count, or I should say to prevent this count from even getting started, that it does put Governor Bush in the position of saying, we don't want to know what's on what these ballots show? Well, I think the problem is you have already seen two counties that had very different standards, so that the people who voted in those counties don't have an equal access. I think there is a federal issue of equality here, of equal protection under the law, due process of law, and I don't think you can start a count and have a different standard in one county than the other, and intent of the voter is not a clear standard. But Congressman Ford, evidently very clearly, the Florida State Supreme Court thinks differently, or at least a majority does. I think there are two points here. One is whether or not the votes ought to be counted, and I think the senator raises a point regarding the standard, and I think those issues can be resolved. We saw Broward County apply a standard. I think the candidates can agree on a standard, and the court, I think, has laid out pretty clearly in its decision. I've not read it all, but I think they've laid out, from what I understand, what that standard ought to be. Let me also add, I think Governor Bush has every right to appeal this at whatever level he chooses to. I think he ought to be careful, though, to criticize the Florida Supreme Court and label it, he and Secretary Baker, who is a respected statesman here in this nation, as a partisan move on the part of this court. Democrats refrained from doing that when Judge Sauls made his decision, and we certainly refrained from doing that at the U.S. Supreme Court level when they vacated the decision. Allow the rule of law to work and allow the people to be heard. And at the end of the day, not only will we know who our president will be, but America will actually win and the voters will be heard.
Senator Hutchison, I want to read to you what the Florida Supreme Court majority said in its opinion. It said the vote it said, the standards to be employed is that established by the legislature in our election code, which is that the vote shall be counted as a legal vote if there is, quote, a clear indication of the intent of the voter. Why isn't that simple?
Because some counties decided that you could have a dimpled ballot that was fully voted in other races, and other counties said, no, it would only be counted if the whole ballot was dimpled, so that there was some inability for the voter to be able to do that. Those are two very different standards, and the votes in those counties were treated differently. I think the legislature did not set a clear standard, nor did the court, and I think therein lies the federal question of due process or equality of treatment.
Ordinarily, when the state legislature doesn't set a clear standard, it's the Supreme Court of that state's responsibility. I'm interested in hearing Ms. Hutchison because this seems to sort of stare down the argument that many of my Republican friends have that state law and state rules ought to rule the day. I guess there have been a lot of changes here in this campaign. Ms. Woodruff, we want the votes counted, and the votes will be counted, and we'll learn who the winner will be, and I can accept that. Hopefully George Bush can, and I can assure you Al Gore will be able to as well.
I think the legislature is going to be the final word. I think the Constitution is clear that they are the elected representatives of the people, and I think they will have the final word on this.
We have three branches of government, and I hope the legislature respects that third branch, and I would hope that the Bush campaign, in its zeal to see George W. elected, would not do any more damage to our Constitution. I'd say any damage. I don't mean to accuse any of the campaign of doing any damage, but of doing any damage to the Florida Constitution or the U.S. Constitution. If it goes to the U.S. Supreme Court, I sat in that argument last week. I trust that the U.S. Supreme Court will render a fair and impartial judgment, and the real winner will become our president.
All right, we're going to have to leave it there. We thank both of you for joining us.
Thank
Congressman
you.
Harold Ford from Tennessee, Senator Kay Bailey Hutchison from Texas.
Thank you, Judy.
We are going to take a break. We'll be back with more of our expanded coverage of this extraordinary day in American politics.
In Florida, at this hour, 7 p.m. Eastern Time, there is some confusion about when the state Supreme Court's order to hand count some 43,000 disputed ballots will be carried out. Circuit Court Judge N. Sanders Sauls, whose ruling was overturned earlier today by the state high court, has recused himself. Judge Sauls recusing himself from overseeing the recount. A hearing is set for 8 p.m. Eastern to decide how to proceed. CNN will carry it live. Al Gore's campaign is asking for the hand count to begin immediately, now that his contest of the Florida vote has been upheld by the state Supreme Court. The justices also ordered the results of already conducted hand counts to be included in the official vote tally. That would shrink George W. Bush's lead in Florida to 154 votes, down from his certified total of 537 votes. A short while ago, the Bush camp confirmed it will appeal the decision to the United States Supreme Court. In the meantime, Republicans have asked a federal appeals court in Atlanta for an emergency injunction blocking any new recounts.
This is what happens when, for the first time in modern history, a candidate resorts to lawsuits to try to overturn the outcome of an election for president. It is very sad. It is sad for Florida. It is sad for the nation. And it is sad for our democracy.
This decision is not just a victory for Al Gore and his millions of supporters. It is a victory for fairness and accountability and our democracy itself.
There is a considerable sense of urgency in all this, as you know, since Florida's presidential electors are supposed to be certified on December 12th. just 4 days from now. Now, let's go live to Atlanta and correspondent Charles Ziwi at the 11th Circuit Court of Appeals. Charles.
Bernie, Republicans, 3 of them, and on behalf of George W. Bush, as an intervenor and appellee, have come here to the 11th Circuit Court of Appeals and asked this court, in effect, to tell everyone in Florida, wait, stop. Wait until the U.S. Supreme Court decides whether it will hear this issue. James Bobb Jr., who was before this court earlier in the week trying to get the recounts thrown out along with Bush attorneys, filed an emergency motion for a temporary restraining order here with the 11th Circuit Court of Appeals, asking the appeals court to stop any handling of the ballots, any sort of hand recount, until the U.S. Supreme Court decides whether it will hear this case. Bob filed the emergency motion on behalf of Robert Touchstone, Deborah Shepard, and Diana Touchstone, 3 residents of Brevard County, that's Orlando, and George W. Bush, as I said, as the intervener and appellee. The operative phrases in this motion being filed tonight: voters pray for an injunction from the county and state defendants from conducting, certifying, or accepting the results of a manual recount in Florida. And Bob has already filed a writ with the U.S. Supreme Court, asking the court to hear an appeal from the court's decision here in Atlanta earlier in the week, in which the appeals court turned aside claims by both Bob's group and the Bush lawyers that the recounts in Florida unconstitutionally dilute the strength and importance of voters' ballots in Florida. In his motion filed with the High Court, Bob says, because their votes have been diluted by manual recounts under Florida statute, which creates an unconstitutional 2-tiered system for standardless, he says, reconstruction of votes in selective counties, voters are irreparably harmed. And he's asking for this court to stop everything until the High Court in Washington makes up its mind what it's going to do. Bernie?
Charles, in terms of mechanics now, explain to us what happens next there in that building behind you.
Well, that's what they're trying to decide right now, Bernie. The clerks are in there. We know there is at least one judge of the 12 judges here on the appeals court. At least one judge is here inside, and we don't know what they're going to do. It only takes one judge, we're told by the clerk's office, to grant a temporary injunction. If a temporary injunction is issued by the court, theoretically, that would stop everything until the justices in Washington decide whether they're going to take this case and hear it. A lot of the same arguments are being made in this motion tonight and in the writ for certiorari in Washington.
Charles Ziwi in Atlanta with the very latest there at the U.S. Circuit Court of Appeals, the 11th Circuit. Judy.
Well, one of the places that vote counting would get started, if it were to begin, would be in Leon County, Florida, the county where the state capital, Tallahassee, is. Our own Bill Delaney is there at the courthouse. And Bill, we know that the circuit judge, Sanders Sauls, has recused himself. Do we know at this point which judge will take his place and how soon any counting could get underway?
Judy, we don't have a clear answer to either of those questions. To the first question, which judge might take his place, I was told about an hour ago by Dave Lang, the longtime clerk of the circuit court here, that it was his understanding that Chief Judge George Reynolds would take the place of Judge Sanders Sauls should Judge Sanders Sauls recuse himself, as he has now done. But that's not for sure. We're not certain that will happen. We expect a hearing on that at 8 o'clock tonight Eastern Time, about an hour from now. Also, I should mention here, the Gore Campaign has filed, advocates for Vice President Gore have filed an emergency suit here in Leon County Circuit Court right now to begin counting votes right away. Problem with that is there's really not a mechanism here yet that we know of to count the votes. Now remember, when the Florida Supreme Court threw this back at George Sanders Sauls, they said, okay, now you're in charge of figuring out how to count votes. What has to be counted here in Leon County? 9,000 disputed votes from Miami-Dade. Those ballots are here and will be counted here in Tallahassee. But in the Florida Supreme Court's order, there was much more than that. The Florida Supreme Court justices charging Sanders Sauls, charging the Leon County Circuit Judge with figuring out how to count some 43,432 undervotes in as many as 64 other counties in Florida. They have to figure out how to do that here. They won't do it here, but they have to figure out a way to do it. Now, Dave Lang, the longtime circuit court clerk here, said, Judy told me about an hour ago, they did have a contingency plan for this sort of thing in place. This is what could happen. It's not definitely what will happen, but it's what this longtime clerk of the circuit court suggests may happen, and that would be 32 teams of 2 people each, deputy clerks, would begin counting, likely in the public library just down the street from the county clerk's office here, but no sooner than tomorrow. He suggested that even with the Gore emergency request for immediate counting, they would want that counting, they would want to give everybody a good night's sleep, and they get started on this again tomorrow. Yes, we're talking about people holding up ballots to the light. Judy.
But Bill, that would
Judy,
indeed
I'm told we're going to...
Go ahead, Bill.
I'm told we're tossing to a press conference now.
No, not at all. Not at all, because regardless of whether he was in his office or not, we have an obligation to call that judge. So I would have called his home.
The 8 p.m. case management conference, or is there a prior meeting?
No, no, at the 8. That's right. All of you will be there too.
When you say judge,
I'm sorry?
she was unavailable to his case, or she was unavailable to
No, she just found herself unavailable to hear this case.
She was contacted.
When you said judge,
yes. Yes.
When you said Judge Cook is unavailable, you unavailable tonight or unavailable?
No,
for
unavailable for this case.
Is that because of the full docket or why?
There might have been several reasons that went into that, and I did not ask her reasons. She just told us that she was unavailable.
There's going to be a camera permitted into that case management meeting.
I'm sorry?
A camera permitted into that case?
Yes, full.
Situation that we've had in the past. We'll carry it out to the mulch box over here out of the 5th floor office building, and we'll have the standard complement of still photographers. What's that?
Lewis. Terry Lewis.
No, actually 3D is substantially larger than 3C. Yeah, it's the largest trial, basically.
Yeah,
trial.
and it has the most seating for media and for the general public.
Right, so, all right. We'll see you tonight at 8 o'clock.
Thank you.
Terry Cass, who is the administrator there for the county, for Leon County, answering some reporters' questions. We weren't able to hear all those questions, but they clearly were about the process that they are struggling with right now to figure out where, when, how to begin this process that the state Supreme Court of Florida has ordered to take place, and that is the manual counting of votes, so-called undervotes, no votes, across the state of Florida. CNN, we want to turn now to someone we've been using as a resource throughout this month-long post-election process, David Cardwell, former Florida elections official. David, this is very much, it seems to me, a race against the clock. On the one hand, you've got the Bush people going to a federal appeals court in Atlanta saying, don't let this counting begin. On the other hand, you've got people scrambling there in Leon County trying to figure out how to get it started.
Well, that's true, Judy. In fact, what's going on today reminds me of the death penalty cases a few years ago when you had lawyers running from one court to the next, federal and state courts, with getting stays or emergency motions. I mean, it's really taking on a momentum of its own almost as we race against the clock. In Leon County, they're going to have to count 9,000 ballots, the undervotes from Miami-Dade County. And while they do have a contingency plan in place, one thing we should keep in mind is that at least in Miami-Dade County, the election workers there who were primarily on the counting teams that were counting the ballots were familiar with the vote system. They were familiar with the punch card ballots. Leon County does not use that system. They're not going to be as familiar with this system. That may slow down the count a little bit. Judge Burton in West Palm Beach had told us they could get in about 300 ballots per hour per counting team. So we'll see if they can maintain that pace. But what's probably the most time-consuming effort is going to be the other 64 counties other 63 counties in the state. They're going to have to determine if they had any undervotes, and if so, to proceed with recounting those. Some of those elections officials may not even know that the Supreme Court has told them to count their undervotes right now.
Yeah, David, I looked at, there was a report on the Supreme Court ruling on that, and I believe I saw instead of all 63, 65 counties, they were talking about a few dozen counties, but with a total of something like 43,000 ballots that would need to be looked at.
Well, all the counties are going to have to determine that they did not have any undervotes. Now, the counties that use either paper ballots or lever machines, there's no way they'll have any undervotes, so we don't have to be concerned with them. But the counties that use the punch card system, there's about 27 of those, and we can discount the 3 of Palm Beach, Dade, and Broward, so we know that there's at least in there's 22, 24 counties they're going to have to go ahead and conduct recounts. And 3 of the next largest counties in the state, that being Hillsborough, Pinellas, and Duval, which is Tampa, St. Petersburg, and Jacksonville, use punch card systems, and they all have to go through this manual recount.
All right, David Cardwell, thanks very much. We're going to go to a break. When we come back, more of our continuing coverage of this stunning set of developments on December the 8th in the year 2000. We'll be back.
Here in front of his official residence at the Naval Observatory began to grow. People driving by honking their car horns in support. Officials in the Gore campaign say the Florida court has reaffirmed the central premise of Gore's argument that every vote should count and no one should be disenfranchised. And campaign chair William Daley was anxious to get the count started.
Let the count begin, not just of the votes yet to be counted in Miami-Dade, but as the court wisely ruled, in every Florida county where undervotes have yet to be counted. Then Florida and America will know with certainty who has really won the presidency.
Daley sent a message to the Florida legislature saying the election dispute should be decided by the judiciary and not by politics. He promised that Gore and Joe Lieberman would abide by the recount and called on George W. Bush to do the same. Gore has always felt that more Floridians intended to vote for him, perhaps attempted to vote for him. Reverend Jesse Jackson said after speaking to Gore after the Supreme Court ruled today, the vice president feels he can live with the results of the recount, whatever they may be. Shepard?
Wendell Goler outside the vice president's residence amid the crowds in Washington. So, what does it all mean? What now? Where does this go? Do we get something done by the 12th? And how do we get there? Answers from Tony Snow, let's hope. Tony, this thing has gotten more confusing than this mind can quite handle, I must admit.
Well, let's play some of the angles, Shep. Number one, the Gore team merely wants to count punch card ballot counties as opposed to all counties in Florida. A number of them use optical ballots that simply mean that you fill in something like when you're taking your SAT tests. On the other hand, the Bush team may say, hey, wait a minute, the court said do all the undercounts. That would mean all the counties. Now, there's kind of a buried treasure in there for Gore. There's a lot of speculation that there were a significant number of undercounts in Jacksonville, where there was a heavy Democratic presence, and that they may be able to scoop up a lot of votes there. So you're going to have a dispute over, do you recount all the counties or some of the counties? Another interesting wrinkle, as you saw at the bottom of the screen just a couple of minutes ago, Terry Lewis, who's a Leon County Circuit Court judge who twice has found against Al Gore, including just today when he was reviewing what was going on in Martin County, Florida. He is now going to be the presiding judge. He's the guy who's going to be setting the standards. We're likely to hear from him at about 8 p.m. tonight Eastern time. So Judge Lewis, who has not always been supportive of Gore, as I said, is going to be the presiding judge. I don't know what the dynamic is there. In addition, you have Bush appeals proceeding in the 11th U.S. Circuit Court of Appeals, where there's a hearing on it. There's a case pending that says that this madness, where every county has different standards by which to recount votes, is unconstitutional. It violates people's equal protection rights to have every vote count equally. In addition, you've got an appeal to the U.S. Supreme Court, which may actually hold an extraordinary weekend session to try to deal with this. So, Shep, if you expected me to provide any clarity, sorry, pal. There is no clarity right here. The word you used before, which was actually used in one of the dissents today in the Florida case, the dissent of Judge Major Harding, he said that this is going to create chaos, and I think that's what you've got. As we pointed out earlier, you really don't have any ballots yet in Leon County, where a lot of them are going to be counted. We now have a judge. We don't have standards yet, and you can be assured that we're going to have legal controversy. And whether this thing gets certified by the 12th, it's doubtful, which means the Florida legislature is going to end the picture as well. The only way I see this thing being tied up in a neat little bundle is if the U.S. Supreme Court were to step in and say to the Florida Supreme Court, okay, you went too far, you messed up. This time we reverse your decision, forget about it. You can't touch this case anymore. That's the only way it gets wrapped up in time for next week.
Possible now that one body of the legislature chooses the president and the other the vice president. We'll talk to Tony Snow about that and all those Republican counties as well in just a moment.
That is a most serious charge.
It is most serious, and I think it's natural in the heat of the moment for people to perhaps overstate the position, because I think all that Al Gore has asked for from the beginning was that votes be counted. And in this case, I think the Supreme Court came up with what seems to be a reasonable standard. They won't let Al Gore pick the counties for the recount. They've said any undercounts in the state of Florida in any county have to be recounted. I think that's a reasonable standard, and it really says that no one has won an election here. The most anyone can claim is they've won a recount.
Well, Mr. Baker obviously is saying that Al Gore is trying to do in the court of law what he couldn't do at the ballot box.
And I suppose Mr. Gore's response would be that Florida law provides for a recount. The deadlines under Florida law don't give you enough time to achieve it, and you have situations such as we found in the courts over the last several weeks that have thwarted every effort toward that recount. Every time we get close to the point of counting ballots, the Republicans head for a court to try to stop us.
One last quick question, very candidly. You told us at the beginning of this interview that Democrats had on their black mourning suits, but if Al Gore had lost in Tallahassee before the Florida Supreme Court today, what were you prepared to tell him?
I think everyone had said this, or at least most Democrats had said it on Capitol Hill this week. This was really the day of judgment. We had these two cases involving absentee ballots that went against Gore. The final decision by the Supreme Court, had that gone against Al Gore, I think it would have been the end of the game. But frankly now, we have a recount, and that recount should decide how the Floridians really wanted to vote in this presidential election.
And you're breathing easier tonight, clearly. Dick Durbin, Senator from Illinois, thanks for joining us.
Thanks, Bernie.
Quite welcome. Judy.
And joining us now, CNN's Washington bureau chief, who's been on the telephone, I think, almost constantly since this came down, except for a brief stint here in the studio when you were telling us what you'd heard up to that point. What are you hearing now, Frank?
Well, especially from Republicans, a real sense of anger, outrage, and that this is some kind of a partisan hijacking, citing the Supreme Court. Very, very harsh language from the House Majority Whip Tom DeLay this evening. I did not speak with him, but he did issue a statement. He's not doing much press. He's not standing in front of the cameras, but he said, and I'm quoting here, the Florida Supreme Court has squandered its credibility, violated the trust of the people of Florida. This judicial aggression must not stand. But you are also finding out there, Judy, some real concern that the anger expressed could step over the line, that where we now are is in such, as Senator Chuck Hagel put it, with whom I spoke, into dark, dangerous, and murky waters, that people may lose control of this situation.
People on both sides, or primarily the Republican side, or what?
Well, that it's unpredictable, Judy, that we don't know where the courts are going to go. We don't know how the count is going to be done. We don't know whether it's going to end up before the United States Congress ultimately. A number of senators, Democrats in the U.S. Senate, are agonized over this. Those who come from states that went heavily for George Bush, if they should have to vote in a situation, do they vote their party? Do they vote who the man who carried their state? But Chuck Hagel was very interesting, Judy, because he issued a blunt warning to fellow Republicans. He said, we've got to keep our rhetoric down, we've got to keep our heads down, we've got to reassure the American people here that there is a process, as agonizing as this is, as annoying as it is, that, you know, if there's any talk at all, it should be about that there's a Constitution and we can govern through the problem and will emerge on the other side. Now, I don't know that that's going to wash with people like Tom DeLay and others who are furious about this, and he's not alone.
And even Jim Baker in that quote, who said Al Gore has created a very, very sad situation for the country in contesting this election.
That's right. Many Republicans feel that Supreme Court was a very partisan move down there, and they feel that, as we heard from Jim Baker all the time, these votes have been counted again, recounted again, and that's that.
Frank Sesno. Bernie.
Thank you, Judy. The date, December 12th, is circled on many calendars as the time Florida must name its presidential electors. It is a significant deadline, but not one without some wiggle room. Senior Washington correspondent Charles Bierbauer reports.
And we don't have a remedy here that can do that by December the 12th.
What makes December 12th critical? Federal law says the state's electors shall meet on the first Monday after the second Wednesday in December. This year, that's December 18th. The code then says those electors shall be determined at least 6 days before the electors meet. Count back 6, December 12th. The date's not as absolute as Florida's court and legislature are treating it.
There's been a kind of snowball effect, and now you see everywhere people saying December 12th is the deadline. Well, it's not actually.
But if disputes over electors are settled by December 12th, 6 days before the Electoral College meets, the law says they are then conclusive, safe from challenge later by Congress. Courts call that a safe harbor provision.
It's nice if you can reach the safe harbor on time. But if you don't reach the safe harbor on time, you can still reach your destination. It just means you might have some choppy waters and maybe a storm to deal with before you get there.
A storm if, after December 12th, Florida's legislature has chosen electors for Bush, and the Florida Supreme Court, after a further recount, has ordered a different slate for Gore. Then the choice of which slate to accept, along with Florida's 25 electoral votes, would fall to Congress. That happened after the 1960 election.
The drop-dead date here is actually January 5th or January 6th, when Congress meets to count the electoral votes. Once they're counted, that's it.
January 5 or 6, the code says Congress shall be in session on the 6th day of January at the hour of 1 o'clock. Through this all, one date is sacrosanct. The 20th Amendment to the Constitution says that the terms of the President and Vice President shall end at noon on January 20th. We just don't know who's going to replace them yet. Judy?
In other words, Charles Bierbauer, we've got plenty of time. What's the rush here?
There's a little bit of time yet.
All right. Charles Bierbauer, thanks very much. And Bill Schneider's here in our studio in Washington with a final thought, Bill.
Well, my final thought is that we are in the middle of a nightmare scenario which no one alive has ever seen before. We could end up with two competing slates of electors. One that is chosen in a recount of the ballots as ordered by the court, if that recount takes place, and that could end up being Gore or Bush, and there could be a second slate which is certified by the Secretary of State. Both of those slates could go to Congress, which is then faced with an agonizing choice because it's a divided Congress. Judy?
All right, Bill Schneider. With those thoughts and many more to come, Bernie and I will have to bid you a farewell for now.
This is the Supreme Court ruling from Florida. Good bedtime reading. I'm Bernard Shaw, and Crossfire is coming up next. Thanks for joining us. Please do not go away. Around the world, CNN's live coverage continues.
Feel that they are vested with enough authority to run amok on their own, almost as if they thought they weren't going to be reviewed by the Supreme Court.
And wasn't the question a very simple one? Didn't the U.S. Supreme Court say, hey, Florida Supreme Court, are you using the Constitution here, or are you using the law? We just want to know which.
Right. Well, they did cite a lot of Florida law. They cited a lot of Florida Supreme Court cases. They cited some opinion from a committee of the legislature, which is the type of thing you cite when you're basing your opinion on the law. But they did not reconcile this decision with one of the two principal concerns in the Supreme Court's admonition to them earlier this week, and that was that you cannot change the rules, the times, the dates, the manner of counting, the place of counting, unless you do so more than 6 days before the election. Now, for the second time, this same court has changed all of those things and it seems to be flying in the face of that federal statute which prohibits those changes.
So in short, you can't change the rules after the game, and you can't legislate from the bench.
And you can't put your thumb in the eye of the Supreme Court of the United States when you know they're going to review what you've done.
From listening to you, it sounds like, in your mind at least, there's one court mad at another.
Yes.
All right, Judge Napolitano, we're going to come back and talk to you in just a moment about the possibilities that now exist. What could each court now do? Who could make the final decision? And really, when you boil it down to the law and the Constitution, what is the role of the Florida legislature, which seems to be acting on its own? All of that, plus a lively debate from Hannity and Combs. Why? Because we can. We learned late afternoon that the ruling would be coming from the Florida Supreme Court around 4 o'clock Eastern Time this afternoon. And then with just minutes to go, a dramatic announcement that instead it wouldn't be at 4 o'clock, but at 4:01. Did you wonder why? That may well be your reason. It was a big day on Wall Street. The NASDAQ climbing just about 6%. Wall Street closes down at 4 o'clock, as I'm sure you know, and afterwards in after-hours trading, down we go. In fact, we are definitely headed lower, said Gary Campbell, who's a chief investment officer who handles $9 billion in St. Louis, Missouri. Not that the markets don't like Al Gore, but the markets don't like uncertainty. And for the past 2 days, analysts have been saying that the reason for the stock market upturn, despite some positive economic news, had a lot to do with a decreasing amount of uncertainty in Washington. Now uncertainty abounds. They did it at 4:01 today. After-hours trading has been interesting. Monday morning could be something else. Judge Andrew Napolitano back with us again today to talk about the decisions. We had an opinion, a majority opinion, and then a dissenting opinion, Judge, from the Chief Justice.
Very significant dissent. First, people should know that it is unusual for a Chief Justice to author a dissent in a major case. The Chief Justice is sort of viewed as the personification of the court. And in a major dramatic case, the Chief Justice really traditionally doesn't dissent in the United States Supreme Court and in state Supreme Courts. Well, not only did this Chief Justice dissent, but it is a ringing, stinging dissent that does something that dissents almost never do, which is predict swift and certain reversal by the United States Supreme Court. And Shep, if you think the markets don't like uncertainty, there's one thing that they fear even more than uncertainty, and that's crisis and chaos. That's exactly what this Chief Justice predicts will occur as a result of this majority opinion.
As a result of that, would you anticipate we could get something very quickly from the highest court in the land?
I do. Whether they take the route of going to Justice Kennedy's home individually tonight, or whether they file with the entire court and ask for expedited review, which could mean as quickly as Saturday, tomorrow, I think that the United States Supreme Court will say to this Florida Supreme Court, hey guys, we gave you your chance. We told you what you did wrong. We told you what issues we wanted you to address. You didn't do it. You've caused crisis and chaos. We're going to bring finality.
And when they bring finality, what then?
It depends how they bring finality. If they reverse permanently both decisions of the Florida Supreme Court, that's the end of it. George W. Bush's electors will vote. The margin of victory will be the 537 number that we've been living with for the past couple of weeks. That's the most certain and the swiftest thing that they can do. I can't imagine them sending it back to the Florida Supreme Court. Fool me once, shame on you. Fool me twice, shame on me. The U.S. Supreme Court's not going to do that again.
Judge Andrew Napolitano, live with us in Fox Central. Judge, thank you very much. Much more to come on this special edition of the Fox Report. In just a moment, we'll check in with our correspondents who cover both this man and this. We'll talk about what their two strategies may be in full gear now. Plus, imagine what Hannity and Combs are doing now. Lo, these many weeks, Sean Hannity's been beating him like a drum. Tonight, Alan Combs with the upper hand. It could be interesting. And before we get away, some news out of baseball that I got to tell you about, so stay with us. Justice Anthony Kennedy. It is true that Judge Napolitano suggested they might be knocking on his door. And for all we know, they may be doing so now. The night is young. There are hours to go before any of the attorneys sleep. And certainly George W. Bush insists this night, as does Al Gore, that this game is not over. Hannity and Combs certainly believe it. They're here with us now as I close the computer and get it out of your way. I was talking just a minute ago about, you know, it's victory day for Alan.
Hey, look, Kennedy might as well say, look, it's a weekend. What are you bothering me with this for? It's a Friday night. Why do you want to bother me on a Friday night?
Alan's hoping for a dimple weekend again. Listen, in all seriousness, Judge Napolitano is right on the law, right on the Constitution. This decision is inconsistent with Florida law, with the U.S. Constitution, with federal law. It's by the way, everybody, let not your heart be troubled. This will not stand.
Heart is in trouble.
This will go down in history, Shep, as one of the most reckless, irresponsible judgments, one of the greatest cases of judicial activism in the history of our republic, and it will not stand. It will be overturned because on the rule of law, they are wrong. They can't change the deadlines.
You sound like Johnny Cochran saying it's a bombshell.
You know,
it's the great.
It is. This will not stay.
Hey,
that is the
Sean's having a bad day. I understand he's a little upset. I think the justices did it. You know, there are two sides to this issue, believe it or not. The justices in the Supreme Court of Florida, the four who agreed with Gore, really did a very good job documenting their case, talking about case law, talking about where the legislature itself has stepped in and said the intent of the voter is paramount. They did a wonderful job documenting all of that, doing just what the Supreme Court asked them to do, which is referring not to the Constitution, but to case law and to legislative law.
Sean, are you concerned, though, now? Are you concerned that if the Florida legislature comes up with its own set of electors,
and they have to,
and we do some recounting down in Florida, which it sounds like
what
at least...
standard, Shep?
Well, now, wait a minute.
What standard?
Wait a minute.
Yeah.
I'm just saying, what if?
What if?
What if they count again and Al Gore wins there and George W. Bush wins in the legislature? We send two people. And my mom's sitting down there in Fort Walton Beach with, you know, she's going, what about me? What about me? What about me?
This stinging rebuke by the Chief Justice of this Florida court, which, as Judge Napolitano pointed out, is almost unprecedented for him to do this.
You know, Alan, everybody on the right is going to be screaming now. Going to be screaming, these are 7 people appointed, all by Democratic governors.
Wait a second. First of all, now they're praising the Chief Justice Wells of the Florida Supreme Court, when 2 weeks ago they were throwing him down the stairs for being a liberal activist
Sure, you praise him when he's with you.
All of a sudden his integrity became 4,000% better in the last, or worse in the last 2 days?
As he said,
absurd.
this will not withstand the scrutiny. He predicted almost certainty of an immediate reversal in this decision. And one of the things that was scary about what he pointed out to here, that this would throw the country into a constitutional crisis, which are his words, not mine.
I'll tell you.
Let me finish.
Well,
here are the
constitutional
problems.
crisis is words that the
Shep,
Democrats are throwing around.
You cannot change the rules after the election has taken place. Not only did they change the rules here, they changed it once, they changed it twice, they ignored the constitutional authority granted in the U.S. Constitution to the legislature as it relates to the selection of electors and the laws surrounding it. It will not
Here's where
stand.
there's a little hypocrisy on the right, because they are saying, according to today's Palm Beach Post, they are changing the rules in order to get the electors in, to get the legislature to meet, to do some fast legislation to make sure that they can appoint their own electors. Talk about changing the rules after the barn door is closed. That's exactly what they're doing to try to get the Supreme Court.
Have to read the Constitution.
That's exactly what they're doing in the state legislature in Florida, changing the rules to get their own slate of electors in there.
The U.S. Constitution is clear. Federalist Papers are clear. U.S. Code is clear. It is the duty, and constitutional responsibility of the legislature to appoint electors in such situations
if
as we now find ourselves in.
If they were not chosen on the date given, which is election day, they were chosen on November 7th. We're doing a vote count now to find out who they were.
Let me make a prediction, Alan. There is not going to be a recount.
You're still predicting.
I am in the business of predicting.
Wow.
I've been right a lot. I've been right 95% of the time.
He might be right because the fix is in with the Florida State Legislature. Bush has the Congress on his side.
Well, you see, but with that statement, it creates the atmosphere of what the Democrats have wanted. Not only did they want to win and steal the election, they want to delegitimize the election.
And B, because Carl Cameron has breaking news. Carl.
Hey, Carl.
Hi, Shepard. Well, here's what we can tell you in terms of the actual specifics of what the Bush campaign has now done. They have, in fact, appealed to the U.S. Supreme Court. In addition, they have appealed to the 11th Circuit Court of Appeals in Atlanta, the federal appellate court. Now, you'll remember that that particular court had set aside the Bush appeal of the defeat that they had suffered in a Miami federal court, saying that at the time, the Bush campaign had not suffered, quote, irreparable harm. In seeking an emergency rehearing in the 11th Circuit Court of Appeals, the Bush campaign attorneys will argue that they are on the verge of suffering that irreparable harm if, in fact, what they consider to be unlawful recounts go forward in the Florida, based upon the Florida Supreme Court ruling. And finally, as we've been reporting since the day before yesterday, they have also sought an emergency stay, and they have submitted that to Justice Anthony Kennedy, the U.S. Supreme Court Justice who is responsible for the 11th Circuit Court of Appeals in Atlanta, which has jurisdiction over the Florida federal court district. Now, Justice Anthony Kennedy has 3 options as laid forth by the Bush campaign in their request for an emergency stay of the manual recount ordered by the Florida Supreme Court today. The first is that Justice Anthony Kennedy could act unilaterally and block the recounts immediately. The second option would be for Justice Anthony Kennedy, this is a U.S. Supreme Court, obviously, he could then confer with the rest of the justices and choose to act unilaterally or choose to recognize the conference that he would have with the rest of the U.S. Supreme Court justices, and they could issue a ruling en bloc. So it is right now in the hands of Justice Anthony Kennedy of the U.S. Supreme Court, the Bush campaign's request, which they had been predicting behind the scenes for a couple of days now, to immediately stay this decision from the Florida Supreme Court. All of this could be finalized, depending on what Justice Kennedy does, within a matter of hours. So things moving very quickly at the federal level, with the Bush campaign appealing not just to the U.S. Supreme Court, but to the appellate court, as well as to an individual justice seeking for a cease and desist order, essentially a stay on those manual recounts. Shep.
All right, Carl Cameron live with us there in Austin. Carl, thanks very much. So we already know what Justice Kennedy's dissent has been here, so certainly no question about how he might move here. Do we have Jim Engel? We do have Jim Engel with us in Tallahassee. Jim, good to see you. Thanks for sticking around. Now I guess this is, we've come 360 really in your state. We're back in Lewis's courtroom yet again.
We're back in Lewis's courtroom, and we're back right where we started, right where we already have been, Shep, and that is to begin recounts of the undervotes this time. Now, we've been looking over the undervote numbers. There are about 45,000 statewide, aside from Miami-Dade, which, of course, you know is 9,000 undervotes that have not yet been counted. It was really closer to 11, but they've already done about a fifth of those. Aside from that, you've got, at most in these counties, about 5,000 is the highest. That's in Duval County. Others are anywhere from 5 to 3 to 2, a few just, some of them a little over 1,000. So you've got what could be a manageable effort here to recount those. But, of course, you've got all these legal challenges. As Carl was saying, one of the things is that the 11th Circuit Court of Appeals already had a case before it from the Bush people that they had partially ruled on, but they have now, the Bush people have now asked for an emergency rehearing of their constitutional challenge of selective recounts. That was already before the court. They had ruled partially on something else, but it said you can come back to us on that question. They have now gone back to them to try to get a ruling on that question while they're trying to get the Supreme Court to step in and stop this. The problem, of course, is the standard. And the dissenting judges said, look, justices here in the Florida Supreme Court said, what kind of standard are you doing here? You have really not given anyone a meaningful standard. A standard just says you have to, if you can, to discern the intent of the voter is not a meaningful standard because it's too broad and there's too much discretion. And already you've seen that various people have exercised it in various ways, and that's just not a good enough standard to proceed with this recount. Shep.
Jim Engel live with us in Tallahassee, Florida. Jim, thanks very much. So where do we stand? Well, the recount set to begin, and now the appeals are underway. The challenges with the 11th District Court of Appeals by George W. Bush, a challenge with the United States Supreme Court as well, and George W. Bush asking that his lawyers go to Justice Anthony Kennedy and ask for a stay to stop the recount completely. Before the most powerful prime time in all of cable news ends this night, we may have an entirely new game. I'm Shepard Smith in New York. I hope you'll stay with us throughout the evening. We've dispatched crews across Florida to keep up with this recount throughout the weekend. And before we get away and head to the weekend on this Fox Report, this from baseball. Probably the most coveted lefty in all of baseball has just signed a $121 million contract with the Colorado Rockies. Mike Hampton is a rich man. See you tomorrow.
Your Riley Factor is on. You want to see this one. The United States of America once again thrown into chaos by the Florida Supreme Court, which has ordered hand recounts of many machine-rejected ballots throughout the entire state. We'll have reaction from both sides, and we'll tell you what is likely to happen now. Also, an exclusive interview with a woman who knows why the Florida Supreme Court ruled the way it did. Caution, you are about to enter a no-spin zone. The Factor begins in 90 seconds.